Madam Court Officer, court's audio is not audible. Madam Court Officer, court's audio is not audible.
Your Lordship, a stay order has been obtained deceptively from this court. We have filed
What to do?
we have written in our I for vacating stay as well the lies that were submitted before this
Correct.
court.
ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು. ಡಿಸೆಪ್ಷನ್ ಎಲ್ಲ ಈಗ ಯಾಕೆ?
My lords,
Your Lordship, unfairly there's a stay of.
All right, ma'am. Don't worry. Yes.
my lords,
ಕೊಡಿ.
my lords, the matter is already.
ಏನ್ GMCPC ನ? ಸೋಮವಾರ ಸರ್. ಬರ್ತೀನಿ ತಾಳಿ, ಅಲ್ಲಿ ಬರ್ತಾ ಇದ್ದೀನಿ ತಾಳಿ. ಹಾ. Why have you filed IA? Court should file. This practice is wrong anyway, give it, we'll see. $230? Bharat. Huh? Huh? ಪರವಾಗಿಲ್ಲ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ, ಏನ್ ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ, ಮಂಡೇನೆ. Disposed? Huh. What? Yeah. Huh. What do you call? Huh? Kannada Sahitya Parishatta? Kudi. Matteya, I will not take the memo. You are not in a restaurant. You are in a court of law. Give it. Yes. No problem. Monday. ನಿಮ್ಮ ಮುಂದೆ ಒಬ್ರು ಇದಾರಲ್ಲ, ಅವ್ರು ಬೇಡವಾ ತಗೊಳ್ಳೋದು? ಕೊಡಿ ಸರ್, FDP ತಾನೆ. miscellaneous ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್, ತೊಂದರೆನೇ ಇಲ್ಲ, ಕೊಡಿ ಸರ್, ಅದ್ರಲ್ಲೇನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಕೊಡಿ. ಹಾ, ಹೇಳ್ಬಿಡಿ. ಆಲ್ರೆಡಿ ಡಿಸ್ಪರ್ಸ್ಡಾ? ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. ಹಾ, ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಕೊಟ್ಟಾಗ ಹೋಗಿದ್ಯಲ್ಲ ಆಗ್ಲೇ, ಅದಕ್ಕೆ ಯಾರಿಗೋ ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಈಗ, ವಾಪಸ್ ರೀಫಂಡ್ ಮಾಡಕ್ ಹೇಳ ಮತ್ತೆ? ಹಾ ಸರಿ, ಎಸ್ 230. ವೆಕೇಟಿಂಗ್ ಕೊಟ್ಬಿಡಿ ಸರ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಯಾವ್ಯಾವ ಎಲ್ಲ ಕೊಡಿ. Vacating and tax matters give.
Your Lordship, the vacating stay is not getting listed. If you may please give it.
Vacating stay ಅಲ್ವಾ? ಕೊಡಿ ಮೇಡಮ್.
If a date may be fixed.
Next Wednesday.
My lords.
Next Wednesday.
Give all vacating stay applications.
My lords.
ಒಂದು ನಿಮಿಷ, ಬೇರೆ ಏನಾರು ಇದ್ರೆ ಅಲ್ಲಿ ಹಿಯರ್. ಹಾ, 12 ಕೊಟ್ರೆ ಆರ್ಡರ್ ಆಗಿದೆ, ಏನ್ ಅದಕ್ಕೆ ಬಂದಿರೋದು ನೀವು ಇಲ್ಲಿ? ಏನ್ ಹೇಳಿ, ಯಾಕೆ ಅರ್ಜೆಂಟು? Tuesday, next Tuesday.
Your Lordship, it's a fresh CRP fresh matter, Your Lordship. In the cross examination, PW1 had admitted that there is no.
CRP?
Yes, Your Lordship.
711.
Illa, the case is disposed, Your Lordship. In the PW1 has admitted there's no dues, but the.
Oh, this landlord tenant.
No, Your Lordship. Recovery suit, small causes case.
ಅದಕ್ಕೆ ಕೊಡಿ.
One date may be fixed.
Pending matter.
Illa, fresh matter, Your Lordship.
ಕೊಡಿ, Monday or Tuesday ಬರುತ್ತೆ. Give it, sir. ಹಾ? ಓಯ್, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. Yes. No hurry, ಪರವಾಗಿಲ್ಲ. Give it, sir. We'll see.
The respondents are without paying the compensation for the sandalwood trees. They are trying to cut the trees, my lord. Today, my lord.
230.
230.
My lord,
Fresh ತಾನೆ?
Fresh matter, my lord. It's in the FIR.
Give it. No problem. Give it.
my lord, GM-CPC matter, my lord. The money recovery suit before the trial court was disposed because there was an arbitration clause. Arbitration clause is not valid, my lord.
Why?
My lord,
Why?
my lord, it is against the scheme of the act, my lord.
What act?
Arbitration act, my lord.
Why?
My lord,
We'll see. ಈಗಲೇ ಬೇಡ, ಕೊಡಿ.
it's a pending matter, my lord. On
Pending
Wednesday, my
matter?
lord. Yes, a notice is issued to respondent.
Give it.
They have not filed. Wednesday.
Huh?
Land acquisition matter, my lord. Alleged notification is in the year 1940. Now, my
Same
lord.
order, ಕೊಡಿ.
Your matter.
230 ತಗೊಳ್ಳಿ.
CRP fresh matter, my lord.
Give it, sir.
Rejection of implementing
ಕೊಡಿ ಎಲ್ಲ. Fresh matters ಎಲ್ಲ ಕೊಡಿ.
rejection of implementing application.
No problem.
ನಾಳೆನೇ settlement
ಓ,
ಮಾಡ್ಕೊಂತಾರೆ.
ಸೆಟ್ಲ್ಮೆಂಟ್?
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗಳು ಅಂದ್ರೆ
ಹೆಂಗ್ ಗೊತ್ತು ನಿಮ್ಗೆ?
ಇದು ಮೊನ್ನೆ ಫೈಲಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟು ನಾನು ಅದು FR ನಂಬರ್ ಕೊಟ್ಬಿಟ್ಟು ನಾನು ಡೇಟ್ ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು ನಾಳೆನೇ ಲಾಸ್ಟ್ ಡೇಟ್ ಕೊಡಿ.
230.
Lordships can leave.
ಇಲ್ಲಿ FR number ಇದ್ರೆ ಬರಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ WP ಆಗಿದೆ ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿ.
Lordships can leave. In a super specific formats, cross-examination application was rejected. Now they have posted for judgment. We call tomorrow.
Monday.
Idiom item, my lord. The applicant has been non-consideration of the application.
Sorry?
Non-aggrieved application.
Non-aggrieved application.
Non-consideration of the application. my lord. By this honorable court, they have not agreed.
Give it, sir.
Kindly have it on-
No, give it, yes.
Fresh matter.
I don't know how to tell what are the facts, what to do. Give it.
Fresh matter in CPC matter.
Ah.
Which the application for deleting one of the defendants has rejected.
Ah.
Now there is no substance cause of action against the defendant. That is the reason I am.
ಅವೆಲ್ಲ ಕೊಡಿ ಸರ್. ಕೊಡಿ.
Monday, your
It
lordship.
will come, give it.
Monday, your lord- at least Monday, your lordship.
It will come, sir. Other day, next day ಬರಲೇ ಇಲ್ಲ, ನೆನ್ನೆ ಬರಲೇ ಇಲ್ಲ ನೀವು. ಕೊಡಿ. 2:30.
The trial court is proceeding with the day-to-day
Let it, good sir, it is proceeding.
My lords, my 16 rule 6 application has been rejected and the
ಅದು
matter is posted for
ಹಾಕದೆ
argument
ಕೊನೆಯಲ್ಲಿ. ಕೊಡಿ.
for tomorrow, your lordship.
No, tomorrow, Monday. Give it, sir.
On the strength of impugned order, my lord, the respondent going to release the amount, my lord, and watch.
Compensation na. Which impugned order?
My lord, order 22 rule.
Friday
for
ಆಗ್ಬೋದಲ್ಲ?
application.
My lords.
Friday.
Pending ಆದ್ರೆ ಬರಲ್ಲ? Pending matter.
Pending, yes, on consideration of interim trial.
My lords.
As per order of this court, my lord, and summons are served on the respondents.
Fresh matter, my lord. GFCPC complaint ಮಾಡಿದ್ದಾರೆ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್.
ಕೊಡಿ ಸರ್.
My lord.
My lords.
Fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lords, the matter is already settled by Supreme Court of
Supreme
India.
Court ಅಲ್ಲ?
Yes, my
ಏನ್
lords.
ಬೇಕೀಗ?
The petitioners have taken the same set of facts and by misleading this court, they have taken a status quo order. Kindly post the matter, my lords.
Tuesday, ಅದು Tuesday ಹಾಕಿ ಮೇಡಮ್. ಅದೇ Supreme Court that's Tuesday.
My lords, vacating stay, my lords.
CPC fresh matter, my lords. Trial court without waiting for the FSL report, they have posted the matter for judgment, my lords.
When they have posted madam?
6th of this month, my
ಅಲ್ಲ
lords.
ಯಾವತ್ತಿಗೆ?
12th, my lords. By end of the list, I'm praying.
ಕೊಡಿ 2:30.
My lord,
Your lordship,
vacating.
your lordship,
ಯಾವ್ದು ಮತ್ತೆ?
Again, they went to Supreme Court and Supreme Court also rejected their plea.
ಯಾವ್ದು 187 ದ?
One.
ಏನಾಗಿದೆ ಈಗ?
Supreme Court has directed for.
ಯಾವ್ದು ಕೊಡಿ.
My lords.
Friday sir.
My lords, tomorrow it is there, my lord, the trial court.
So what? ಏನ್ ನಾಳೆ ಮುಗಿಸ್ಬಿಡ್ತಾರ?
your lordship.
ಕೊಡಿ.
My
Your lordship.
vacating stay, my lords.
ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ. ವೈ ಆರ್ ಇನ್ ಹರಿ?
At least I request.
ಕೊಡಿ. No, ಕೊಡಿ. Yes. Little vacating stay ಹಾಕಿದ್ದೀರಾ? ಹಾ ಬರುತ್ತೆ. Very good sir, give it, ಕೊಡಿ. Pending matter ಅಲ್ವಾ ಅದು? Yes.
My lord.
Give it sir. ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಕೊಡಿ. ಡೇಟ್ ಕೊಡಲ್ಲ. No, don't ask for date. Yes. Concurrent finding. Concurrent. Rejected to affirmed. Kodi no. We'll see. Give it. Yes.
At least.
Give it, madam. Kodi. Yes. No, madam. Give it. Monday ಬರುತ್ತೆ.
Tomorrow, my lord, because that matter in the trial.
Tomorrow ಆಗಲ್ಲ. Friday ಬರುತ್ತೆ ಕೊಡಿ.
My lords, the matter pertains to preservation of Gomar lands, my lords, in a representative suit. My lords, my IA, my lords, for the end of the list.
Yes, 2:30. Give it.
Your lordship, fresh matter TIT, asking for order of interim stay, requested to be listed tomorrow.
Give it. Yes.
My lords, this is KITB allotment disseminate, my lords. This is a pending matter, my lords. It was. heard,
Memo
my
ಕೊಡೋದು
lords.
ಕೊಡಿ madam. Pending matter.
Date is given on 23rd. my
If it is
lords.
given, it will come.
No, my lords, they are allotting to different people, my lords, now.
Let it come on
The matter-
Tuesday then, 16th. Yes.
Please.
My lord, vacating stay. My lord,
Vacating stay ಕೊಟ್ಬಿಡಿ applications ಇದೆ.
lords,
Give
the trial court has rejected,
You would-
suppressing the, that
ಅದ್ಯಾಕೆ
day,
vacating stay ತಗೊಂತಾ ಇಲ್ವಾ?
lords, it was listed on Thursday.
Can't help, sir.
ಅವ್ರು
Give it,
ಹುಷಾರಿಲ್ಲ
yes.
ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಡೇಟ್
ಏನು
ತಗೊಂಡಿದ್ದಾರೆ
ಮಾಡಕ್ಕಾಗಲ್ಲ,
ಮಂಡೆಗೆ.
ಕೊಡಿ.
ಮಂಡೇ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿರೋದು.
Monday vacating stay ಲಿಸ್ಟೇ ಆಗಲ್ಲ.
Sorry, Thursday it was listed.
Thursdayನೂ ಲಿಸ್ಟ್ ಆಗಲ್ಲ.
Lords, they are by
GMCPC ನ?
suppressing illegally.
GMCPC ನ?
Lords, they have taken.
GMCPC ನ?
CPC, lords.
ಕೇಳಿಗೆ ಉತ್ತರ ಕೊಡೋದೇ ಇಲ್ವಲ್ಲ?
CPC, lords. By
ಕೊಡಿ,
suppressing.
Wednesday ಬರುತ್ತೆ ಕೊಡಿ, next Wednesday.
ಆರ್ಡರ್ ಆಗೋಕ್ ಮುಂಚೆ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ಅದನ್ನ ಸಪ್ರೆಸ್ ಮಾಡೋ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ. Any date, lords. I live.
Seriously don't understand when I'm saying Wednesday,
Wednesday.
we're going on making submission.
I'm obliged.
Why ಬೆಳಿಗ್ಗೆ ಯಾಕೆ ತೊಂದ್ರೆ ಕೊಡ್ತೀರಾ ಹಿಂಗೆ? ನಾನು ಮೆಮೊ ತಗೊಳಲ್ಲ ಅಂತ ಹೇಳಿದ್ನ?
ಇಲ್ಲ, we have been.
ಮತ್ತೇನಿದು?
Publish.
Yes, Kodi.
My lords, BD is trying to demolish the building, my lords. I have applied for
230.
regularization, my lords.
230.
Much applied. And applied for construction of toll plaza. Interim prayer is not yet considered. Date is given on
1 and 2. Aayt Kodi.
Request for initial.
Atrocity 482 to 24 matter, your lordship has stayed for admission.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ.
ವಜಾ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ,
ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಡಿಸ್ಪೋಸಲ್ ಆಯ್ತು ವಿಲ್ಸ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
My lords, land acquisition matter, my lords.
ಏನ್ ಬೇಡ ಮೆಮೊ ಕ್ಲೈಂಟಿಗೆ ಹೇಳಿ ಬಂದಿದ್ದೀರಾ ಕೊಟ್ಟೆ ಬರ್ತೀನಿ ಅಂತ ಮತ್ತೆ ಬಿಡಿ. Yes.
Your lordships have already heard this in part CRP. Direction was given for listing after 6 weeks. The matter is not listed.
I will see. Give the memo.
I have grave threat of disposition.
Grave threat. 230. 230.
Council notice is served, lords. Council notice served, lords.
Parala kodi.
My lords, land acquisition
For any
matter,
date,
my lords.
No, give it.
CRP.
Matter is posted for orders, lords, by 20th, lords.
ಏನ್ ಮ್ಯಾಟರ್ ಸರ್?
Recalling the PW1.
ಅಷ್ಟೇ ತಾನೆ ಕೊಡಿ. ಎಸ್ ಎಲ್ಲ ಹಾಕಿರೋದು ಫ್ಯಾಗ್ ಎಂಡ್ ಅಲ್ಲಿ ಕೊಡಿ.
CRP.
ಇಲ್ಲ ಸ್ಟೇ ಅವತ್ತೇ ಕೊಡ್ತಾ ಇದ್ದೆ ನಾನು.
Date ಕೊಟ್ಟಿದ್ರಿ, date
ಎಲ್ಲ ಸ್ಟೇ ಕೊಡೋ ಕೇಸ್ ಇದ್ರೆ ಅವತ್ತೇ ಕೊಡ್ತಾ ಇದ್ದೆ. If I have not granted stay, it is not a case for stay. It has to be heard. ಅಷ್ಟೇ. Yes.
CRP 224 matter, fresh matter. 2-3 ಸರಿ ಮೂವ್ ಮಾಡಿದೀನಿ ಬಂದಿಲ್ಲ.
Please sir.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಹೋಗಿದೆ ಸರ್.
ಏನ್ ಆ ಟೈಮಲ್ಲಿ CRP ಅಂದ್ರೆ ಅದು ಬರೋದೇ ಇಲ್ಲ ಕೊಡಿ.
ಲಿಮಿಟೇಷನ್ ಕ್ವಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀವಿ ಅದರಿಂದ
Land acquisition matter, notification of 2013, notification.
Give it, sir.
I've complied with the office objections.
Give it, it will come.
GMCPC, both court denied to grant the interim order.
I will also do the same thing. Kodi.
No, blood. Good case, sir.
Kodi.
Please.
One matter from 230.
They are likely to delete my defense, my lord, day after today.
Oh, very good, sir. Give it. Yes.
One submission. Matter is on Friday, my lord. Order 7, rule 11 is rejected. It is posted for evidence on Friday.
Evidence stage alla 711 ಗೆ.
No, my lord, cause of action is 2002, 2011. Declaratory suit.
ಆಯ್ತು. ಇನ್ನೊಬ್ರು ಯಾರು ಹೇಳಿದ್ರಲ್ಲ 711 ಯಾರ್ದು? ಎಸ್ ತಗೊಳ್ಳಿ.
One submission. Yesterday list serial number 142. ಅದು ಜನರಲ್ ಅವಾರ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು the petitioner have mentioned. It is not the general award matter.
ಯಾರಿಗೂ ಅವ್ರು ಹೇಳಿದ್ರು ಕ್ಲೋಸ್
142. I am for the respondent. It is Muda matter. It is not the general award matter.
ಆಯ್ತು ಸರಿ ನೋಡಿ.
142.
either will post it back. Don't worry.
Please, any date.
Let's call the case. Yes. Speedy memo.
3 memos.
Take it back. We'll take the earlier 2 memos. Take this back. Speed ಆಗಿ ತಗೊಂಬಿಡಿ ವಾಪಸ್. Yes.
Being spoken to still number 1.
No, GMCPC matter was listed on the 22nd. Your lordship had passed an interim order staying the 2 impugned orders passed by the trial court. That portion has not been reflected in the order sheet.
Further proceedings are stayed ಆಗ್ಬೇಕಷ್ಟೇ.
Allah, we have not sought the stay of the further proceedings. I have challenged 2 orders passed by the trial court. The lordship had stayed the operation and implementation of
it
those
is made clear
orders.
This court on 22/8/2025 had passed the following order. The learned counsel for the petitioner has moved a memo of being spoken to on the score that the order that was the inadvertent omission in the order with regard to the stay of the impugned orders and further proceedings before the concerned court being not stayed. The error is to be corrected. The order would read thus. In that light, the orders impugned shall remain stayed, and it is made clear further proceedings before the concerned court are not stayed.
One last submission, what order was dismissed, what application was dismissed for non-prosecution was an order under Rule 1, Order 1, Rule 10 instead of Order 6, Rule 17, my lords.
Adon correct ಮಾಡ್ಬಿಡಿ.
And recall of which was made after 1 year, not 2 years.
Yes. All right.
Heading on IS number 2.
ನೀವು ಹೇಳ್ಬೇಕಾರೆ ಯಾಕೆ ಹೇಳಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ?
ಸ್ವಾಮಿ
ಹೇಳ್ಬೇಕಾರೆ ಯಾಕೆ ಹೇಳಲ್ಲ? 230 ಮೂವ್ ಮಾಡಿದ್ದಾ?
ಇಲ್ಲ.
Yes.
Respondent.
Number 2. Lordship permission.
R1 counsel ಇಲ್ವಲ್ಲ? ಹೇಳಿ ಬಸವ.
Your lordship permission.
2.1 is the important to your lordship. WP number 3827 of 2021, your lordship, is very important. The property which has been granted in the name of the petitioner, Ashraya and Indira Awaje.
Why LB is connected?
They filed a LB petition challenging the entry cancellation of Kata in their favor. They had filed a suit. My lord, suit was dismissed on the ground that there was no grant in their favor. The land belongs to the state, and the panchayati says there is no grant. Challenging that, they filed a RA. My lord, RA, they say, my lord, they filed this petition containing that until disposal of this LB petition, RA should not go forward. From March 22, RA is pending, my lord, for all.
The first one, your lordship, the only is a concern.
Idರಲ್ಲಿ first all stay ilva?
First all stay ಇದೆ. But the only thing your lordship,
RA
upon consideration of this LB matter.
ಹೇಳಿ sir, on merits ಏನು ಹೇಳಿ?
Your lordship permission.
There is vacating stay here, ಹೇಳಿ.
ಹೌದು. Your lordship, I have produced all the documents. Your lordship.
What is this suit for?
Suit. This is LB matter.
Suit is for injunction.
Sir,
not
for
for
suit,
second one important, your lordship.
Important. First one ಹೇಳಿ ಈಗ. ಅಗರ್ first one dismiss ಮಾಡೋಣ, second one ಕೇಳ್ತೀನಿ.
ಅದ ಎರಡು ಒಂದೇ ಆಗುತ್ತದೆ.
ಅದಕ್ಕೆ first ಹೇಳಿ. Yes, CPC suit ಏನು ಹೇಳಿ?
Suit for injunction.
Suit for injunction file ಮಾಡಿದ್ರು sir. On the basis of the order passed by the Jilla Panchayati Lordship. Upon consideration of that,
what is the order, sir? First suit for ಏನು ಹೇಳಿ? Injunction.
ಹೌದು.
Trial court ಅಲ್ಲಿ ಏನಾಯ್ತು?
Trial court has been dismissed, your lordship. Upon consideration of the Jilla Panchayati order.
ಸರಿ, appeal ಏನಾಯ್ತು?
Appeal is pending consideration before that.
Why you have
stay? That's the reason why I filed a writ petition before this one for staying.
No, there is awaiting the judgment in WP 3827. Why 3827?
That's the reason why I was submitted before this one.
Tell me, sir.
I have this in this case, your lordship. LB matter. I have challenged the local bodies of order in appeal number 59 of 2010 and 11. Annex H1, your lordship. Without being considering all the documentary evidences which I have produced before the Gram Panchayat is also accepted. Taluk Panchayat is also accepted. Without being all this considered, your lordship, the Jilla Panchayati has been dismissed. Allow the appeal filed with the respondent number 4, your lordship. Without being issuing any documents, without being issuing any notice.
What is the complaint?
My lord, may see page 67 of the suit, my lord, where the trial court after trial. Last
OS 192 of 2010
filed by him.
ಆಯ್ತು, ಏನಾಯ್ತು?
Last two lines, my lord. In view of the above discussed oral and documentary evidence, it appears clear that the suit property claimed by the plaintiff is part and parcel of the land property granted to the father of different number, that is site number 4 and so. There is no basis for the kata entered in the name of the plaintiff in respect of a suit property as per exhibit P7 to P9, as there is no such resolution passed by the Amurur Panchayat accepting such kata in favor of the plaintiff. Thus, on the basis of such illegal kata, the plaintiff cannot derive any right, title or possession. Apart from the said documentary evidence, there is no other materials to show that she is in possession of the suit property either lawfully or unlawful. Therefore, it can be concluded that the plaintiff has failed to prove that she is in possession and the suit is finally dismissed. Challenging this finding, Lord, they have filed an RA. Until they get all this settled in an RA, how can the revenue interest be changed?
ಈಗ ಫಸ್ಟ್ ಆಮೇಲೆ LB ಪಾಸ್ ಮಾಡಿರೋ ಆರ್ಡರ್, ದಟ್ ಪಿಟಿಷನ್ ಪಾಸ್ ಮಾಡಿರೋ ಯಾವತ್ತಿಂದು?
Lord, that in LB court, my lord, what they have said is
Annex H1, you will also page number 50.
That is dated 2/2/19, my lord.
What is that order?
Where, my lord, the kata made in, my lord, may kindly come to operating portion kinta. I don't have the page number, my lord, I'm sorry.
Page number 52.
52 operating portion kinta ಮೇಲ್ಗಡೆ.
Your lordship kindly be
11th line, my lord, ಮೇಲಿಂದ 5ನೇ ಲೈನ್.
ಅಪೀಲು ಸಂಖ್ಯೆ ಅಧ್ಯಕ್ಷರು ತಾಲೂಕು ಸೋನ್ಸ್ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿ ಎದುರುದಾರರು ಖಾತಾ ಮಾಡಿರುವುದನ್ನು ರದ್ದುಪಡಿಸಿ ನಿಮ್ದಾದು?
Your lordship,
all this you decide in the RA, this will remain subject to the result of the RA. ಅಷ್ಟೇ.
Your lordship permission, your lordship.
ಅಷ್ಟೇ.
Annex A,
the order that is passed that you have challenged in LB will remain subject to the result of the appeal that you have filed before the court.
That's the reason why they are waiting for the decision of the
LB ಅಷ್ಟೇ, LB decision ಇದೇನೆ.
ಅಲ್ಲ, correct one. The only your lordship. Annex A, you will kindly see.
Yes.
They were granted
anything else? ಎಲ್ಲ ಸೂಟ್ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಳ್ಳಿ. The petitioner is before this court calling in question an order of the, first CPC de togoli, an order of the concerned first appellate court. An order challenge
ಏನು
ಮಾಡಿಲ್ಲ?
ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Because of the reason, there is no order in the
Very good.
REI, your lordship.
Excellent. Yes. The petitioner is the plaintiff in OS 192 of 2010. Calls in, suffers an order and challenges it before the first appellate court in RA 59 of 2011. During the subsistence of the suit, it transpires that certain, subsistence of the appeal, it transpires that certain orders are passed by the municipal authorities, which is called in question, municipal authorities. The learned counsel, the plaintiff then prefers an appeal, as observed, prefers an appeal before the first appellate court and simultaneously files and later files a writ petition in WP 12675 of 2023 seeking stay of all further action till this court would decide writ petition 3827 of 2021.
Yes.
Yavyadu? 3827 of 2021, the petition which seeks complete stay of the regular appeal proceedings. Further proceedings. Complete further proceedings before the regular appeal. Therefore, the petitioner seeks two orders at the hands of this court, which are on the face of it untenable. As the petitioner, having suffered an order at the hands of the first trial court, has preferred an appeal before the first appellate court. Could the subsequent petition
The earlier,
terming it,
earlier petition.
yaudalla sir, the subsequent petition terming it to be, LB first, the subsequent petition, i.e. GM CPC, seeking stay of all further proceedings in RA in the light of the fact that the proceedings in WP 3827 is pending is unwarranted. The petitioner, as observed, suffers an order at the hands of the civil court in which the observation is as follows, page 67 marked portion, against which the petitioner has preferred an appeal. In the appeal, the entire the issues are at large. In the light of the subsistence of the appeal, in the light of the subsistence of the appeal, sorry, in the light of the appeal pending adjudication before the first appellate court, all the contentions that the petitioner has now urged in the petition shall await a decision at the hands of the shall await a decision in appeal so and so. The prayer of the petitioner is also the same, that the appeal proceeding should be stayed till the proceedings in 3827 of 2020 would conclude. In that light, reserving liberty. 2021 ಅದು 20 ಅಂತಿದೆ ಇಲ್ಲಿ 3827 of 2020.
Yes, 21 correct. Prayer ತಪ್ಪ.
ಮತ್ತೇನಿದು?
Prayer ತಪ್ಪ.
Prayer ಅಲ್ಲ, petition.
21.
ನಮ್ಮ ನೋಟಿಸ್ 21 ಅಂತಾನೆ ಬಂದಿರೋದು.
4th August 2020 21 ಆಗೋಗುತ್ತಾ?
3827 of 2021.
ಸರಿ ಸರಿ ಆಯ್ತು. 21
ಮೋಸ್ಟ್ಲಿ FR ನಂಬರ್ ಆಗಿ ಆಮೇಲೆ
ಸೊಳ್ಳೆ ಸರ್. ನೀವು ಹಾಕಿರೋ ಪೆಟಿಷನ್ಸ್ ಅದೇ
Correct.
20 ಅಂತಿದೆ ಸರ್.
20 ಅಂತಿದೆ.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದು?
ಲಿಸ್ಟಲ್ಲಿ 21 ಅಂತ.
21 ಇದೆ. ಲಿಸ್ಟಲ್ಲಿ 21 ಇದೆ. ಬಟ್ ಇದರಲ್ಲಿ ಕರೆಕ್ಟ್.
ಅದು ಏನೋ ಒಂದು ಫೈಲ್
2020 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದು. But it has subsequently it has been listed and 28, 38, 27 ಆಗಿ.
Yes. Therefore, the petitioner shall, the proceedings in 3827 of 2020 or any order that is passed shall await the decision of the first appellate court in RA so and so. The aforesaid observation, the petition stands disposed.
March 22, my lord, the matter is pending, my lords may fix.
The concerned for the first appellate court shall in the light of the pendency of the appeal before the first appellate court for the last 3 years, for the last 3 years, I deem it appropriate to infuse finality into the proceedings. The direction to the concerned court to dispose the appeal with an outer limit of 6 months.
Not binding on the Jilla Panchayati respondent order.
ಅದೆಲ್ಲ ಅಲ್ಲೇ ಆಮೇಲೆ ನೋಡ.
Well, because of this reason, that's the reason why the original suit has been dismissed on the basis of the Jilla Panchayati order.
Obliged.
That's it.
Yes.
Number 3.
For the issue, my lord, this annexure he is the order passed.
Suit for
the execution petition has been filed.
Order, when order?
The order has been, the arrest warrant has been issued and he has been arrested.
For what?
For the payment of the maintenance amount, my lord. Which
Husband,
has been compromised,
husband,
which has been husband. which has
ಎಷ್ಟಿದೆ?
been- ಅದು 3 lakhs ಅಗ್ರಿ ಆಗಿ ನಾವು ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ ಎಲ್ಲ ಅಮೌಂಟ್. ಕೊಟ್ಟಿದ್ದಾದ್ಮೇಲೂ ಇಟ್ ವಾಸ್ ಡಿಸೈಡೆಡ್ ಬಿಫೋರ್ ದಿ PLC ಪ್ರೀ ಲಿಟಿಗೇಷನ್ ಕೌನ್ಸಿಲ್ ವೇರ್ ಇನ್ 3 lakhs have been given, affidavit has been filed, my lord.
Where is that? Page.
Where is that, my lord? Your lordship kindly see the annexure E, arrest warrant has been issued.
Page ಎಲ್ಲಿ 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದು ರೆಕಾರ್ಡ್ ಮಾಡಿರೋದೆಲ್ಲ.
That is the case, my lord.
That is the case ಅಂದ್ರೆ?
I may be permitted to submit
Really?
regard to these aspects. 3 lakhs have been agreed to compromise before the PLC. My lord.
Where is that?
That is, my lord. Your lordship, you kindly see the execution petition wherein which has been arisen. Lordship kindly
ಅದು
see the annexure C.
compromise page ಇಲ್ವಾ?
Compromise page illa. ಅದಕ್ಕೆ that why annexure C, I filed an application before the PLC to give entire document to show that. Your lordship, annexure C, my lord.
Page
19, my lord. ವಿಷಯ ಜನವರಿ 2000 ಕೊಟ್ಟಿದ್ದ ಶ್ರೀಮತಿಯವರ ಅರ್ಜಿ ಬಗ್ಗೆ PLC 6/2014 ದಿನಾಂಕ 26/2/2014 ತೀರ್ಮಾನವಾದ ಕೇಸಿನ ಬಾಬ್ತು ಅಂದರೆ ಮೇಲ್ಕಂಡ ಕೇಸಿನ ಪೂರ್ತಿ ನಕಲಿ ಪ್ರತಿಯನ್ನು ನೀಡಬೇಕಾಗಿ ವಿನಂತಿ ಹಾಗೂ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ದಿನಾಂಕ ಆಗಸ್ಟ್ 2014 ದಿನಾಂಕ 11/12 ಹಾಕಿರುವ ಪ್ರಮಾಣ ಪತ್ರಿಕೆ ಪ್ರತಿಯನ್ನು ಕೊಡಿಸಬೇಕಾಗಿ ಪೂರ್ವ ಕಡೆ ಪ್ರಾರ್ಥನೆ. ಫಾರ್ ದಿಸ್, ಮೈ ಲಾರ್ಡ್, they have given the annexure D, my lord, the endorsement ದೃಢೀಕರಣ ಪತ್ರ by the authority, my lord.
ಏನಂತ?
20, my lord. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಉಲ್ಲೇಖ
ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಬೇಕೆಂದು ಮನವಿ ಸಲ್ಲಿಸಿರೋ ಸರಿ, ಆದರೆ ಸರಿ ಉಲ್ಲೇಖ ಅರ್ಜಿಯಲ್ಲಿ ಕೇಳಿದ ದಾಖಲೆಗಳು ಕಚೇರಿಯಲ್ಲಿ ಇಲ್ಲ, ಲಭ್ಯವಿರುವುದಿಲ್ಲ.
That is, my lord. The entire execution petition arising on PLC 6/2014, my lord. That is not on the judgment of the trial court, my lord. It is on the PLC. The execution petition is also based on the compromise petition which has been made out in the PLC.
ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದ that document is very much necessary
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ
to make an inquiry with regard to that and pass an order, my lord.
He has not paid single rupees. She is 60 years old.
ಕಾಂಪ್ರಮೈಸ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ಬೇಕು. ಇಲ್ಲ ಅವ್ರು
ಅಲ್ಲ execution ಅವ್ರು
ನಿಮ್ಮ ಹತ್ರನೇ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್. Kindly see page 6. He has taken 2 difference. His ground cells of me. Kindly see page 6, my lord. Page 6. The said amount 3 lakhs have been paid through cash at the instance of honorable authority. After that, the trial court has passed the matter for inquiry and the matter was adjourned to several days and last without making any inquiry in the execution authority ಅಂತ ಹೇಳ್ತಾರೆ. The objection ಅಲ್ಲಿ ಅವ್ರ sister
ಆಯ್ತು, ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ we will wash, send it back to the executing court, let it decide.
And let inquiry may be done, my lord.
He has not paid, my lord, amount paid ಮಾಡಿದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್
ನೀವಾರು ಕೊಡಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಅಲ್ಲ ನಮ್ಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವ್ರ ಅಮೌಂಟ್.
ಅಲ್ಲಪ್ಪ, ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಇಬ್ರು ಮುಖ ನೋಡಿದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿ ಅಂತ ಅದ್ರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹೋಗಿದ್ದೀರಾ? ಏನ್
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ yes taken.
Grounds is important or where is the compromised documents? How have you filed? What are you trying to execute? Tell me. ಏನಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದೀರಾ?
For recovery of amount.
Where is the order of payment ಎಲ್ಲಿದೆ? Have you filed execution in thin air or there is some document? Which is the executable order? Tell me. ಎಲ್ಲಿದೆ? ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ಲ. ಇಬ್ರು ಗಾಳಿಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಆಗಿತ್ತು, 3 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ. What are you executing, sir? ಇದನ್ನು ಸ್ಟೇ ಇದೆಯಾ ಅದರಲ್ಲಿ?
ಅಷ್ಟೇ.
ಸರಿಯಾಗಿ. The petitioner is before this court. Calling in question an order dated 19/1/2023, passed in execution petition 83 of 2018, by which a warrant of arrest is issued against the petitioner for non-compliance of a particular order passed on 16/4/2018.
He also admitted that 3 lakhs ಕೊಡ್ಬೇಕಂತ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅವ್ರು ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿರೋದು ಯಾರು?
ನಾವು ಹಾಕಿರೋದು ಸ್ವಾಮಿ.
ಯಾವ್ದ್ರ ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ ಸರ್? ವಾಪಸ್ ಅಲ್ಲಿಗೆ ಬರ್ತಾ ಇದೀವಿ. ಯಾವ್ದ್ರ ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ ಸರ್?
PL OS number PL.
Is it not basic law that there should be an executable order, not heir? Yes. The petitioner heard so and so. The petitioner is the husband,
Husband.
The petitioner is the husband, the respondent wife. The two have a settlement in pre-litigation case 6 of 2014 before the legal service authority and the legal service authority. It is alleged by the respondent wife that the petitioner did not pay a rupee even pursuant to the settlement so arrived at in PLC 6 of 2014 before the legal service authority, and initiates and institutes execution proceedings. The execution proceedings progressed. In the interregnum, the petitioner is said to have filed an application before the concerned court/authority where PLC 6 of 2014 had taken place, seeking furnishing of complete documents of the said PLC. The application reads as follows, page 19. It is replied to by the Taluk Legal Service Committee before whom PLC 6/2014 is said to have taken place in the following manner. The concerned authorities would reply that there are no documents found with regard to PLC 6 of 2014. Therefore, the petitioner contends that the concerned court ought to have conducted an inquiry prior to the issuance of an arrest warrant at the say of the respondent. The learned counsel appearing for the respondent submits that the petitioner has in his pleading itself admitted that he had to pay 3 lakhs and 3 lakhs was agreed to in the PLC proceedings, which the learned counsel for the petitioner disputes. In that light, without holding any inquiry with regard to whether there was a settlement at all and the documents of settlement could be procured or otherwise, as obtaining in PLC 6 of 2014, the concerned court could not have issued an arrest warrant against the petitioner. In that light, the petition deserves to succeed with a order. Deserves to succeed.
19/1/2020.
And the order dated 19/1/2023, which issues an arrest warrant, to be obliterated. The matter would be remitted back to the hands of the concerned court to hold an inquiry and then proceed with the execution petition 83 of 2018 in accordance with law. For the aforesaid reasons, the following order allowed, quashed. The matter is remitted, allowed in part, quashed. The matter is remitted back to the hands of the concerned court to hold an inquiry with regard to the issue placed before it, as it is completely shrouded with
Expediently, maybe direct for
so and so. In the light of the execution proceedings of the year 2018, the concerned court shall now expedite the proceedings and conclude the same with an outer limit of 6 months, 3 months from today, if not earlier. Yes, next.
And also further order in detained in the civil prison antano ide.
All consequential. The order dated 19/1/2023 and all consequential actions taken pursuant to the said order stand quashed. Yes, next.
Petitioner Manoj, I'm praying
NOC.
short accommodation to file objections to the IA Manoj. In fact, it was ready, but the authorized signatory is not available.
In convention center.
Manoj, this is arising from an order in a suit for ejectment filed by the respondent, who's the plaintiff. I'm the defendant.
Interim
in
order
the
ಇದೆಯಾ?
matter.
Vacating stay ಹಾಕಿದಾರಾ?
There's an interim order in my favor.
ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ.
Vacating stay na.
We have filed this application.
Manoj, I'm seeking time to file
One
objections.
moment, let me know what it is. Yes.
This application was filed by the respondent for a direction to the petitioner to remove all the belongings that she claims to be hers. This is the Choultry, which wherein we have a convention center, which was leased to the petitioner on a monthly rent. There arose certain dispute with regard to the rent. Then the trial court has directed her to pay 4 crores and 4,000 or something.
Or to pay the lady neither.
Illa, illa.
No, is a sorry, the
Petitioner,
firm.
not me.
I'm sorry. One of the partners
Yes,
is a
yes.
lady. I'm sorry. The firm. One of the partners is a lady. Now we have filed this application because there was a demand of tax by the corporation, which the respondent had not paid.
All right, we'll hear it. Anyway, vacating stay ಹಾಕಿಲ್ವಲ್ಲ.
ಅಲ್ಲ ನಂದೇನ್ ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ಇವ್ರು ತಮ್ಮ ಸಾಮಾನ್ ತೆಗೆದುಕೊಂಡು ಹೋದ್ರೆ I can lease it to somebody else subject to the outcome of the suit.
No, but that's
We'll-
not
we'll
what they are
decide it.
seeking. They are seeking permission of this court to take back possession from the BBMP, which was taken from me, wherein I was prevented from being a tenant and exercising my rights. They want to short circuit the suit here by getting the relief of ejectment
All
to
right.
this
She
IA.
has filed a
BBMP
We'll
is
hear it.
not a
No, no,
party.
agreed. She has filed a counter claim. Where can I short circuit the suit? Suit is pending before the court. I made it very simple. You take back your belongings, I'll give it to somebody else and earn some money because I'm running free hostels. I have to maintain them. I require about 15 lakhs of rupees every month.
No, what is the rent paid?
Rent paid is nothing. 8 crores is to be
There was
paid
a
now.
deposit to be made here, and to him I've made it. To the respondent, there was a
ಎಷ್ಟು the
deposit.
arrears of rent?
My lord, they claim
8
4
crores, my
crores,
lord.
14
8 crores?
Yes,
is
my
what they say. It's just a bombastic number without
Fantastic.
basis.
Let her file
This
her side of the dues that she
Sir,
says that
please
she's.
don't
Alla, what?
refer to me
No,
as
petitioner
her.
and
Please
she's
address
not
me
petitioner.
appropriately, sir. You're
Sir,
a
I'm not-
That's not correct.
Did I use an unparliamentary language?
No,
I
not-
said, let her file means let the council file her application, statement
Now-
of account.
Madam, what are the arrears of rent?
My lords, there's a dispute about that. The trial court directed 4 crores, 14 lakhs to be deposited.
4 crores, 14
Of
lakhs.
this, in which this court said you deposit, you pay 50 lakhs. We have paid that. There's an interim order operating. The
Correct.
rest of the matter has to be decided before the trial court, whether that is the arrears at all. Because I was prevented from using the property partly because of the respondent's misdeeds, partly because of
So
force
why
majeure.
are you here now?
I am here because the trial court directed me to deposit the entire arrears. I am against that
4
order.
crores.
Yes, 4 crores, 14 lakhs. In that, I have an interim order, stay of the suit, and also deposit of 50 lakhs, which I have done. Now they filed
We'll
this
hear the
IA.
matter.
Yeah, we'll hear this application was necessitated because that convention hall is not being used by her for her business.
ಮತ್ತೆ her
I'm sorry. The
by the
convention-
petitioner.
The
Yes.
petitioner's business.
All right, yes.
It is lying vacant there. They have certain belongings which they claim to be belonging to them. My only request is you please take away those belongings. I can lease it to somebody else so that I can earn some money to feed as many as
See the relief
We'll hear
1,500
it.
students.
We'll hear it then. We'll fix a date
Oh,
for
this is
hearing.
not a
No, may I
convention
beseech your
hall, it's a
lordship to have
hotel.
it on some next shortest available date.
Yes. We'll fix a date. We'll hear it on 19th,
19th, my lords.
Friday.
Much obliged.
Please, my lords,
List
the
on
interim
19th.
order may be continued.
The registry to, you have entered appearance or all
My lords,
long
my
back?
name
it?
is already there.
Yes. Ravi HK should be deleted.
Yes.
Registry to delete the name of Ravi HK as appearing for the petitioner. List the matter on 19th in preliminary hearing.
My lords, the interim order may kindly.
Yes.
Wait.
Interim order stamp system will continue to the next date.
Much obliged.
Yes.
5.
I appeal for
Respondent
the
3 to 5,
petitioner
my lords.
in this matter. They
My lords,
filed
I have filed an
application for,
application for vacating the stay, my lords.
What's the suit for? Sir?
in this matter, my lord, what had happened?
Suit for
Execution petition.
execution.
petition.
All execution.
Execution of
yes.
the
This matter, what
LAC
happened?
award, my lords. Award is of the year 2014. 3 to 5 are the land
ಒಂದ್
losers,
ನಿಮಿಷ.
my lords.
Vacating stay ನಿಮ್ದ? ಹೇಳಿ 3 to, ನೀವು ಯಾರು ಸರ್?
I am for the impleading respondents.
Who is the impleading respondent?
Special land acquisition officer, National Highway Authority of India.
Why?
Because here, one small fact I would like to
ಹೇಳಿ,
submit, my
ಹೇಳಿ.
lord. In this
Yes.
matter, during the 1997, land of the respondent number 325 is acquired for the formation of the highway by the PWD department. Then they granted a compensation of rupees 75 per square feet. 29 guntas acquired in the particular village. Thereafter, that is under old act, section 4 and 6 applicable, 97 and 99 final notification done. Award passed in the year 1999. Subsequently, the reference court passed a compensation of rupees 113 per square feet. That is in the year 2000 and 2014. By that time also, they are only the party. This petitioner established in the year 2012 for the widening and formation of existing and new highway only came into picture in the 2012. That old.
Now that impleading application is rejected.
Impleading application, they filed impleading application, that came to be allowed. Now they are not pressing that matter against respondent number 1 and 2. Lordship may kindly see.
So acquisition is before your formation itself.
Yes, my lord. Lordship may kindly see. These are all the land acquisition officer fund-based project, my lord. They established for the new acquisition and.
Mic ತಗೊಳ್ಳಿ ಸ್ವಲ್ಪ. On ಆಗಿದೆ ನೋಡಿ.
On ಇದೆ. This land acquisition officer appointed under the statutory body as a statutory body only for the payment of compensation for new acquisition, and if there is a old acquisition pending matters handed over to us, we are liable to pay.
So this was not handed over to you.
Yes, no. Moreover, Lordship may kindly see on 5-2.
ಅದನ್ನೇ ಹೇಳಿ ಅಲ್ಲಿ.
ಅದನ್ನೇ ಹೇಳಿದೆ, that came to be rejected. Lordship may kindly see page number 35 for a moment, man. Initially, court issued notice based on their application. For that, the petitioner here personally files a memo. Second para onwards is important, my lord.
Acquisition date ಹೇಳಿ.
Acquisition is date 14/3/1997. 14th March 1997. And 6/1 notification on 19/11/1998. Award passed on 16/4/1999. Claimant files application under 18, section 18 of the old act on 16/12/1999.
Enhancement.
For enhancement. Initially, it was 19 lakhs. That comes to around 75 per square feet. Then reference court held that they are entitled to higher compensation, 113 per square.
What is the order of the reference court?
113 per square.
Date.
26th April 2014. In all these proceedings, this petitioner is not a party, including execution matter and LAC matters, nowhere. Thereafter.
Now, who are the other parties there?
Respondent number 1 and 2, my lord.
1 and
2.
State.
PW department. NH division. There is a confusion is that.
Oh, NH division.
NH division, care circle. Lordship may kindly see. Coordinate bench of this honorable court.
Judgment debtor number 3. I think how are you described as JDR3 because now you are impleaded.
Yes, my lord.
Yes, madam.
My lords, after filing the execution, my lords, we have taken the steps. The respondent number 2 has written a letter addressing to the court, my lords, wherein he has stated that the third respondent division is established in the Hassan. So the execution award has to be executed. All the files pertaining to the Hassan division has been transferred to the division which is established in the year 2012, my lords. The execution award is of the year 2014. So therefore the
award is not of the year 2014.
LAC award is
enhanced.
Enhanced award.
Reference order is on 2014. Section 18.
So as the second respondent has written a letter that all the documents pertaining to the said acquisition has been transferred to the division which is established in the Hassan. The petitioner, the executioner.
NHA did not initiate acquisition at all.
Not only that.
NHA did not initiate anything in this case.
Even I produced.
State has washed off its hands. Avaru kodbekagirodu.
I have produced one letter. Lakshmi kindly see page number 41. They said that NH division Hassan. Page number 41 annexure F, my lord.
41.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ದಟ್ ಇಸ್ PW ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬೆಂಗಳೂರು ದಿನಾಂಕ 9/7/2018 ಪ್ರಕಾರ ಹೊಸತಾಗಿ ಸೃಜಿಸಲಾದ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ವಿಭಾಗ ಹಾಸನ NH division. This is special land acquisition officer appointed under section 3 of the National Highways Act. There is a confusion. There are two departments, NH division and
Let's kindly. See
Anything
page-
else, ma'am?
Page number 21,
Yes,
order
ma'am.
of this
Yes.
trial court, my lords.
Hmm.
On perusal of the records, it is seen that the notice issued to the JDR number 2 is returned with a letter stating that all the records has been transferred to the Special Land Acquisition Officer, Hassan. Hence, JDR number 3 is the necessary party to the proceedings. Hence, after perusal of the records only, the court has held that the Special Land Acquisition Officer, Hassan, the records have been handed out. Accordingly, we have made them as a party, my lords.
page number 27.
ಕರೆಕ್ಟ್ ಆಗಿರೋರ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು ಮೇಡಮ್. ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಥಾರಿಟಿ ಆಫ್ ಇಂಡಿಯಾ ಅಲ್ಲ.
NH division is there, my lord. Hassan.
The petitioner,
We are the land losers, my lords, in the.
correct madam, ಏನ್ ಮಾಡ ಅಲ್ಲ
1997
state has
we
to
are-
take, you have to go against them.
Let's kindly see the
If you,
order.
madam, you're throwing your arrows on someone else, you will not get anything.
Correct, ma'am.
ಹಂಗಂತ ಏನ್ ಬೇಕು ಯಾರನ್ನ ಬೇಕಾದ್ರೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ ಬಿಡ್ಬೋದು ಅಂತಲ್ಲ, ಇಲ್ಲಿ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕು ನಿಜ, ಸ್ಟೇಟ್ ಶುಡ್ ಗಿವ್ ಇಟ್.
My lords, the conduct of the.
Conduct of the state, not them.
Correct, my lords.
Yes.
Kindly see the order of this honorable court dated.
No, we will hold up the state now.
But
Yes.
more 23-1, kindly see the order of this.
Are
one.
easily washed off your hands. Yes, state government sitting
Kindly
silent.
see 23-1 order notice.
Not the state government. There, one incident I would like to highlight.
23-1 order, Swami.
Acquisition initiate ಮಾಡಿದ್ದು ಯಾರು ಸರ್?
ಅವರೇ
State government.
ಹೌದು, ಅದರಲ್ಲಿ P. ಪ್ರಸಾದ್ ಅಂತ ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ.
ಹೌದು.
This coordinate bench of this honorable court specifically directed to execute engineer to be present before this honorable court. He was
23-1 order
present.
notice. Swami.
He was present.
23-1-25.
He was present and he stated that I would like to engage one advocate P. Prasad. He is the standing counsel for.
23-1.
25.
ಇವರು ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಥಾರಿಟಿ ಆಫ್ ಇಂಡಿಯಾ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್. ಅವ್ರು ಯಾಕೆ? ನ್ಯಾಷನಲ್ ಹೈವೇ, ಯು ಸಿ ದಿ ಆರ್ಡರ್ 23-1-25.
ಅದೇನಾಗಿದೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ಡಿವಿಷನ್ ಅಂತ ಎಕ್ಸಿಕ್ಯೂಟ್ ಇಂಜಿನಿಯರ್.
ಎಸ್,
ಎಕ್ಸಿಕ್ಯೂಟ್ ಇಂಜಿನಿಯರ್ ಅಂತ ಬೇಕಿದೆ.
In spite of that, my lords,
He
they
was
are not.
here. Executive engineer was present and he.
ಈಗ ಯಾರು, ಹೂ ಶುಡ್ ಬಿ ಸಮ್ಮನ್ ಟೆಲ್ ಮಿ? ಕಾಂಪನ್ಸೇಷನ್ ಬರ್ಬೇಕು ಇಮಿಡಿಯೇಟ್ ಆಗಿ.
Executive engineer
ಆಫ್
NH division.
ಆಫ್ ಹಾಸನ್ ಇಸ್ ಇಟ್?
There is a interim order against only as per this petition concerned. They are not filed any
My lords, we
steps.
have made all the efforts, my lords.
See, they are land losers. They need compensation. Your technicalities they will not know. Our court ಹೇಳಿದ್ದಾರೆ, ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಅಂತ ಇಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದಾರೆ. Court also is permitted without looking into the law. That's a different thing, but somebody should pay compensation now. Is the.
He is a senior citizen, my lords.
1 minute.
Response number
Will
1.
not drive you away. Wait. Yes. The executive engineer of the National Highway Division, Hassan, of the state government shall be present before the court on 15th at 2:30 PM. A copy of this order shall be furnished to the learned HCGP for its compliance. How does he escape responsibility? We'll see. Yes.
Acha. Still number 6.
Impleading applicant.
Paying for the petitioner.
I have a preliminary.
Impleading ಯಾರು? ನೀವ್ ಯಾಕೆ?
ನಾನು ಕಂಪ್ಲೇನೆಂಟ್, ಒರಿಜಿನಲ್
GM
ಕಂಪ್ಲೇನೆಂಟ್.
case sir, ಇಲ್ಲಿ ಯಾಕೆ ಬಂತಿದ್ದು?
Special order.
ನಾನು ಒರಿಜಿನಲ್ ಕಂಪ್ಲೇನೆಂಟು.
ಸರಿ.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ.
Is the complainant?
Your lordship, the interim notice is at 14. My page 14. There is no details regarding any of the
ನಿಮ್
complaint.
ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿದೆ?
ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಲಿ ಹಾಕಿ. Your lordship gets it at
Page. So impleading application.
application, impleading
Complaint
application.
No, I have.
Misuse of power, so Indiranagar club.
ಇದ್ರಲ್ಲಿ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಅಪಾಯಿಂಟ್ ಆಯಿತು. ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಹ್ಯಾಸ್ ಇಶ್ಯೂಡ್ ನೋಟಿಸ್.
Where is that?
Instead of challenging.
1 minute, sir, 1 minute. From members ಅಂತ ಇದೆ?
ಮೆಂಬರ್ಸ್ ನಾವೆಲ್ಲ ಮೆಂಬರ್ಸ್.
ಎಲ್ಲರೂ ಬರ್ತಾ ಇದ್ದೀರಾ ಈಗ?
ಅಲ್ಲ ಎಲ್ಲರೂ ಇಲ್ಲ, ನಾವಲ್ಲಿ ಸೈನ್ ಮಾಡಿದವರು ಒಂದು 5-6 ಜನ ಇದೀವಿ. 4 ಜನ ಇದೀವಿ.
ಈಗ interim order is granted, is it?
Please. ಇದರಲ್ಲಿ instead of challenging the order appointing inquiry officer.
Where is the order appointing inquiry officer?
Your Lordship, I have not been served the order appointing the inquiry officer. That is also one of the grounds I have mentioned. I have not been given any details regarding the allegations against me also.
You want to file objections to this impleading application?
I have filed.
You already filed?
I have already filed. Lordship, the objections is that the entire dispute, we are challenging the second respondent's jurisdiction in inquiring regarding allegations pertaining to election of the club. So we are only challenging the jurisdiction of the second respondent. Hence, the alleged complainants are not a necessary or a proper party for the present writ petition.
We'll see, we'll hear it then. You be on record, we'll hear
Please,
it. Yes.
Please.
List the matter on 26th. Yes.
Much obliged. Interim order may be extended.
Interim order subsisting will continue to the next date of hearing.
7.
I appear for the petitioner, Your Lordship. Lordship, one ground is on the jurisdiction point. On the last occasion, Your Lordship has made very clear that you will not consider that, and it has very much jurisdiction. The other ground which I just wanted to point out here is, Lordship, page 98 may be looked in Annexure F. Page 98, Your Lordship. Annexure F.
Page
98. Lordship, an MFA has been filed where they have filed the execution on the order of the court. An MFA has been filed and the same is pending. It is filed on 28/3/2024. And the respondent himself is a caveator in the same, Your Lordship.
ನೀವು ಹಾಕಿರೋದಲ್ವಾ ಅದು?
ಅದು MFA ನಾನು ಹಾಕಿರೋದು. 28/3.
ಆಯ್ತು, respondent caveat, so what?
ಸರ್ವ್ ಆಗಿದೆ, MFA ಸರ್ವ್ ಆಗಿದೆ. That is what I wanted to bring it to this Lordship.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಸರ್? ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡಿತ್ತು, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. What I am saying is, when the MFA is pending, without disclosing the same to the execution court, and execution court without issuing the notice to me, it has straight away given the attachment of my property.
ನಿಮ್ಮ ನೋಟಿಸ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬಿಫೋರ್ ಇದು? ಎಸ್,
ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಎಲ್ಲ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ತಾವು ನೋಡ್ಬೋದು, ಮಾರ್ಚ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಜುಲೈ ಆದ್ರೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. ಹಾಗಾಗಿ ನಾನು ಕಾದ್ಬಿಟ್ಟು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದು. ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀನಿ, ನೋಟಿಸ್ ಬಂದಿದೆ ಇವಾಗ, ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀನಿ. ಅದರಲ್ಲಿ MFA ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದೀನಿ.
ಆಯ್ತು, ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಡೀಲಿ ಈಗ.
ಅಲ್ಲಲ್ಲ, 96 ಪೇಜ್ ನಂಬರ್ 96
ಅವತ್ತು ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು ಜೂರಿಸ್ಡಿಕ್ಷನ್ ವಿಷಯವಾಗಿ.
Not only that, and also this
jurisdiction the executing court has. All right, so let the executing court decide the issue.
No,
ಹೌದು, ಕೋರ್ಟಿಗೆ MFA ಹಾಕಿದಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿಗ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡು ನಾಟ್ ಆಫ್ ಪಾಸಿಬಿಲಿಟಿ ಮ್ಯಾಟರ್ ಅಂತ
MFL
ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. MFA ಇದೆ, ಪೆಂಡಿಂಗ್ ಇದೆ.
MFA ಟ್ಯಾಗ್ ಮಾಡೋಣ, ಕೊಡಿ ಅದು.
ಅಲ್ಲ, ಟ್ಯಾಗ್ ಮಾಡೋದೇನು ಬೇಡ ಸ್ವಾಮಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು. ಅಲ್ಲಿ ಡಿಸ್ಪ್ಲೇ ಇದು ನಾಟ್ ಆಫ್ ಪಾಸಿಬಿಲಿಟಿ ಮ್ಯಾಟರ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಗಿದೆಯಲ್ಲ ಆಲ್ರೆಡಿ?
ಇದೆ, ಆಗಿದೆ.
The petitioner is before this court seeking the following prayer. The prayer of the petitioner, petitioner is on the ground that the attachment warrant of movables of the petitioner is ordered without issuing notice to the petitioner. It transpires this very petitioner has preferred a miscellaneous first appeal in MFA page 98. Page 98 alide Ajay bhai. So in the end, the learned counsel appearing for the respondent submits that there is an order undertaking. There is an undertaking given by the present respondent that they would not precipitate the matter before the executing court. In the light of the said undertaking, this petition would not be necessary, as all these contentions can be urged before the appellate court in MFA so and so. Reserving such liberty, the petition stands disposed. Yes.
Yeah, for respondent number 1 in this matter, my lord.
Petitioner.
I seek for senior is as some personal emergency, my lord, since.
Again, consideration of interim prayer in.
Idralli, I filed an application for return of plaint saying that it's a suit for specific performance, which is filed before a commercial court. So I have challenged the very jurisdiction of the court.
No, it's, my lord, it's based on a joint development agreement, my lord.
Let there be an
But it
interim
may
order
be
of stay of proceedings
well,
that can be heard at leisure.
At present, my lord, the joint development agreement has been impounded. It has been sent to district registrar.
Suit, where is the plaints? Page.
May request it to be passed.
51, my lord.
1 ನಿಮಿಷ ಇರಿ sir.
Much only.
51 is the
50?
51, my lord, is the copy of the plaint. And the relief which is sought for, my lord, is at page 66, my lord.
ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಬೇಕಾದ್ರೆ ಹಾಕ್ಬೋದು ಅಂತ ಎಲ್ಲಿದೆ?
Prayer, my lord. The first prayer is directing defendants 1 to 4 to execute and register a joint development agreement in favor of the plaintiff for development of scheduled property pursuant to aid memory agreement dated so. And cancelling the sale deed dated so and so, executed by first defend number 1 to 4 in favor of defend number 5 and 6 in respect of survey number so and so. And again, cancellation.
ರಾಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಷ್ಟೇ.
ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್
ಜಲ್ದಿ ಆಗ್ಬೇಕು ಅಂತ ಎಲ್ಲ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಹೋಗೋದಲ್ಲ.
It is the trial court matter is on 15th, my lord. I undertake to take
This is the petitioner's petition, so don't worry. The petitioner is before this court, calling in question an order dated 13/8/2024 by which the application filed by the petitioner order 7 rule 10 comes to be rejected. The application was preferred on this score that the suit which is akin to the prayers that would be akin to seeking in a suit for specific performance being sought before the commercial court. The commercial court on the face of it did not have jurisdiction, albeit prima facie, on the face, did not have jurisdiction, albeit prima facie, as the suit with the aforesaid prayers would undoubtedly be, not be maintainable before the concerned court. In that light, further proceedings before the concerned court shall remain stayed. The petitioner, the respondents is at liberty to file statement of objections and seek vacation of the order if he so desires.
There is a Supreme Court judgment on this. I filed on 26 March 2025 along with authority. And judgment of concurrent court of this honorable court.
Concurrent court of this honorable court. One ನಿಮಿಷ sir, ಕೊಡಿ. ಯಾವುದು sir?
The first judgment which is decided by the honorable Supreme Court, my lord, page number 15, my lord, in para number 20.
Yes, sir.
Where the court, it was the matter was that they were deciding the consumer dispute, where the objection was raised that it is a commercial dispute, hence it will not come before the consumer court. My lord, the Supreme Court has observed that the joint development agreement would fall within the purview of the joint venture definition.
No problem. ಅಲ್ಲಿ ಇದ್ದಿದ್ದು deficiency of the service and other things about joint development agreement.
No, not
what you are seeking is cancellation of agreement, implementation of joint development agreement in a particular manner.
No, it is there, my lord. This concurrent court of this honorable court has recorded, my lord, page number 39. Page number 39.
Yes, sir. Page number
39, my lord, in the list of authorities, my lord. Kiran Builders versus Surya Babu.
1 minute. ಬನ್ನಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ 2
ಪ್ಲೀಸ್
page ಇಲ್ಲ ಇಲ್ಲಿ ಪ್ಯಾರಾ 2. Respondent herein approached the commercial court raising a challenge to an arbitral award.
This was arbitral award with respect to joint development agreement, my lord. My lord, if my lord can come to last para, my lord, page number 8.
It has been submitted, the bar several conflicting decisions have come commercial court considering similar questions. Clear the agreement for construction infrastructure which may be titled as joint construction agreement. No problem. ಹಂಗಂತ ಎಲ್ಲ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಬರಬೇಕು ಅಂತಲ್ಲ, ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಅಗ್ರಿಮೆಂಟ್, ಆಲ್ ದೋಸ್ ರಿಲೀಫ್ಸ್ ನಾಟ್ ಇನ್ ಅ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್. ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಓದಿದ್ದೀಗ you can't read this disjuncting the facts.
No, my lord, there are two subclauses, my lord, subclause 6 and this one, my lord, which says it falls under the joint venture agreement as well as the construction and infrastructure agreement, my lord.
ನಿಮ್ಮ prayer ನೋಡಿ sir.
Asking for
prayer ನೋಡಿ.
petition of joint development agreement, my lord.
Execution
No,
of
my lords,
joint
what has
development
happened is-
agreement will come before the commercial court?
No, my lords, they only has filed an impounding application, my lords. It has been impounded saying that it's a joint development agreement. And now it has been sent to the district judge saying that pay stamp duty, my lords.
We'll hear it and decide this. Don't worry.
No, my lords, what I'm saying is that, my lords, the matter is in plaintiff evidence has been concluded, my lords. Only this agreement has been not marked and it has been posted for cross of the plaintiff witness, my lords. What I'm submitting, my lord, I will undertake to take adjournment on 15th, my lords, and it may be had any date on after 20th, my lords. We will argue on merits, my lords. Any date may be fixed, my lordship.
On the face of it.
Evidence has been
relief
concluded
that
already,
sought
my
for
lords.
cannot be granted by the commercial court. Cancellation of sale deeds, my lord, cannot happen before. I'm a third party. I'm a bona fide purchaser. Can the commercial court decide my right over the property?
Yes, sir.
They only has alleged that it is a joint development agreement, my lord, and it has been imported on that based on their submission.
Sir, it is in wrong submission.
The order has been passed impounding my agreement.
Any amount of consent cannot confer jurisdiction, sir. It
Please,
is a
my
settled principle. Wait, we'll decide. Let's the matter on 19th.
Please, my lords, my request stay may be,
Stay is granted.
matter is on 15th, my lords. I will not precipitate, my lords. I
Oh.
undertake, my lords. I will take adjournment.
Stay is
on
not
that.
for you, for the court.
Please, my lordship. It is already evidence has been concluded, my
problem.
lordship. It's
Yes.
on for the cross of.
Yes, yes.
plaintiff witness.
Next.
Number 9.
What modification?
This, your lordship, is a case in which section 11 application was allowed by the city civil court appointing an arbitrator. This is at page 25 of the petition, your honor. Page
Hello, IA modification, what is that?
I will just explain to your lordship the background in which the IA came to be filed. Page 25 of the petition.
Yes, sir.
Proceedings
It was
before the
seen that-
execution court. Proceedings before the execution court, my lord, is sought to be challenged, my lord, by the petitioners. They had approached this court and an interim order is granted by this honorable court, directing, my lord, to deposit 50% of the amount, which, my lord, they have not complied with. Now they are seeking, my lord, for modification of that order.
Ah, modification. But explanation yake, come to that.
I'll come to that.
Don't beat around the bush. Yes.
The point is this, your honor. If the 50% deposit is given, it gives life to an order which is otherwise lifeless. It's an order nullity.
What is an order nullity?
Page 25, your honor.
Ah.
The appointment of the arbitrator under
Which is
section
the order passed by this court earlier? Yaudilva?
on 13/12, it is just that there's a stay of the execution. Please deposit 50%.
Where is that?
On 13/12/2024, your honor.
Page.
No, that is the order of this
The
court.
order of this court, my lord.
In this petition.
Idralen.
Other
Petition.
order sheet, my lords, may kindly have a look.
Interim stay.
Issue emergent notice to the respondent, 13/12/20.
This is not complied.
That is not complete.
Not complained and I
Now
have
they're
filed-
Then
seeking for
modification kelta
I
hai.
have sought for modification of this.
Ah,
Now
yes,
the-
sir.
Now the case is this, your honor.
Ah.
The city civil court in Hukehi, one of the districts in Karnataka, assumes jurisdiction and appoints an arbitrator under section 11 of the Arbitration Act. Now, that per se is not permissible and any order of that sort. The arbitrator does not have jurisdiction, inherently lacks jurisdiction to pass any award.
Why you did not make those submissions at the time of grant of the interim order?
I made those submissions, your honor.
You have to seek modification before that court only.
No.
No.
The point, it's
The-
covered judgment, your honor.
Alle ಮಾಡಿ. The application,
Your Honor,
the
one
coordinate
small
bench of this court on 13/12/2024 had passed the following order. The petitioner does not comply with the order but has preferred an application seeking modification of the order. If the order has to be modified, it has to be placed before the same honorable judge who had passed the order on 13/12/2024. Therefore, the registry is directed to place the matter before the same honorable judge who had passed the interim order at 13/12/2024.
There's one submission I want to make.
ಅಲ್ಲೇ ಹೇಳಿ ಅಲ್ಲ. ಯಾಕೆ ಹೇಳಿಲ್ಲ ಅವಾಗ್ಲೇ? Before the court, why you did not say that? Before
On
the
that
order
day,
was passed?
I could not go to judgment number 3, which is produced before the court.
No problem, yes.
It is covered.
ಅಲ್ಲೇ ಹೇಳಿ sir.
One
Yes.
submission, Your Honor. This is not a review petition, just an IA. So
Modification.
modification, but
If it is modification, ಅಲ್ಲೇ, yes.
Your Honor, may a date be given, Your Honor.
I can't give a date to that court. Move it. I have directed the registry, yes.
Much obliged.
10.
So appearing for the petitioner, Your Honor. So, the present petition is
Vacating stay,
filed.
no? Please. Vacating stay, yes, sir.
The present writ petition is filed against the order on IA filed by defendant 527, seeking for amendment of writ petition filed by
Amendment
them
of writ
before
petition,
8
na?
years.
Amendment of writ petition?
Written statement.
Written statement.
Yes, sir.
So memo has been filed.
Memo? What is your case, sir? Wait, what is your case? What is the suit for?
Suit is for partition. So
What is the amendment sought? Why is it rejected?
Lord, amendment is allowed in my favor. I have filed an application for amendment of written statement. It is allotment, against which they have come before this.
You are the written statement amendment is allowed.
Please, defendant number 5.
The plaintiff is
Plaintiff
here.
is before this court.
5 to 7.
What is the ground?
My lord, the only amendment I have done, in my previous written statement in para 27, I state, my lord, that there are some sales have happened with respect to suit schedule property. With respect to those details, my lord, I have added one paragraph. That is the only amendment which I have done.
Where do I get that?
My lord, the application is at page 52. One paragraph, my lord, page para 27, capital A.
Para?
27 capital A at page 52 is the proposed paragraph, my lord, which I am.
Ashtena?
Please, Ashtem.
These flats are located on the plaintiff's property. In possession, any possession. Yes, sir. What's wrong with this? Nothing.
The application should have been submitted, dismissed in the proposed amendment is not necessary in the suit for partition. And the question of payment of the court does not even, arise. So the court has passed the order without assigning enough reasons.
Where
not
is the
even-
order? Impugned order.
57.
57.
57, page 57, reasoning is at page 59. Para 8. So, para 7 and para 8.
Memo.
One minute, madam. ಅಷ್ಟೇನಾ?
There's
ಏನ್
an
ಮೆಮೊ?
interim order of stay, sir.
Interim order?
Yes, of stay ಇದೆ.
ಇಲ್ಲಿದೆಯಾ?
So,
ಅದನ್ನೇ ಕ್ಲೋಸ್ ಮಾಡಿ.
memo ಒಂದು file ಮಾಡಿ.
ಏನ್ ಮೆಮೊ ಅದು?
So memo filed by the petitioner.
Dispensing the notice for.
Dispensing the notice.
ನಿಮ್ದೆಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ಕೇಸ್.
ಅವ್ರು ಕೊಟ್ಟ ಇವಾಗ.
ಅದಕ್ಕೆ. The petitioner is before this court calling in question an order dated 10/9/2024 passed in OS 2398 of 2024 instituted for partition and separate possession. The application under Order 6 Rule 17 filed by the defendant is allowed and the plaintiff is before the court. Heard so and so. The plaintiff institutes a suit, institutes a subject suit seeking partition separate possession. The issue in the list does not relate to the merit of the matter. During the merit of the matter, in the proceedings, the respondent defendant, though after about 7 years of the institution of the suit, files an application seeking amendment under Order 6 Rule 17. The application, the amendment sought for is as follows. The concerned court by the following order allows the application. Page 59 to 62. The order has driven the petitioner plaintiff to this court in the subject petition. The solitary contention of the learned counsel for the petitioner is that the amendment so sought by filing an application under Order 6 Rule 17 is unnecessary for the decision in the suit. A perusal at the amendment would is only for the purpose of amplification of the averments already made in the petition, in the written statement. The concerned court, by its order quoted supra, has, by rendering cogent reasons, allowed the application, holding that the application was necessary to decide the issue as the partition with regard, the issue is partition of the joint family properties. In the light of the order, we are brooding no error apparent or illegality. This court would not exercise its jurisdiction under Article 227 of the Constitution of India and obliterate the same. In the light of the petition being found wanting in merits, the petition stands rejected. Interim order of any kind stands dissolved. Yes, next.
11.
Note that written statement amendment was filed
Idu
only by
nimdena?
defendant number 5, my lord. Please, great.
Early petitioner.
The last occasion also he sought for passover. Later on,
Did not come. What's the matter?
Suit for partition has been filed.
Section 17.
26
Issue and illy.
26 rule 10 application has been filed. Refer the
Refer
document.
what?
The document, that is the genealogical tree which is engrossed on the stamp paper. In respect of that, the authorities have issued a same certificate after collecting the information by the revenue inspector.
Barbekala. The petitioner has remained continuously absent and the interim order is being extended from time to time, which is granted in the year which is granted on 28/3/2025. The suit is now stayed in the, therefore, as a last chance in the awaiting the appearance of the petitioner, list this matter on 12th. In the event the petitioner would not appear, the petition would be dismissed. Next.
12.
In order pass ಮಾಡಿದ್ರೆ ಕೇಳಿಲ್ಲ ಅಂತ ಅಲ್ಲಿಗೆ ಹೋಗಿ ತಗೊಂಡ್ಬರ್ತಾರೆ order. Yes.
Petitioner, my lord, kindly pass over the case, my lord. Senior is held up in another court, my lord.
Vacating interim order. ಅವರು ಇಲ್ವಲ್ಲ. ಏನ್ ಮ್ಯಾಟರ್?
Suit for declaration and injunction, my lord. My lords have passed an interim order not to construct, my lord. In spite of that, in spite of them undertaking that they will not construct, they have been constructing the building, my lord.
Where is the undertaking?
My lord.
Well, I didn't take any undertaking, my lord. Even I am not constructing any further construction also after the granting of the interim order, my lord. Lord, last date of hearing of
Use the
application
documents,
for
my
the
lord.
vacating
Kindly
the
pass
interim
over
order,
the
my lord.
case.
They
Have the documents, photographs, my lord.
ಕೊಡಿ.
Yes, my lord.
ಯಾವತ್ತು ತೆಗ್ದಿರೋದು? ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
No, even respondent number 2 also present before the court. I am not done any construction, my lord. After the getting the interim order.
ಅಲ್ಲ ಈಗೇನು ಇಶ್ಯೂ ಏನು ಹೇಳಿ? ಏನ್ ಮಾಡ್ತಾ ಇದೀರ ಅಲ್ಲಿ?
Signature.
FIR ಯಾಕೆ? 29/2025. ಒಂದ್ ನಿಮಿಷ. ಇದೇ ಬಿಲ್ಡಿಂಗ್ ಇದು?
Yes, my lord. Yes, my lord.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ, ಇದನ್ನ at the time of the filing the petition ಅದರಲ್ಲಿ ಇದೇ ಸ್ಟೇಟಸ್ ಇದ್ದಿದ್ದು ಅವತ್ತಿನ. I am also producing the same photos.
ಕೊಡಿ. ಪೆಟಿಷನ್ ಫೈಲ್ ಆಗ್ಬೇಕಾದ್ರೆ ಯಾವ್ದು ಇದು? ಇದಲ್ಲ, where is the date? What are these photographs?
After the
Page
interim-
115 ಏನು?
ಇದು ಸೂಟ್ ಫೈಲ್ ಮಾಡೋತ್ ನಲ್ಕು.
ಸೂಟ್ ಫೈಲ್ ಮಾಡು.
ಸೂಟ್ ಫೈಲ್ ಮಾಡೋ.
Correct. Interim order ಕೊಟ್ಟಿದ್ಯಾ ಅವತ್ತು?
There is no interim order before the trial court, my lord. Your lordship only grant the order on.
My lords, on
There is no-
9/6/2025, my lords have granted
It's
the
a
interim order. my lord.
9/6/2025.
Yes, my lord.
ಆ 9/6 ಆದ್ಮೇಲೆ ಎಲ್ಲಿದೆ photographs?
We have produced it now.
9/6 ಮುಂಚೆದು ಎಲ್ಲಿದೆ?
We have produced it in the petition, my lord, 119.
No, not like this.
Kindly pass over the case, my lord. Senior will address his arguments, my lord.
Less them.
There is some emergency, my lord. ನನ್ನ ಲೇಬರ್ಸ್ ಎಲ್ಲ ಬಂದು ಅಲ್ಲಿ ಕಾಯ್ತಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ. ನಾನು ದೂರದಿಂದ ತಗೊಂಡ್ಬಂದಿದ್ದೀನಿ ಅದನ್ನ.
Pass over.
Please.
2:30 ಬರಲಿಲ್ಲ ಅಂದ್ರೆ interim order vacate ಮಾಡ್ತೀನಿ. Yes. Next.
13.
For petition. But there are two more writ could be tagged, my lord's lordship.
Two more writ petitions?
There are two IS also filed by the petitioner. There are two writ petitions on that.
This is
The present, my lord, may just-
ಈಗ ಫಸ್ಟ್ ಇದ್ರದ್ದು ಹೇಳಿ. Two
Please.
more ಆಮೇಲೆ ನೋಡ.
Please, my lords, in this
Suit
matter,
for-
the suit for rejectment, I am the defendant. I filed an application to recall, reopen.
Recall what?
To recall PW1 for cross-section. It was filed for first time.
First time.
Please, my lords.
ಒಂದ್ ಚಾನ್ಸ್ ಕೊಟ್ಬಿಡೋಣ.
Lords, may also.
ಇಲ್ಲರ ಸುಮ್ಮನೆ ಇಲ್ಲಿ stay ಆಗಿದೆ.
ಅಲ್ಲ 2018 ಇಂದ there the 3 applications were filed. It
Where
was-
are they? ಕೊಡಿ.
Lords,
In
may also,
fact,
before that, my lords, may just take one attention of my lords. The reasonings, my lords, at page
To
50.
forget the reason, sir. ಎಷ್ಟನೇ
Well,
application ಇದು?
No, my lord, one IA for recall is first application, my lords. My lords, what they said, my lord,
ಸರ್ತಿ
there is a direction and.
You said 3 times.
There are 3 applications filed for recalling witness.
Where are they?
They have not produced. My, your lordship, it is a suit for ejectment. There is a direction by the honorable court to deposit admitted rents. 86 lakhs rupees rents are due. And they are running institution. The institution has been derecognized by the Department of Education. And they are not running the school also, institution also. before the-
Why are you before this court?
No,
Tell
my
me,
lords,
sir.
I just make this submission. My lords,
Why are you before this court?
The recall reapplication.
Where is that order?
My lord, that order at annexure page 12, my lords. Well, the reasons, my lord, they said there is a direction from this honorable court to deposit the amount or vacate the property. There
Where
no
is, where
such,
is the order?
Plus, there is no such order, my lord, they made such.
Which is the order?
Plus, annexure page 12 is the order under
No, I am
challenge.
holding, I am there, sir. Which is the order of the court?
Well, that order of the
When
court.
the defendant has failed to comply with the orders of this court, where is the order?
That order, my lord, lordship may kindly say annexure H page 55. The order sheet, I produced it, my lord, the web host. There is no such order, my lord, they made such submissions. Annexure H page 56, sorry, 55, the entire order sheet. There is no.
ಇಷ್ಟೇನ
di-
order ಇರೋದು?
ಅಷ್ಟೇ, there is no direction. My lord, they made the submission that there is
No,
an.
no, no, we have not made the OS, in OS itself, there is a direction by the honorable court under order 15 rule 10 application has been filed.
Para 9 ಗೆ ಬನ್ನಿ sir, page 16.
Para 7, my lord, they are, I'm sorry.
Para 9, hence this case. the
As per
defendant
the
accept-
statement of the plaintiff, 7 ಗೆ ಬನ್ನಿ. The Honorable High Court has directed the defendant to deposit entire arrears or quit and hand over vacant possession. Where is that order?
My
Who is
lord,
the plaintiff?
I represent plaintiff, my lord.
ಹೌದಾ?
Please.
ಇದು ಎಲ್ಲಿದೆ?
That-
ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇರೋ ಅಬ್ಸರ್ವೇಷನ್ ಗೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
A writ petition has been filed by them.
Where is the order that this court has directed entire arrears of rent or quit? Where is that order?
There is-
Order ಎಲ್ಲಿದೆ?
That is passed in WP number,
Where is that order?
that is not produced before this.
ಎಲ್ಲಿದೆ ಸರ್? ಇದ್ರೆ ಅಲ್ವಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ? ಸುಮ್ನೆ ಹೋಗಲ್ಲ ಹೇಳಿ ಒಂದು ಆರ್ಡರ್ ಬರ್ಸ್ಕೊಂಡ್ ಬಂದಿದೆ.
ಇಲ್ಲ.
ಕೊಡಿ ಸರ್ ಆರ್ಡರ್.
I'll produce it. I'll produce it. Your lordship, there is a direction by the honorable court
Where?
in original suit against which they preferred writ petition
Sir,
before this.
forget it. Writ petition, ಏನಾಯ್ತು writ petition ಅದು?
Pending.
It is pending.
ಬಟ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಯಾಕೆ ಹೇಳಿದಿರ ಅಲ್ಲಿ ಹೋಗಿ?
ಅಲ್ಲ, there was a direction by the honorable court to deposit rents, then
So,
it will consider the
I think
WP number.
ಅಷ್ಟೊಂದು ಅರ್ಥ ಆಗದೆ ಇರೋದೇನಿಲ್ಲ ಇಲ್ಲಿ. As per the statement of the plaintiff, the Honorable High Court of Karnataka has directed the defendant to deposit entire arrears of rent or quit and hand over vacant possession of the suit scheduled property. ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
While considering WP number 15029/24.
Whatever it is, ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? Why did you make this wrong statement?
I have not.
ನೀವಲ್ಲ, ಯಾರು, whoever it is. Why has the plaintiff made a wrong statement there?
No, it was a direction, my lord.
ಎಲ್ಲಿದೆ ಸರ್? ಕೊಡಿ.
That's why
We
it
will
was not considered.
impose costs on this plaintiff. Exemplary cost for having made a false submission that in the writ petition there is an order like this. Where is the order? ಏನೇನೋ ಹೇಳಿ ಆರ್ಡರ್ಗಳು ತಗೊಂಡು, what is all this?
Oral direction.
Oral direction.
The writ petition was not considered unless and until you deposit the admitted rents.
Now I will direct not to do that also because of the conduct of the plaintiff. Yes. Anything else, sir?
My humble submission before
Yes,
this
sir.
honorable court.
I will not direct, sir. I will give reasons why I don't direct. This is not the way to conduct proceedings there. ಅದಕ್ಕೆ ಎಲ್ಲ ಸ್ಟೇ ಆಗಿ ಕೂತಿದ್ದಾವೆ. This is why ಎಲ್ಲ vacating stay ಮೇಲೆ ಹಾಕಿರೋದು.
ಇಲ್ಲ 15 rule 10 application ಮೇಲೆ they
ಅದು ಏನಾದ್ರೂ ಆಗೋಗ್ಲಿ, 15 rule 10, this order cannot be sustained even for a minute because it is premised on a horribly wrong footing. And the reason for that premise is the submission of the plaintiff. I will just now set it aside. ಇಲ್ಲ ಆರ್ಡರ್ ಕೊಡಿ. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಓರಲ್ ಆಗಿ ಹೇಳಿದ್ದೆಲ್ಲ ಅಲ್ಲಿ ಹೇಳಿ ಆರ್ಡರ್ ಅಂತ ಬರೀತೀವಿ, ಹೊರಿಸ್ತೀರಾ?
ಇಲ್ಲ ನಾವು ತಪ್ಪು
ಮತ್ತೆ ಇನ್ನೇನು, ಯಾರು ಪ್ಲೇಂಟಿಫ್ ತಾನೇ ಹೇಳಿರೋದಲ್ಲಿ?
That was the submission made before the honorable court in WP number 15029/24.
ಆರ್ಡರ್ ಎಲ್ಲಿ ಪಾಸ್? ಇಲ್ಲ ಇದೆ ಆರ್ಡರ್ ಶೀಟ್ ಪೂರ್ತಿ. ಅನೆಕ್ಷರ್ ಹೆಚ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಪೂರ್ತಿ ಇದೆ ಅದರ ಆ ತರದ್ದು ಒಂದು ಶಬ್ದ ಇಲ್ಲ. The petitioner.
Also, order sheet is not produced.
ಆಯ್ತು ಸರ್, ಈ ಪೆಟಿಷನ್ ತರ್ಸೋಣ ಮಧ್ಯಾಹ್ನಕ್ಕೆ. ಇಲ್ಲ ಅಂದ್ರೆ ವೇಟ್ ರೆಡಿ ಫಾರ್ ಕಾಸ್ಟ್ ಆಫ್ ಅ ಲ್ಯಾಕ್.
Oh my lord.
It's also one, sir. Nan WS ಮೇಲೆ IA ಮೇಲೆ WS has taken as nil. I filed an application to recall. Application consider ಮಾಡಿಲ್ಲ also may issue.
Strike off has been order has been passed.
But it was
ಈಗ
initially.
ಸದ್ಯಕ್ಕೆ ಇದನ್ನ ಮಾಡಿ. Don't obfuscate the issue further. The petitioner is before this court calling in question an order dated 24/3/2025 passed on ಎರಡೇ ಯಾವ್ದಿದು?
Recall
and
ಎರಡು recall
no, recall and reopen the stage. Recall PW.
On applications IA 7 and 8 in OS 1286 of 2022. The petitioner is the defendant, the respondent, the plaintiff. The plaintiff and the respondent have an agreement with regard to the suit schedule property, the agreement of lease. The plaintiff institutes a suit seeking ejectment of the petitioner from the suit schedule property. The issue in the list does not pertain to the merit of the matter, but certain applications filed by the petitioner seeking recall of further examination of PW1 and the reopening of the case from the stage of such examination. The concerned court rejects the application. The rejection of the application has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would submit that the order of rejection of recall of application is on the premise that this court has in a particular writ petition directed deposit of entire arrears of rent or quit the property. This is in fact quit the property. The learned counsel would submit that the recall of PW1 was to recall and reopen was for the first time sought before the concerned court. The learned counsel appearing for the respondent would refute the submissions in contending that there is a writ petition filed in WP 8927 of 2024 in which certain orders are passed and therefore the orders are passed and there is not the deposit of arrears of rent is not done by the petitioner. Therefore, indulgence should not be shown at the hands of this court to the petitioner. I have given my anxious considerations. Therefore, narrated facts are not in dispute. The narrated facts, dates, link in the chain of events are all a matter of record. The plaintiff respondent has instituted a suit seeking ejectment of the petitioner. In the said suit, in the said suit, 2 applications are filed. Recall of PW1 for the purpose of cross-examination and reopening of the case from the said stage. The concerned court by the following order rejects the applications. At paragraph 7 and paragraph 9, which forms the major portion of the order, the observation is that this court in writ petition 8927 of 2024 has passed an order of deposit of arrears of rent by the petitioner or quit and hand over vacant possession of the property. The learned counsel appearing for the petitioner has placed on record the entire order sheet in writ petition 8927 of 2024. It reads as follows. A perusal at the order sheet of the writ petition would clearly indicate that there is no such order passed by the coordinate bench. It was on the face of it a false submission made by the plaintiff before the concerned court, which has been neatly bought by the concerned court and rejected the application. The entire order is premised on the submission of the plaintiff that this court in the petition indicated here and above has directed by payment of arrears of rent or quitting, or the petitioner quitting from the quitting and delivering over vacant possession of the property, while there is no such order. If the reason to reject the application is based upon this erroneous premise, which is based upon the falsehood of the plaintiff before the concerned court, there can be no question of sustainability of the order that is passed. For the aforesaid reason, only on the aforesaid reasons, the order dated so and so stands quashed. The application filed by the petition IA 7 and 8 shall merit consideration afresh in accordance with law at the hands of the concerned court, ordered accordingly.
Lordship, in the writ petition 8924/27/24, the Honorable Court directed, having challenged their order, that to deposit entire arrears of rent.
Ellide sir, kodi sir. Order idea tara?
That was challenged before the.
Bere ee court order madidara tara?
Unless and until it is deposited, I will not consider the stay the prayer for stay. That was the order passed by the Honorable Court.
Ellide order?
Adrinda he sought 2 weeks time anta ade order sheet alli.
I should imagine what that court said. ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು.
Annexure HL ಇರುತ್ತೆ.
ಆರ್ಡರ್ ಇದ್ರೆ ಬರ್ಸ್ಬೇಕು ಆರ್ಡರ್ನ.
No, the court directed to deposit entire arrears.
ಎಲ್ಲಿದೆ ಡೈರೆಕ್ಷನ್?
Before the trial court.
Trial court, sorry sir. All right. You have said this court has directed.
No, before the trial court, it was direction
anyway,
was
I can't
given.
convince you. Anyway, pass the orders. Yes. Next.
14.
I appear for the petitioner. If my lords remember, I filed my lords.
Yen modification, ನನ್ನ order, ಯಾರ order?
No, my lords, the coordinate bench's order.
Go there only.
Please.
Yes.
It was already, my lords, listed
My lords.
previously.
Yeah, it was substantially argued, my lord. If I may just show, my lords, from 7 years, they have not paid permanent alimony.
Lords, if my
My
lords
lords,
remember,
my-
I have paid my lords 16 lakh, my lords, is my contention. Lords,
Go before the same
Please,
court.
Lords, it was already
Modifi-
listed once, my lords, but then due to my lords, the coordinate
what?
bench, my lords, gave a date. But my lords, because it is a GMCPC, it came back, my lords, before this court.
The application is preferred seeking modification of the order dated 26/4/2025 passed by the coordinate bench. If it is to be modified, it has to be placed before the same honorable judge who had passed the order. Therefore, the registry is directed to place the application before the same honorable judge who had passed the order, which modification of which is now sort of. Yes,
Lords,
next.
can I seek for a date, my
No,
lords,
sir.
because the.
Move the matter there.
My lords, interim order may not be continued, my lord.
Well,
They're not in
interim order subsisting would continue till the next date. What sort of submission is this?
No, my lord, interim
Yes.
order should not be continued.
Well, what sort of
My lord,
submission is
because they have
that?
not complied with it.
That's okay. Ask that court.
My lords, your lordship had
ನಾನು ಅಲ್ಲಿ
extended-
ಕೇಳಬೇಕು ಅಂತ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಮಾಡಬಾರ್ದು ಅಂತ. Yes. Next.
The order of appointing court commissioner, the instance of
Suit for-
application, suit for declaration filed by the respondent voter 7 who are the plaintiffs, my lord, sir. and
ಅಲೋ ಆಗಿದೆಯಾ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
it's allowed. It is allowed. Well, their contention is that way back in 1968, an extent of 36 guntas was sold in favor of father of the petitioner, who is the third defendant.
ಈಗ ಅಲೋ ಆದ ತಕ್ಷಣ ಏನ್ ಸೂಟ್ ಹೊಟ್ಟೋಯ್ತಾ?
ಹೊಟ್ಟೋಯ್ತು ಅಂತಂದ್ರೆ the crux of the application is that they are attempting to make a request before the court below by appointing commissioner to, discover the possession. Plaintiffs. Discover the possession. My lord may kindly come to the application filed at page 88, annexure K. To demarcate the properties based on the boundaries as mentioned in the registered sale deed dated so and so, and also suit schedule property. And the affidavit at page 91, para 5, which I would like to note, when the fact read by this honorable court, the issues involved.
Demarcate the property based on bound declaration suit tane.
Declaration suit, otherly possession. What they are claiming is that now they are disputing that the extent of sale under the sale deed of the year 1968 is only 7 guntas, not the entire 36 guntas. Not to dispute the bona fides, I would like to draw my lord's attention to page 44, an application submitted by the first plaintiff before the Tahsildar concerned in 2012. Her husband stated to have died in 2006. Illi typed copy 45. Nanna ಯಜಮಾನರಾದ ಓಜೇಗೌಡ ಬಿನ್ ಕೆಂಪೇಗೌಡ ಅವರ ಹೆಸರಿಗೆ ಆರೋಳಿ ಹೋಬಳಿ ಕೊಟ್ಕಾಳು ಗ್ರಾಮ ಸೋಂಡ್.
Where is the order?
In page number 94, my lord.
If at all the contention is that 7 guntas, then why did she made application in 2012, discarding that application upon consideration of my objection? Entire, the khata was transferred into my name, and the court below stated that in order to ascertain this assertion of the plaintiffs, it is necessary to appoint a court commissioner. It amounts to, my lord, the demarcation of the possession, which is impermissible. But I would like to brought to the notice of this.
Very report ತಂದ ತಕ್ಷಣ demarcation ಆಗಲ್ಲ.
That is their purpose, what they have sought.
Purpose is evidence, yes.
Provided that, my lord, the factum of possession that the parties, it's the obligation on the parties to prove it. Lord, I would like to rely upon.
Oh, please, sir, kodi.
The
Injunction suit.
It's a.
Postulates are laid down. Postulates are laid down.
Yes.
ಅದ್ರಲ್ಲಿ ಓದಿ.
In fact, at page, para 12.
ಓದಿ.
Where it is made applicable under the provisions of provisions applicable for local inspection, what is impermissible is the delegation of adjudicating power. To cite an example, if both parties claim to be in possession of the disputed property, the local inspection by the commissioner cannot be ordered to ascertain the possession. This is what exactly the purpose behind fielding this application. The question of possession is to be decided by the court. However, if one party alleges encroachment, then by another, and the other party denies such allegation, the commissioner can be appointed to ascertain whether there is encroachment or not. It is their contention. After 50 years, this suit is filed in the year 2014, that they are the owners of to an extent of 27 guntas and dispute the sale deed of the which was executed long back. They have not even filed a suit for rectification.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
ಏನಂತ
ಯಾವುದು 9/2/1968?
ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಅದನ್ನೇ ಚಾಲೆಂಜ್. My lord, my suit is based on the very same sale deed only. For a moment, my lord, kindly turn to ink page number 99, annexure M. The entire survey number 21/6, my lord, measuring 2 acres 29 guntas. Out of the said extent, my lord, the grandfather of the plaintiff, my lord, acquired 36.5 guntas in 2 bits. One bit, my lord, 7.5 guntas, and second bit, my lord, 26.5 guntas, both with separate boundaries. But while executing the sale deed in favor of the father of the defendant, my lord, they have executed, my lord, with respect to 7.5 guntas. But
when is the sale deed executed?
My lord, 1968.
1968.
For a moment, my lord, kindly turn to, my lord.
ಈಗ ಅವತ್ತು ಬಿಟ್ಟೋಗಿದೆ 7.5 guntas ಅನ್ಬಿಟ್ಟು ಈಗ ಚೆಕ್ ಮಾಡಬೇಕು.
Sketch, my lord, 26, my lord, suit sketch. For a moment, kindly turn into, my lord. This, my lord, suit sketch, the portion Total extent, my lord, 2 acres 29 guntas. Out of the said extent, MNOP, my lord, this is, my lord, the fallen to the share of the grandfather of the plaintiff, 7.5 guntas, and one more portion, my lord, ABCD fallen to the share of 27 3/4 guntas. My lord, the same is mentioned in Annexure C also. For a moment, kindly turn to Annexure C, ink page number 43. ಇದರಲ್ಲಿ ಚೆಕ್ ಬಂದಿ ನಮ್ಮ ಅನುಭವದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 22ನೇ ಪೋಡು ನಂಬರ್ ಅಲ್ಲಿ ನಮ್ಮ ಅನುಭವಕ್ಕೆ 36 ಗುಂಟೆ ಆಕಾರ ಸೋ ಅಂಡ್ ಸೋ, ಪೂರ್ವಕ್ಕೆ ಓಟ್ಲಿ ಮೋಜಿ ಕೆಂಪೇಗೌಡರ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಮಹಾದೇವರಾಯನ ಭೋಗ್ಯವಾಗಿರುವ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ಮೂಗಯ್ಯನ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಇದೇ ನಂಬರ್ ನಲ್ಲಿ ನಮ್ಮ ಹಿಸ್ಸೆಯ ಜಮೀನು, ಈ ಮಧ್ಯೆ ಇರುವ ಮೇಲ್ಕಂಡ ಜಮೀನು. Whatever retained, my lord, have retained the, my lord, the land in the southern portion of the said extent.
And prove your title there.
My point is, my lord, kindly come to next document. If such being the case, they should have restricted, even so belatedly filed application at page 44. She has submitted application seeking seeking kata, transfer of kata in respect of 36 and 1/4 guntas at page 44. That too in 2012, and she stated that her husband died in 2006. And upon submission of my objection, my lord, the Tashidar has passed an order in 2012, and the kata was transferred into my name. And after 2 years, this suit came to be filed. That too without making any application for rectification of the sale deed, or even questioning the validity of sale deed, that is not binding on them, howsoever it may be. Lord, directly they have
ಈಗ prayer ಏನಿದೆ?
ನಂದು ಬರೀ
this is for declare that plaintiffs are the absolute owners of the suit schedule property, which is 27 guntas. Page 22, internal page 9, my lord, sir, the plaint. Okay, this is the obligation on the part of the plaintiffs to establish.
Petitioner, defendant number 3 in OS 234 of 2014 is before this court, calling in question an order dated 17/4/2025 passed in OS 603 of 2014, allowing an application filed by the plaintiff under Order 26 Rule 9 seeking appointment of a court commissioner for local inspection and a report to be submitted thereon. The petitioner heard so and so. The petitioner is the third defendant, the respondents, the plaintiffs. The plaintiffs institute a suit in the subject OS in the year 2014 seeking relief of declaration and possession. The issue in the list is not with regard to the merit of the matter.
Permanent injunction.
Permanent injunction. The issue in the list is not with regard to the merit of the matter. The plaintiff in a suit instituted in the year 2014, i.e. 603 of 2014, files an application under Order 26 Rule 9 of the CPC seeking appointment of a court commissioner after about 10 years of institution of the said suit. The application comes to be allowed, and the allowing of the application is what has driven the third defendant, i.e. the contesting defendant, before this court in the subject petition. The learned counsel M.H. Prakash, appearing for the petitioner, would contend that the petitioner is wanting evidence from the hands of the commissioner, which he himself does not have. The learned counsel submit, which they themselves do not have. The learned counsel, taking this court to the order itself, would submit that that what is sought is the boundaries and certain details regarding a sale deed of the year 1968. According to the petitioner, according to the counsel, if 7.5 guntas had been left out in 1968 in the said sale deed, the sale deed, there is no rectification sought, nor the sale deed is questioned, nor the sale deed is sought, nor an order, nor a suit is instituted, say, contending that the sale deed would not be binding upon the plaintiff. That being the case, now an application is filed in the year 2024 of a document of 9/2/1968 and the boundaries thereon to be determined. He would submit that this cannot be anything but fetching evidence in favor of the plaintiff. The learned counsel Nandish Gaud, appearing for the respondent, would submit that the inspection became imperative as as observed by the concerned court with regard to 7.5 guntas of the sale deed dated 1968 and the boundaries drawn thereon. And therefore, no prejudice would be caused to the petitioner if the report of the commissioner is sought. In fact, it would steer clear the controversy is what the learned counsel would submit. I have given my source. Therefore, narrated facts are not in dispute. The narrated facts are a matter of record. The suit is one for declaration and permanent injunction. The prior in the suit is as follows, page 22. The narration in the suit is that a registered sale deed was entered into on 9/2/1968, which is shown as MNOP in a rough sketch produced. And there is discrepancy with regard to the boundary of a boundary depicted in the sale deed dated 9/2/1968 with concerning 7.5 guntas. The suit is instituted in the year 2014 with the aforesaid prayer and on the aforesaid premise. When the suit progressed to a large extent, 10 years passed by, and at the fag end of the suit, fag end of the trial in the suit, the application comes to be filed under Order 26 Rule 9 of the CPC, seeking report of a commissioner pursuant to a local inspection. The concerned court by the following order allows the application. The reason so rendered by the concerned court is as follows, page 198 to 102. As submitted by the learned counsel appearing for the petitioner, the sale deed dated 9/2/1968 has spent itself. If the plaintiff is wanting to seek his title, the relief that he has sought on the strength of the said sale deed, and the discrepancy or any contention with regard to the sale deed has been left over for close to 50 years. Now the petitioner cannot, by way of the court commissioner, dig in evidence or fetch evidence in his favor, which has become bleak during the trial. In that light, the order of the concerned court runs foul of the judgment rendered by the coordinate bench of this court in the case of Shadak Sharappa versus so-and-so, ILR 2023, Karnataka, page 53, court para 12. ILR Karnataka, ILR, sorry. 2023 SCC online Karnataka, page 53, court para 12. So in the coordinate bench has considered the entire spectrum of the circumstances that may arise with regard to an application under Order 26 Rule 9 being filed and it being allowed. One such circumstance is with regard to possession. The possession has to be proved by the evidence before the concerned court and not by fetching evidence through the appointment of a court commissioner. In the light of the law as laid down by the coordinate bench, the order of the concerned court would fly foul. In that light, the order becomes unsustainable. For the aforesaid reasons, the following allowed, quashed. Next.
16.
Against issuing of notice on ex parte prayer.
Nanneda.
Alla.
Yes. Yes, sir.
Non-granting of ad interim order is the subject matter.
ಈಗಿಬ್ರು ಇದ್ದೀರಲ್ಲ ಅಲ್ಲೇ ಮಾಡಿ
ಅಲ್ಲಿ ಮಾಡಬಹುದು. ಅದರಲ್ಲಿ ಒಂದೇ ಐ ವಿಲ್ ಬ್ರಿಂಗ್ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ನೋಟಿಸ್. IA 1 and 2 ತಾವು ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಿದೆ. It may be made as status quo, not to be influenced by that order ಅಂತ ಅಬ್ಸರ್ವ್ ಮಾಡಿರಾಯ್ತು. But IA number 3 IA 2 ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ ಅಲೌಡ್ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಿದೆ.
ಇಲ್ಲ, ಗ್ರಾಂಟ್ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಆಸ್ ಸ್ಪ್ರೆಡ್ ಫಾರ್ IA 2, 3. Yes, that separate ಆಗಿ ಮಾಡ್ಲಿ ಅಲ್ಲಿ ರವಿಶಂಕರ್ ಸರ್.
Lord's police protection, of course, Lord's, your Lord's, my direct, it can be
Alle,
considered
that will be
independently.
considered
Whatever
independent.
interim order is there, it can be continued
till the
IA
matter
1
is
and
decided
2
within 4 weeks.
IA 1 and 2 for 4 weeks, I will continue. IA 3, police protection will be considered independent.
IA 1 and 3.
I just wanted to say this, my lords. They have got only 2 stands, as I can make out from their statement of objections. There's nothing for them to even go and contest the matter before the court because I'll just take 1 minute, my lords.
What's the suit for?
Lords, the suit is for injunction. Lords, your lords may recollect, my lords, this matter had come up relating to one of the wills said to have been executed where your lordship directed CBI inquiry, which was upheld by the Supreme Court, directed to be concluded within a period of 8 months. Now they have got 2 stands which they are taking, my lords. Number 1, they say money is given by us but the property was purchased in the name of Rajaram, the predecessor in interest of the present petitioners before lordships. That is a matter presently at large before the Supreme Court. That's not a defense available to them. 2 is regarding the will. They say that after the death, he is a person who has executed a will. That is subject matter of an investigation. They don't have a defense. Other than that, they don't have any other story to tell. I tell
ಅಲ್ಲ ಇದು ಸುಮ್ಮನೆ ರೆಮಿನಿಸೆನ್ಸ್. Yes. The petitioner is before this court seeking the following prayer. The petitioner heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner, learned senior counsel Jaykumar S. Patil representing the respondent. The petitioner is driven to this court on a threshold premise. The petitioner institutes suit seeking injunction against the respondents. The concerned court does not grant ex parte temporary injunction and leaves the application under Order 39 Rule 1 and 2 to be considered at a later point in time after the appearance of the respondents. To protect the interests of the petitioner, this court had granted an interim order on 30/6/2025, which reads as follows. The respondent is now represented. In the light of the representation of the respondent, it is now necessary for the concerned court to consider the application of Order 39 Rule 1 and 2 and pass necessary orders in accordance with law. The learned senior counsel would submit that, in accordance with law. The learned counsel for the senior counsel for the petitioner submits that the order dated 30/6/2025 be continued till the application would be considered at the hands of the concerned court. The learned counsel for the learned senior counsel for the respondent submits that IA 1, 2, and 3 are all injuncted by the aforequoted order. He would submit that IA 1 and 3 were for injunction, but IA 2 were for grant of police protection. If therefore I deem it appropriate to continue the order dated 30/6/2025 for a period of 4 weeks, while directing the concerned court to consider the application filed by the petitioners under Order 39 Rule 1 and 2 within an outer limit of 4 weeks. The order on IA 1 and 3, the order dated 30/6/2025 would be restricted to IA 1 and 3. Insofar as IA 2, which was seeking police protection, is concerned, it is for the concerned court to answer the said application on its merit after hearing the parties. For the aforesaid reasons, the following order. The writ petition stands disposed. The concerned court is directed to answer the application of Order 39 Rule 1 and 2 after hearing both the parties.
All 3 applications. Your lordships may say all the 3 applications.
All police
it will be a consequential order.
The applications before the concerned court under the Order 39 Rule 1 and 2 or otherwise, and 151 of the CPC. The interim order granted on 30/6/2025 only insofar as applications IA 1 and 3 are concerned shall stand extended for a period of 4 weeks. All contentions remain
Can I make this request, Milords? It should not happen that for some reason the trial court is unable to conclude 4 weeks from today. Your lordships may have already directed that trial court shall decide this matter within a period of 4 weeks. We'll cooperate. Let it be extended till the applications are decided by the trial court, Milords. Please.
Yes. The 4 weeks
injunction ಬದಲು ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಮಾಡಬಹುದು.
4 weeks ಅಲ್ಲಿ ಹೇಳಿದಿನಲ್ಲ ಮೇಲ್ 4 weeks ಅಂತ ಅದನ್ನ till the conclusion till the court answers the application. Anyway I have said 4 weeks.
Please, Milords. Great.
17
ಹೇಳಿ ಸರ್.
ಮತ್ತೆ
ಹೇಳಿ ಅವರು
ಆಯ್ತು.
Lords, the property of the petition has been utilized in various extents. And your lordships had notified, but the interim order is restricted only to 3 guntas, for which your lordships wanted to hear the other side and had notified. But they have to now make a statement because page 160, the sketch is
Interim order
already.
illide.
No, for consideration, my lords, your lordships had
Consideration.
notified the other side.
I am for the respondent number 5. Just received instructions yesterday to file an
Right,
objection.
3 guntas ಅಷ್ಟೇ ಅಲ್ವಾ?
Now, the interim prayer which we are seeking is only for 3 guntas because that is what is remaining. I am admitting to the
Not
fact.
to utilize.
Yes, not to utilize, because all the properties are utilized, not acquired.
Without acquisition utilized?
Yes. Railways is used. My lords, kindly have a look at page 160, my lords. This is the survey which was conducted after we gave a complaint.
We'll decide, yes.
Insofar as 3 guntas, if it is not utilized
As on today.
As on
That is
today,
there.
very well.
The counsel for the, heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner. The
Number 5.
respond number 5, railways, huh?
BMRC.
The respondents, you are the 5th respondent?
I'm the 5th.
Respondent number 5 seeks 2 weeks time to file statement of objections. The learned senior counsel submits the interim order that is sought is not to utilize the remaining 3 guntas of land while the railways have utilized every other land and every other land of the petitioner. In that light, there shall be an interim order as prayed for only in the event that those 3 guntas are not utilized as on today. Yes.
That's Railways and BMRCL.
Railways and BMRs.
Please.
Yes.
Great.
Yes.
Orders 18.
On GM CPC day, not that you should not come, but why are you both senior counsels waiting on North side? Either noderlill.
Today unusually the court was little bit slow. Otherwise normally by this time it would have been over. By 11:15 would have
No,
been
I am
over.
not well. That is, yes. Running temperature. Yes.
Please, Your Lordship. My Lord, it's a petition filed by victims, my Lord.
Yes.
The
The 311 application.
The 311 and 91 application was filed, my Lord, to produce 2 documents and to recall PW 14 for further examination, to get marked these 2 documents. My Lord, kindly see the documents, my Lord, at page 40, my Lord. These 2 documents, my Lord, were issued by accused number 1 in the year 2007, my Lord. Kindly page 40, my Lord.
Page 40.
40, Your Lordship.
Yes, sir.
My Lord, petition 11107, Your Lordship.
I'm holding that.
Yes,
one.
yes, yes. My Lord, this is addressed to PW 14, my Lord. My Lord, issued by accused number 1, my Lord. Bottom, my Lord, that the contents, my Lord,
ನಿಷ್ಠೆಯಿಂದ
that
ದಕ್ಷತೆಯಿಂದ ನಿರ್ವಹಿಸಿದ so and so. ಇನ್ನು ಮುಂದೆ
ತೆರವಾದ ಹುದ್ದೆಯನ್ನು ಇಂದಿನ ಜಾರಿಗೆ ಬರುವಂತೆ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. Here, the resignation given by this PW 14 was accepted unconditionally and his work, my Lord, was recognized, appreciated in this letter. And in next page also, my Lord, another letter. He was also the secretary of Vidya Pita. My Lord, page 41, my Lord, second paragraph, my Lord. You had dedicated your most precious time to me and to my great satisfaction and accompanied me in good and bad days with such goodness, love, affection, understanding. My Lord, you had stated in your resignation letter.
ಈಗ you want to produce these documents.
These 2 documents, my Lord, they want to produce. It is the application, my Lord, filed by prosecution. Kindly see, my Lord, the application it is.
ಎಲ್ಲಿದೆ page 42.
Page 42, my Lord, is the application. My Lord, the stage was, my Lord, immediately after recording of 313 statement, my Lord, this application was filed. My Lord, seeking production of these 2 letters and for further examination of PW 14. My Lord, on the day, that is 10/7, when this application was filed, the statement of accused persons were recorded same day, Your Lordship. In those statements, all the three accused make an allegation that this PW14 is responsible for setting up of these victims and initiated the prosecution at his instance. And also, my lord, the ground is this PW14 was removed from service because of his malpractice at that time. That is the defense taken. And also in 313 statement, this is the statement that they have given. Kindly, my lord, that we have produced a 313 statement of
Who is the accused here?
accused is respondent number 234.
Allah, accused. You are the complainant
We are for victims. Your Lord.
or victim. Yes.
My lord,
How is this
application-
relevant whether you have been given encomiums or not for the victim's case?
my lord,
How is the document which
document-
shows
yes, yes. Your
there
Lordship,
may be
this-
plethora of encomiums
No, no, not
on
like
you?
that. Your Lordship, may
How
kindly
is
see-
that relevant for victim?
Relevancy, Your Lordship, kindly see relevant for the case.
Cases of POXO.
Well, case of
Cases
POXO.
of POXO.
POXO.
All right.
Well,
ಅದರಲ್ಲಿ
okay.
ವಿಕ್ಟಿಮ್ಗೆ ಇದೆಲ್ಲ ಇವ್ರಿಗೆ ಲೆಟರ್ಸ್ ಆಫ್ ಅಪ್ರಿಸಿಯೇಷನ್ ಬಂದಿತ್ತು ಇವ್ರಿಗೆ ಅನ್ಬಿಟ್ಟು ವಿಕ್ಟಿಮ್ಗೆ ಹಾಕ್ಬೇಕದು.
My lord, here the question, my lord, it is in
Don't you
respect of
think
the case.
there is a skeleton coming out of the cupboard
Not
here?
like that, Your Lordship.
Then-
My lord, PW 14 and 15, my lord, husband and wife. At the first instance, my lord, they came to Bangalore, rescued those victims.
Correct.
My lord, it is for the first time before them, my lord, they disclosed this
No
incident.
problem.
Yes. My lord, the evidence of PW 14 and 15, my lord, is a corroborative evidence to the testimony of victim.
No problem.
Yes, my lord, when the defense is attacking the testimony of PW 14 and 15 about their character and all that, my lord, it is required that the letters which shows that
We will take the letter of appreciation will be taken note of, not a problem. Why do you need
is what-
recalling of victim ಮೂಲಕ ಇದನ್ನ ಹೇಳಿಸ್ಬೇಕು ಅಂತೇನು?
no, not like that, not through victim.
Then-
It is to be, my lord, evidence to be led through PW 14, not through victim. My lord,
PW
we are only challenging the order, my lord, passed by the trial court. My lord, it is not through
This
victim that
you can
we are
always submit. ಅದಕ್ಕೋಸ್ಕರ ಇದು ಸ್ಟೇ
But the proof of, that's what, my lord, that proof of these two documents, my lord, the prosecution is seeking.
Yes, sir.
My lord, the order is challenging, that's all it is.
ಅಷ್ಟೇ ಇದೆ, ಅಷ್ಟೇ
My lord,
ತಾನೇ.
That's all, my lord, here, in order to put it straight, my lord, and clearly, my lord, these two documents which were the part of judicial record, my lord, it is not invented for the first time. My lord, these two documents were produced in a criminal case which was launched against PW 14. My lord, these two documents were adjudicated. A judicial finding is recorded by the Honorable JMFC. Later, my lord, by the CMM Court of Bangalore for elected representative, a finding is recorded. Judgment is also there. Now, my lord, they are seeking for production of these two letters, my lord, which was not produced by the accused, only charge sheet is produced. Kindly see, my lord, that in the evidence of PW 14, my lord, exhibit
Charge
D-
sheet in which case? In the case where you are the accused.
Yes, my lord, PW 14 was the accused, charge sheet was produced. These two letters were not marked or got confronted to PW 14. Now, these two letters which were not produced either by the defense or by the prosecution remains incomplete. Evidence remains ambiguity. This is required to be produced to clarify and to complete the evidence. It is not that something new is to be added here. Kindly see, my lord, here in the
Yes,
evidence.
ಇಷ್ಟೇ ಇರೋದು 42 ಅಲ್ಲಿ ಇರೋದು ಅಷ್ಟೇ.
ಅಷ್ಟೇ 40, 41, two letters, my lord.
No, 40, 41, two letters
and
through 42
41
you
is
want
the
to produce.
application, my lord, that, my lord, these two letters to be confronted to PW 14, prosecution wants to introduce these two documents as an evidence. Except this, my lord, that what evidentiary value could be attached for this is a matter of appreciation by the trial court. But the necessity is that these two letters contents clearly disclose
ಆಯ್ತು, ಅಷ್ಟೇ ಇರೋದು
contrary to
ಅದರಲ್ಲಿ.
defense. That's all it is.
Yes, sir.
PW 14 is the person who is sought to be recalled for the purpose of further examination in chief.
Recall PW 14.
For further examination in chief.
Ah.
But he came to be examined on 7th of December 2024.
7th of
December 2024. He came to be cross-examined at length on 16th of December 2024. Subsequent thereto, 41 witnesses are examined in the case. Consequent to the directions which came to be given by the Honorable
Yes.
Supreme Court. And the trial has got to be concluded within a period of 1 year. In fact, the Lawrence trial judge has sought for extension of time by making an appropriate request to the Supreme Court. Supreme Court has granted by 3 months.
ಈಗ
Well,
ಎಲ್ಲಿ
these-
ಎಂಡ್ ಆಗದೆ ಯಾವಾಗ ಅದು?
I'm
Three
sorry,
three
now-
months ಎಂಡ್ ಆಗದು?
Now it is posted for arguments.
Where are the orders?
Application came to be filed.
1 minute, sir. Where are the orders of the Supreme Court?
Well, in fact, the Lawrence judge himself would refer to it at page 34, in page 34, paragraph 14. Well, he is not the victim. He is not the first informant in the case. He is nobody in the case. Well, he wants to bring on record in the case a letter of appreciation given to him by the accused. Well, unless and until it is necessary for the just decision of the case, he shall not be recalled. Is the law laid down by the Supreme Court. In fact, that is the law which my lord has also laid down in one of the cases.
Yes.
It must be necessary for the just decision. Well, I give him encomiums. I praise him. Oh, you are a wonderful man. You are very, very honest. Your integrity is high class. In what way that is relevant or necessary for the purpose of a just decision in this case? In which case, my lord, the accused has been facing trial for an offence under section 376. How is it relevant? It must be relevant. It must be necessary. Encomium, giving him some encomiums, in what way that will help the prosecution to arrive at a just decision in the matter, whether the accused has committed this offence or not. But may I request your lordship to kindly turn to paragraph 14, your lordship would get this. The main allegation is against accused number 1 that he, being the head of the mutt, used to call the victim to the private, etc. Entire case relies on the evidence of the victim. Evidence of PW 14 is that he knows about the act committed by the accused number 1 through the victim, and then he took them to Vadanadi Seva Samiti. PW 14 has an opportunity to bring his evidence in chief and also at the time of cross-examination to depose that the accused number 1 had given appreciation letters to him. But during his evidence, he did not state anything with regard to the appreciation letter issued by the accused number 1 in his favor. In this case, prosecution has already examined 54 witnesses. He is PW 14. Another 44 witnesses have been examined subsequent to his examination. And this court has already recorded the statement of the accused under section 313 CRPC. The Honorable Appellate Court has given an action to dispose of this matter within a period of 1 year. The period has also completed, and this court has sent a letter to the Honorable Apex Court requesting for 3 months' time for disposing of this matter. At this stage, the prosecution has filed its application for recall of PW 14 for production of document. But prosecution is the one who makes the application before the court. It suffers an order. Prosecution is not interested in coming up either in appeal, revision, petition, writ petition before this honorable court. 2 prosecution witnesses are before this court. They want to take up the cause of this witness PW 14, who came to be impeached during the course of the his cross-examination by placing on record certain
That's on
documents.
merit.
That would be on the merits of the matter. How are these victims concerned with PW 14 producing these 2 documents? How did they secure these 2 documents? Well, that is all again a matter of evidence. He is not the victim. He is not the first informant. He is only a prosecution witness because he comes to Bangalore, takes them to Chitradurga. From Chitradurga, he takes them to Mysore and brings them back. That's a different thing.
I myself passed the order.
Yes, your lordship has passed
Facts
the order.
I'm aware.
But his evidence came to be impeached by producing certain documents. He is a most unreliable, untrustworthy witness, or he is a liar. That's all to that extent. Now, my lord, accused giving him compliments, my lord, will in no way further the case of the prosecution to come to a just decision in the matter. The order which came to be passed by the Lawrence trial judge certainly does not call for an interference in the hands of this honorable court, would be my respectful submission.
Judgment is
Supreme Court. Sapan Kumar's case. Your lordship has referred to it in my lord's judgment.
Yes.
Manju Devi.
Well, paragraph
That's to be referred to.
10 and onwards. Unless and until it is necessary for the just decision, you can't do it. And though that too after much water has flown, after examining 44 witnesses subsequent to his examination and cross-examination, he would open his eyes. When the statement of the accused came to be recorded, in their statement they would pinpoint that he is the root cause for that. Probably to cover up that matter.
Judgment.
Mark, my lord. maybe-
ಬರಲ್ಲ ಕೊಡಿ. Don't worry about all that.
Lord, kindly page
ಎಲ್ಲ
11, my lord.
ಎಲ್ಲವೂ ಹಳೆದೆ.
Yes.
2025 we will give you.
ಎಲ್ಲ.
Yes.
Page 11, your lordship, in page 11, paragraph 10, my lord, it is.
Hmm.
Manju Devi's case,
Yes, yes.
it needs hardly any emphasis that the discretionary powers like those under section 311 CRPC are essentially intended to ensure that every necessary and appropriate measure is to be taken by the court to keep the record straight and to clear any ambiguity insofar as evidence is concerned. My lord, kindly see, my lord, that to support this, my lord, paper book evidence, my lord, your lordship, kindly page 89, my lord, petition it is. Page 89, my lord, in the evidence it is. 2013ರಲ್ಲಿ ಮುರುಘಾ ಮಠದ ಹಣವನ್ನು ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ ಎಂದು ಬೆಂಗಳೂರಿನ ಎಂಎಲ್ಎ ಮತ್ತು ಎಂಪಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸ್ಪೆಷಲ್ ಸಿಸಿ ನಂಬರ್ 279/2017 ಕೇಸ್ ದಾಖಲಾಗಿತ್ತು ಎಂದರೆ ಸರಿ, ಸಾಕ್ಷಿಯು ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ನಿರ್ದೋಷಿ ಎಂದು ಆದೇಶವಾಗಿದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಸದರಿ ಪ್ರಕರಣದ ದೋಷವನ್ನು ಪಟ್ಟಿ ನೋಡಿ ಗುರುತಿಸಿದ್ದು ಅದನ್ನು ನಿಶಾನಿ D28 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. In same case, these two letters were marked as exhibit D3 and D4.
Notwithstanding that, charge sheet is filed.
Charge sheet filed, my lord, during trial, my lord, this exhibit
These documents are marked.
But these documents were marked on behalf of PDL-14 as an
Then,
accused.
notwithstanding the charge sheet being filed, you wanted to mark these
Well,
documents.
these
They
are
are
the-
marked as D3 and D4 there.
D4, my lord, they want to, my lord, complete record has to come on record. That's all it is. My lord, not a filling of document. When they got marked the very charge sheet itself, my lord, these defense documents which were marked as D3 and D4, to be for better appreciation, my lord, it should be placed on record.
ಅಷ್ಟೇ ಅಲ್ಲ?
And my lord, in respect of this delay, my lord, we have not caused any delay, not even a moment. 10/7, my lord, is the date of recording statement. Kindly, my lord, that one aspect I bring to your lordship's kind notice. My lord, a 313 statement, my lord, we have produced, your lordship, kindly one sentence it is.
What is his locus is a question.
No, that is the stand of the accused. ನೀವು
Prosecution
ನಿಮ್ಮ
doesn't cover.
ದುರ್ನಡತೆಯನ್ನು ನೋಡಿ ನಿಮ್ಮನ್ನ ಕೆಲಸದಿಂದ ತೆಗೆದಿವೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Prosecution is
Prosecution only it is the case of prosecution only.
ಅವರು ಸೈಲೆಂಟ್ ಆಗಿದ್ದಾರೆ.
Yeah.
Prosecution is shooting from the
it
victim's
is
shoulder.
My lord, here your lordship may kindly see, application, my lord, application is that the prosecution, it is not of the victim. My lord, prosecution is also there on record, no doubt about it. They are not, my lord, that sailing with the accused. It is their application.
How can they say anything?
They can't say, my lord, that it is the
I'm not saying
application.
they are
of
sailing with the accused. Yes.
My lord, now law is settled, my lord, that in Jagdish Singh case, victims also have a, my lord, locus standi
No
to
problem.
agitate it.
I am not saying
They are
anything.
only challenging,
Yes.
my lord, the order is not correct, please correct it. They have no self-interest in all that. It is not PW-14 who has come. It is the victim's petition it is.
Yes.
My lord, in 313 statement, only one sentence, my lord. kindly.
Yes, sir.
Page 49, my lord. Page 49, my lord. Kannada 313 statement, my lord, it was filed. ಹೀಗೆ ಮಠದಿಂದ ನಂತರದ ದಿನಗಳಲ್ಲಿ ಮಠದ ಆಸ್ತಿ ಮತ್ತಿತರ ಸೊತ್ತುಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ಕಬಳಿಸಿದ್ದರಿಂದ ಮಠದ ಪರವಾಗಿ ಆತನ ವಿರುದ್ಧವಾಗಿ ನಾನು ಹಲವಾರು ದಾವೆ ಮೊಕದ್ದಮೆಗಳನ್ನು ಮಾಡಿದ್ದನು. ಈತನ ಅಕ್ರಮ ಅವ್ಯವಹಾರ ಮತ್ತು ಮೀರಿದ್ದು ಪತ್ರಿಕೆಗಳಲ್ಲಿ ವ್ಯವಹಾರ ಪ್ರಸ್ತಾಪವಾಗಿದ್ದು ಆತನ ನನ್ನ ವಿರುದ್ಧ ಹಲವಾರು ಪ್ರಕರಣಗಳನ್ನು ಹೂಡಿದ್ದು ನನ್ನ ವಿರುದ್ಧ ವೈರತ್ವವನ್ನು ಸಾಧಿಸುತ್ತಿದ್ದನು. My lord, this is, and because of this reason, my lord, that page 51 also, ನಾನು ಮಠದಲ್ಲಿ ಇಲ್ಲದೆ ಇರುವ ಸಂದರ್ಭದಲ್ಲಿ ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಎಸ್ ಕೆ ಬಸವರಾಜನ್ ಮತ್ತು ಸೌಭಾಗ್ಯ ಬಸವರಾಜನ್ ಕೂಡಿಕೊಂಡು ನನ್ನ ವಿರುದ್ಧ ಷಡ್ಯಂತ್ರ ಮಾಡಿದ್ದು, ಇಬ್ಬರು ಮಕ್ಕಳನ್ನು ಬಂದು 1 ತಿಂಗಳಿಂದ ಹೆಚ್ಚು ತಮ್ಮ ಮನೆಯಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಇಟ್ಟುಕೊಂಡಿದ್ದು, ಲಾಯರ್ ಜೊತೆಗೆ ಪ್ರವಾಸ ಹೋಗಿದ್ದು, ಆಸೆ ಆಮಿಷಗಳನ್ನು ಹೂಡಿ ಅವರನ್ನು ಸಾಕ್ಷಿಗಳು ಮಾಡ್ತಾರೆ. This is the defense, my lord, that this.
Yes, we'll pass out to say 230.
One more. PW-14 himself is not before this court. Prosecution is not before this court. Well, under section 313, whatever I say has got to be accepted as unrebutted evidence in the case is a settled legal position. But he wants to overcome my statement by saying that he is the one who is responsible for this litigation against me by producing these documents.
No, the first question I asked was that whether encomiums are given to PW14 or not. Why are you worried?
Lord, here
Oh,
the
it will
credibility,
further
my
the
lord,
case of the
that
prosecution against me to make out an offense
credibility of
against me under
PW14 being
section
attacked,
376.
my lord, he is a prosecution witness, your lordship. He is a prosecution witness and the main witness he is not an ordinary witness.
Who is seeking his recall?
Well, prosecution is seeking recall.
All right, that is dismissed.
Prosecution is seeking recall.
Yes, that is dismissed. They are not before this court. They are happy with the order.
Victims also can challenge the order against the prosecution.
Yes.
Well, any order which goes against the prosecution, victim also can challenge.
All right.
Well, section 40 of the POCSO Act, well, gives an authority for the victim.
I'm not on that. We'll answer strictly within the contours of 311. Yes.
Well, it is necessary.
Is it necessary for a just decision?
Just decision of the case.
Ashta section
Well, what the
313
Supreme Court says, my lord,
311.
to put the record straight and complete. If it is necessary for better appreciation, well, these two documents, well, it will not affect them if it is so.
230
Please,
I will declare at 230.
All
So it is his suggestion that his claim is that he is responsible. If he produces this document, accused will not have any, don't have any objection for this.
Well, Lord, for better appreciation and understandable manner, these two letters are required. They are the continuity of that document.
Right, 230.
Please.
20.
Both 18, 19, ಎರಡು ಅದೇ ಅಲ್ಲ?
Yes, yes.
Same.
My lords, the first appellate court.
ಒಂದು ನಿಮಿಷ ಸುಶಾಲ್. ಇದು
Yes, my lords. My lords, the first appellate court, my lords, has rejected my amendment
ಏನಿದು?
application.
A failed vacating application.
Rejection of 6-17 application.
Yes, my lords.
In appeal.
RAL.
Yes, my lords. My lords, appellant.
ಬ್ಯಾಟ್ರಿ ಹಿಯರ್ ಒಬ್ರೇ ಇದ್ದೀರಾ? Yes.
My lords, appellant number 2 and 3, my lords, they filed an amendment application that came to be allowed. Appellant number 1, my lords, files an amendment application on very similar grounds, my lords, because there has been a division in the family. The first appellate court, my lords, rejects
Suit
my
for
application.
partition.
Suit for partition. I
What?
suffer a decree, my lords.
You suffer a
I did
decree.
suffer a decree. However, my lords, I was not contesting the matter because my brothers were contesting the matter. My brothers, my lords, challenged the order before the first appellate court. While the petition was pending, my lords, while the appeal was pending, they transposed themselves as respondent, my lords, and they let go of the appeal. My lords, my lords, who had no written statement on record, become an appellant number 1. However, my lords, appellant number 2 also, my lords, files an amendment. That has been allowed. My lords, my application for amendment, my lords, has been rejected. I say, my
Now,
lords,
which is the amendment that is allowed?
allowed, my lords, just at page 121, annexed to H.
121.
Yes, my lords.
Filed by the appellant.
Appellant number 2 and 3.
You are appellant number 1.
1.
Which page?
121, my lords. Annexed to H.
You have no objection for this. ಇದಕ್ಕೇನು objection ಇರ್ಲಿಲ್ವಾ? Huh?
It has been allowed.
Appellant 1 and 2 ಯಾರು? 2 and 3 ಯಾರು?
Different advocates.
Advocates ಬೇರೆ sir. Appellant 2 and 3 ಯಾರು?
No, they are responding with 31 and 32, my lords. Process has been
They
given.
are brothers.
They are brothers, all are family
All
members.
family
All
members.
family members.
ಅವ್ರಿಬ್ಬರದ್ದು ಮಾಡಿದ್ರೆ ಇವ್ರದ್ದು ಮಾಡೋದು ಏನ್ ಪ್ರಾಬ್ಲಮ್?
Let that be
ಅದು
allowed.
appellate stage ಅಲ್ಲೇ ಆಗಿರೋದು.
In this case, my lordships, Annexure J is the application of the petitioners, my lordships. Annexure J, what they want to amend, they want to amend the regular appeal, my lords.
Regular appeal amendment. Appeal, yes.
139, page number 139.
Yes. ಈಗ ಅವರಿಬ್ಬರದ್ದು ಏನಾಗಿದ್ದು amendment?
That got allowed, my lords.
2 and 3 ಅದು regular appeal amendment ಏನಾ?
Yes, my lords.
Yes sir. Anything else?
I would
sir?
like to place a judgment of the trial court.
What sir?
But
ಈಗ ಇರೋದು 617 before the appeal.
few points.
Judgment ಅಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, the proposed amendment, the amendments of the proposed amendment was already answered by the trial court.
ಅಲ್ಲಿ ಹಾಕಿದ್ರ ಇದು?
ಅಲ್ಲ, ಇದೇ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದು, ಅದೇ ಡಿಫೆನ್ಸ್ ಅನ್ನು ಮತ್ತೆ ಇವ್ರು ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ.
That, my lords, have been let go on.
Kindly peruse
Kindly look at the judgment.
similar facts, my lordships. Oral partition 1989, mutation, ಈ ತರ ಆಗಿರೋದ್ರಿಂದ ಡಿವಿಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು that was
Suit for
motivated by
partition.
the trial court.
Not suit for partition was filed by one of the legal error of one proposed it as Kenchappa.
The present petitioners, my lord, before my lord, they are the wife and children of defendant number 4. Kindly peruse page number 2 of the judgment.
Yes.
Defendant number 4, my lord, B.V. Ashok. Of the judgment of the trial court.
Page?
Page 2, my lord. Page 2 of the judgment. Just now I furnished, my lord.
Yes, sir, ಅದನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
B.V. Ashok, my lord. Kindly peruse page number 5, my lord. Cause title. Cause title of the judge. He files wakalat through advocate, my lord. During the pendency of the trial court proceedings, my lord, he dies. Later on, my lord, these petitioners were brought on record through an advocate, my lord. They filed wakalat, but they have not filed any return statement during the proceedings of trial court, my lord. In OS.
ಕೋರ್ಟ್ಲೆ ಆಗಿತ್ತಾ?
Alagitto. Now, during the pendency of appeal, my lord, in order to fill up those lacunas, they filed 6/17 application. That application runs into 12 pages, my lord. In order to fill up those lacunas, my lord, regarding oral partition, that has been negativated before the trial by the trial court through issue number 1, my lord. That is at page number. I should kindly see page number 14 of the judgment.
Where is the application?
Application is at, my lord, annexure J.
139, my lord.
139.
No, the other two applicants, appellant 2 and 3.
Please.
Our application ಯಾವ್ದು?
Our application is on different grounds, my lordship. This application is the ground on which the trial court has already adjudicated the issue in controversy, my lordship. The
Issue
similar
number 1
set
is in
of
respect of oral partition, my lord.
similar set
That has
of
been
facts-
negativated in.
So this is
page number
139 to 153 amendment application. huh?
ಹೌದು.
similar set of facts which has been
Oral
answered to the
partition,
trial
para
court.
number 1, that has been negativated by the trial court itself.
The petitioner.
Now
came-
they wanted to bring the same set of facts by way of 6/17 in order to fill up those lacunas, my lord, since they have not filed return statement.
I'll say.
Under Article 41 rule 2, my lordship, they can add those grounds before the first appellate court.
May I say this? my
Yes,
lord?
sir.
May I say this? Because I, my lord, did not file written statement before trial court. Different number 2 and 3 filed it, my lords.
You did
my
not
lords,
file?
Yes, my lord, I have not filed. I was sailing with them. Because these different number 2, my lords, had originally challenged the decree. They transposed themselves as defendants respondent, my lords, in the appeal, and they let go of the decree, my lords. So, my lords, the only one surviving to challenge the decree is me, my lords, where I have brought in additional grounds. I have, my lords, brought in 3 additional grounds and 2 set of facts, saying that the contention taken in the original suit is why I have to bring forth, my lords. That is all I have done. Otherwise, my lords, the entire appeal becomes infructuous today.
Lord, may kindly see page number 39 of the appeal, petition, my
See,
lord.
we'll have to answer whether it should be permitted or not.
No, page number 39, my lord.
Yes,
Kindly.
sir, should.
Return statement act la trial court.
ನೀವ್ ಯಾರಿಗೆ?
23.
They are the ones who are transposed as respondent number 2 and 3. They are
I
sailing
I
was
was
on the
sailing
same
with
boat.
my brother, my lords. I was
They are
sailing
sailing
with
on
my
the same
brother.
boat.
Good for partition.
Yes, my
ತಾನೆ.
lords.
Respond number 2, 3, 5, 6, and 7.
Hmm.
We have filed the wakalat.
Very good. ಆಮೇಲೆ?
Filed a deep objection, madam.
I am for,
ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಇವಾಗ್ಲೇ we have filed.
I am for respondent.
Vacating stay ಹಾಕಿರೋದು ಯಾರು?
I am for respondent plaintiff number 1, my lordship. I filed application for vacating the interim order, my lordship.
We'll see. This
Lord,
has to
kindly
be-
peruse, my lord.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ
One
ಸ್ವಾಮಿ?
submission,
Kindly
one.
peruse, my lordship. I have also produced document before this honorable court. Now they are developing the.
Friday.
ಅಲ್ಲಲ್ಲ, developing one of the scheduled property, my lordship. ಇದ್ರಲ್ಲಿ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ. ನಾಳೆಗೆ ಅಂತಾರೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಬಂದ್ರೆ ಮತ್ತೆ ಇದಾಗ್ತಾ ಇಲ್ಲ. ಮೈ ಅಪ್ಲಿಕೇಶನ್
First list ಅಲ್ಲೇ ಬರುತ್ತೆ Friday.
ಅಲ್ಲ.
Yes.
ಹಂಗಿದ್ರು.
Reasonings of the trial court may be kindly seen at page number 39, my lord.
List on Friday.
Not this Friday, next Friday, my lords.
Petition copy ಕೊಡಿ.
I'll do it, my
Filed a
lords.
deep objection.
I'll file it, my lords. They came on
I
wakalat
will not,
yesterday.
there is already a vacating stay. We will not wait for your detailed objections here.
19th, my lords.
No,
No, this,
12th.
No, this, my lords, 12th, my lords, my lords, are CCI matter, my lords.
So what? Half day ಅಷ್ಟೇ ಅದು.
Because I am not.
2:30 ಗೆ ತಗೊಂತೀನಿ.
Because I am not here in Bangalore on 19th. My lords, Friday, my lord. Next Friday, Monday, my lords.
No.
It was
Monday
19th.
ಅಷ್ಟೇ. Monday. No adjournment.
No.
Monday.
But my memo may kindly be taken on record, my memo.
Learned
Filed by
counsel,
respondent number 15.
Learned counsel Chetan A representing the respondent.
15 to 21.
Respondents 15 to 21 files a memo along with documents. The same is taken on record.
Yes.
This is an interim order, my lords.
Interim order subsisting will continue till the next date of hearing.
Monday.
21.
Memo for dismissal. ಯಾರು ಹಾಕಿರ ಮೆಮೋ ಫಾರ್ ನೀವೇನಾ?
In order to facilitate an application for withdrawal of suit, then since there is a
The
stay
learned
not
counsel for the petitioner files a memo seeking dismissal of the petition. The memo reads as follows. Elli memo. ಹಾಕಿದಾರೆ madam? Memo. Memo reads as follows. In the light of the said memo, the petition is disposed as withdrawn.
Please.
Yes.
22.
Post immediately after service of notice upon respondent.
It is
Interim
served on 8 minutes. I undertake to come on
learned
record.
counsel, Srimati Sridevi Bhosle accepts notice for respondent.
Plus 2.
Only respond.
Only respondent. Register to print the name of so and so. List after 2 weeks. Interim order there.
ಇಲ್ಲ.
Yes.
Next week.
List on 22nd.
Please.
Of less.
Next.
23.
A week's time is granted to do the needful.
My lords, one, because my lords, in
2
this
to 6
matter,
yaru.
it was not at all heard, my lords, no notice has been issued in this matter. On the last occasion, my lords directed, no notice, because it was not at all heard. So
How
that's
that's not at all heard? ಏನಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Yes, my
Interim
lords,
order
because
ಇದೆಯಾ?
no notice has been ordered in this matter, because I appeared through caveat and
Okay.
they sought for more than 25 times date, my lords, in this matter.
25 times data.
Yes, my lords.
ಕೊಡಿ ಏನಿದೆ? What's the matter, sir?
Senior counsel engage ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
Huh?
I'm the proxy counsel, senior counsel.
Proxy counsel. The proxy counsel representing the petitioner seeks time. List the matter after a week.
That's on Monday, date may be given. So on Monday, my lords.
Proxy counsel ಗೆ interim order action ಮಾಡಲ್ಲ ನಾವು.
ಅಲ್ಲ, interim order ಏನು ಕೊಟ್ಟಿಲ್ಲ ತಾವು ಅದ್ರಲ್ಲಿ.
ಹೌದಾ? ಸರಿ
There is no
ಬಿಡಿ.
interim order
ಮತ್ತೆ
because-
ಯಾಕೆ?
My lords, Monday it came,
Why?
because it reached up to Supreme Court, my lords, that's already attained finality in this matter.
ಆಯ್ತು ಸರ್, let's see.
Monday, my lords.
Not Monday. List next week ಅಷ್ಟೇ.
ಇಲ್ಲ, ನೀವು ಡೇಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಬರಲ್ಲ, ಸೊ
ಮೂವ್ ಮಾಡಿರೋದು ಯಾರು?
ಐ ಆಮ್ ನಾಟ್ ಮೂಡ್.
ಮತ್ತೆ ಅವರೇ ಮೂವ್ ಮಾಡ್ರಿ. ಮಾಡ್ತಾರೆ ಬಿಡಿ.
24.
ಸರ್, ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ, ಎನಿ ಕನ್ವೀನಿಯಂಟ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್.
Yes, next.
24.
Served the respondents, my lord, appearing before the.
Learned counsel so and so undertakes to enter appearance for respondents.
R3.
The third respondent.
R1 and 2 also I served, my lord. I filed a
Counsel for the petitioner submits that the needful has been done. Office to verify interim order subsisting would continue till the next date of hearing. Next.
a memo has already been filed, my lord, on 8th.
All right, yes, next.
25.
For respondents matter.
Learned counsel so and so undertakes to enter. ಹಾಕಿದ್ದೀರಾ ವಕಾಲತ್? Learned counsel submits that he has entered appearance for the respondent registry to print the name of so and so as appearing for the respondent.
And someone serve ಆಗಿದೆ ಸ್ವಾಮಿ.
Copies
Memo
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Petitioner to serve set of papers upon the aforesaid counsel. ಆಯ್ತಲ್ಲ, ಬಂದಿದಾರಲ್ಲ.
ಆಗ್ಬೋದು.
So and so. Interim order ಇದೆಯಾ?
Yes,
ಇಲ್ಲ,
my lords.
interim
Interim order may be
ಇಲ್ವಾ?
Interim order ಇದೆ sir.
List after 2 weeks, yes.
Yes, my lords.
Interim ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
Interim ಮಾಡಿಲ್ಲ. Set of copies not served, my lord.
ಕೊಡಿ ಕಾಪಿ, yes.
26.
Response 1, 2, 5, 7.
Compromise petition has been filed by playing fraud and misrepresentation on the sisters. You may kindly see the brothers have taken the 2 acres of property.
Project fraud in the compromise decree so arrived.
And only 30-40 has been given to the
Yes,
sister.
sir.
So that the inquiry was held, my lord, that of course, that an application filed before the trial court.
Correct.
The inquiry was held, that it is held that there is no fraud has been.
ಲೋಕ ಅದಾಲತ್ತ ಏನು?
Lok Adalat, National Lok Adalat ಇದೆ. But earlier they filed an original suit challenging the very same compromise order that it was rejected after filing an application order 7 rule 11.
Same
And there-
order?
the
Where
same
is
order.
that order?
The same order that
Where is that?
I will place, my lord, that all the
No,
orders.
no suit
The
has
learned
been filed.
counsel appearing for the respondent submits that on the very same cause of action of the compromise vitiated by fraud was projected in a suit filed subsequent to the said compromise. The learned counsel submits that the respondent defendants therein had filed an application under Order 7 Rule 11 CPC. Accepting the said application, the suit has been rejected. Therefore, the contention that the compromise being vitiated on account of fraud has already been adjudicated upon and is dismissed, he would submit that he would file.
Statement of objections, it is already stated, my lord, I will paste the record. It's OS
ಹೇಳಿದ್ದೀರಾ already?
986 in statement of objections to
I
filed
would
to the
seek time
application.
to place those orders on record. List the matter on 17th in preliminary hearing.
Please.
Yes. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ,
There is
interim
no
ಮಾಡು.
entry.
Next.
27.
Oh, 2 weeks time to do the needful. Next. Post immediately after service of notice upon the second respondent.
29.
28 lordship.
Post immediately after.
ಅಲ್ಲ
ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಇದು ನಮ್ಗೆ ಚೇತನ್ ಎಸಿ ಬದಲ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ NOC ಬೇಕಲ್ಲ.
The learned counsel so and so submits that his entered appearance in place of Chetan AC for the first respondent. Registry to print the name of so and so is appearing for the first respondent. Post immediately after service of notice upon the second respondent.
But
Next.
first respondent is already on record, my lord, since long
Sure.
time.
No, I filed NOC.
If he has filed NOC ವಕಾಲತ್.
ಅದನ್ನೇ ಹೇಳಿದ್ದೆ ಈಗ ನಾನು. Yes. Next.
Sale number 29, ma'am.
29.
29. 1 week time to take up. In the meantime, kindly pass an interim order. to
Pass
stay.
an interim order.
Yeah.
Yes. First do your job, sir. Yes.
What happened? The last date of hearing, since I could not find traffic jam, sale number 9 was
You could
there.
not traffic jam.
I could not. I came from the Law Brothers. So I filed on IF number 4, seeking permission to file written statement. It has been rejected. And the appellate of all documents stands in my name.
Learned counsel with the petitioner seeks a week's time to do the needful. Needful be done by the next week. Interim order subsisting would continue to the next date of hearing. Yes.
30.
2 weeks to do the needful. Next.
31.
R2 and R3's vendor is not respond number 4, who is not served. If already in R2 and R3 Chandrasekhar represents.
I appear for R2 and R3.
I appear for R1.
R4 ಬರ್ಲಿ. ತಗೊಂತೀರಾ?
ಅಲ್ಲ ಈಗ ಈಸ್ ಅವರ್ ವೆಂಡರ್, ಅವರು ಊರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ನಾನು ಇದೇನೋ ಇವತ್ತು ಬಂದಿದ್ದಾರೆ.
ಆಯ್ತು ಸರ್.
ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಸರ್.
I am for R1. I already filed for application for vacating interim order. Put up ಆಗಿಲ್ಲ sir.
ಹಾಕಿದ್ದೀರಾ? Suit for?
Suit for permanent injunction. Permanent injunction.
ಆಯ್ತು. List on 17th. Registry to put up the application so filed by the respondent seeking vacation of the interim order.
17th I am going abroad. 16th.
ಓ ಮುಗಿಸ್ಕೊಂಡೇ ಹೋಗ್ಬೇಕಾ? ಬಂದ್ಮೇಲೆ ಮಾಡೋಣ ಬಿಡಿ.
ಆಮೇಲೆ ಆದ್ರೂ ಆಯ್ತು ಸರ್. ಅದಕ್ಕೆ 17th ಬೇಡ ಸರ್.
ಅಲ್ಲ, ಊರಿಗೆ
ಯಾವಾಗ ಬರ್ತಾ ಇದ್ದೀರಾ ವಾಪಸ್?
ಡಿಲೇ ಮಾಡಿದಷ್ಟು ಒಳ್ಳೇದು.
ನಾನು
ನಮಗೆ ಐ ಆಮ್ ದಿ ಸಫರರ್.
ಸ್ವಾಮಿ, I am today itself I am ready. If you let my learner.
Yes, I am also ready.
I am also ready.
I am also ready.
I have filed application but put up ಆಗಿಲ್ಲ.
ಇದು plaintiff and defendant ಏನ್?
ಸ್ವಾಮಿ,
I am for first respondent.
ಈಗ ಇವರು ಪ್ಲೇಂಟಿಫ್, ನಾನು ಡಿಫೆಂಡೆಂಟ್ 1 and 2, ಅವರು ಡಿಫೆಂಡೆಂಟ್ 4, ಡಿಫೆಂಡೆಂಟ್ 3 ಮೈ ವೆಂಡರ್, ಅವ್ರು ಬರ್ಬೇಕಾಗಿದೆ. ಈಗ ನಾನ್ ಸಫರ್ ಮಾಡ್ತಿದ್ದೀನಿ, ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಹಾಕಿದ್ದೀನಿ. ಆನ್ ದಿ ಡೇಟ್ ವೆನ್ ಈ ಫೈಲ್ ದಿ ಸೂಟ್ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಹಾಕಿದ್ವಿ. ಇಲ್ಲಿ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಯ್ತು. IA1 ಫಾರ್ ಇದು TI. ಇಲ್ಲಿಗೆ ಬಂದ್ರು, ಇಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡ್ರು. ಸ್ಟೇ ಏನಾಯ್ತು, ನೀವು ಫರ್ದರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಮಾಡಬೇಡಿ ಅಂದ್ರು. 8 ವರ್ಷ 9 ವರ್ಷದಿಂದ ಇದಿದೆ. ಈಗ ನನಗೆ
9 ವರ್ಷ ಸ್ಟೇ ಇದೆ.
9 ವರ್ಷದಿಂದ ಇದೆ ಸ್ವಾಮಿ. ಅಲ್ಲ ಇಲ್ಲಲ್ಲ, ಅಲ್ಲಿ ಅಲ್ಲಿ ಅಲ್ಲಿ
ಅವಕಾಶ ಕೊಡಿ ಸ್ವಾಮಿ, ಹೇಳ್ತೀನಿ.
MFA ಆಮೇಲೆ ಒಂದು ಇದು ಏನೋ ರಿಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಇವರೇನೇನೆ. ಈ ಸಾರಿ ಸೊಸೈಟಿ ಅವ್ರು ಬಂದಿದ್ದಾರೆ ತಮ್ಮ ಮುಂದೆ.
ಈಗ ನಿಮ್ಮ ಸೊಸೈಟಿ ಅವರೇ ಬಂದಿಲ್ಲ. ಪಿಟಿಷನರ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಅಬ್ಸೆಂಟ್. He was also absent. Today also absent.
He is present today, sir.
He is not petitioner.
Oh, vendor is the petitioner.
Yeah. Society vendor is the petitioner. Last time also he himself has taken a interim order.
ಆಯ್ತು, ಈಗ ಅವ್ರ ವಕಾಲತ್ ಹಾಕ್ತೀರಾ?
ಯಾರು ಸ್ವಾಮಿ?
ಅದು R3 ಗೆ.
R4 ಗೆ ನಾನು ಬೇರೆಯವ್ರು ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ. ಯಾರೋ ಒಬ್ರು ಸುನಿಲ್ ಶಾಸ್ತ್ರಿ ಅಂತ ಅವ್ರಿಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರು. ಅವ್ರು ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ. ಒಂದು ಇದೇನೋ 10 days ಟೈಮ್ ಕೊಡಿ. 24th or 23rd ತಾವು ಹಾಕಿದ್ರೆ ವೆರಿ ಅರ್ಜೆಂಟ್.
16th ಹಾಕೊಂಡ್ರೆ 17th I am going up.
ಬರೋದು ಯಾವಾಗ?
ಬರೋದು 2 months ಆಗುತ್ತೆ. So 1.5 months ಆಗುತ್ತೆ.
1.5 months.
ಅಲ್ಲಿಗೆ ನಮ್ ಕತೆ ಮುಗಿಯುತ್ತೆ.
ಅದಕ್ಕೆ 16th when day after tomorrow ಹಾಕೊಂಡ್ರೆ I am ready. Day after tomorrow ಹಾಕೊಂಡ್ರೆ I am ready.
ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
USA ಹೋಗ್ತಾ ಇದ್ದೀನಿ.
ಅಷ್ಟೇನಾ?
ಹಾಕಿ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು ಅವ್ರು ಹೇಳಿದಾಗೆ ನಿನ್ನೆ 17,
Before-
18 ಹಾಕಿ ಸ್ವಾಮಿ.
16th,
16. Put up ಆಗ್ಲಿ ಸ್ವಾಮಿ ನಾನು vacating IA.
along with the vacating application.
IOB extended.
Interim order stand section.
ಅಲ್ಲ,
Case-
how can they ask for interim extended? Petitioner has filed a petition. He has taken response. How can they seek now?
Interim order ಅವ್ರ ಪರವಾಗಿ ಇರೋದು.
Society is the petitioner.
ನೀವು ಇನ್ನು
Society is the petitioner.
ನಿಮಿಷ ಸರ್, ಅವ್ರು ಅಬ್ರಾಡ್ ಹೋಗೋ ಇದ್ರಲ್ಲಿ ಇದ್ದಾರೆ, ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ ನಾನ್ ರೆಡಿ ಇದ್ದೀನಿ.
ಸರಿ, ನೀವು 16th ಏನಾದ್ರು ತೊಂದ್ರೆ ಆದ್ರೆ ಹೋಗಲ್ವಾ?
16th
ಕೇಸಲ್ಲಿ ತೊಂದ್ರೆ ಆದ್ರೆ ಹೋಗಲ್ವಾ?
17th night ಹೋಗೋದು ಸ್ವಾಮಿ.
ಆಯ್ತು
17th midnight. Ticket is booked.
ಆಯ್ತು 16th
16th.
ಡೇ ಟೈಮ್ ಅಲ್ಲೇ ತಗೊಂಬ 16.
32.
Memo for disposal.
Look, since pleadings were complete, no, we filed a memo for disposal.
What should I, ಹೊಸದೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? What is the issue?
No, I file a suit for partition in separate possession. I include 5 properties in the plaint. Thereafter, I come to know that
ಇಲ್ಲಿ
one of-
ಬಂದಿರೋದು ಯಾಕೆ ಕೋರ್ಟಿಗೆ?
ಇವಾಗ my amendment application for omission of one item number, I filed
Why do you want to omit a suit
because
schedule
the
property
item
in
number that I
partition?
seek omission is not a joint family property. It is a self-acquired property.
Court will decide that.
I seek omission of it. It is rejected on the ground that partial partition is not permissible.
Now, court will decide that later.
I can prove that it is self-acquired.
ಇಲ್ಲಿ ಪ್ರೂವ್ ಅಲ್ಲ ಸರ್, ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು.
Correct. Your lordship may see.
ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದೀರಾ ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್.
Your lordship may see.
We'll dispose it now.
That is a subject matter of counterclaim also.
No,
The only ground on which I seek your lordship's indulgence is they have to file a separate suit, or they have to file a counterclaim. A separate suit.
Counterclaim ಹಾಕಿಲ್ವಾ?
ಅಲ್ಲ,
Okay,
Lords,
that
not only
application
that,
is
they've
pending.
also filed another suit. In that suit, Lords, item number 2 is included. Lords, I am the dominus litis in my suit. Lords, I seek omission of one item number in 5. Lords, another suit is already filed seeking partition of item number 2. Another suit is filed.
They have filed one suit. Another dot has filed another suit where this property which is ought to be now excluded is item number 3. We have filed also a counterclaim where we are also seeking share in this property. The issue is this, my lords. Plaintiff files suit for partition with respect to 6 items. Suit item number 3 was in the name of another person inadvertently. He mischievously enters into a sale deed with that person and he enters into a gift deed in favor of his wife. That is the reason he wants to exclude this property now.
Lords,
That will
another
see. Court
suit,
will decide.
Lords, another suit is filed
We
seeking
will not,
partition. Lords,
ಅದೆಲ್ಲ court will decide all that is suit schedule property ಇದ್ದ ತಕ್ಷಣ it won't be partition.
Lords,
You
if
can
Lords,
always prove it that it is your self-acquired
is
property there.
available for partition, Lords, they can do it in their suit. Lords, in my suit, Lords, I see commission because it is self-acquired. It is not joint family property. Lords,
ನಿಮ್
only
suit partition ಗೆ ಅಲ್ವಾ?
Nam suit partition, there are 5 item numbers, Lords, one is not a part of the joint family property.
ಅಲ್ಲ,
And my lords,
court- court will decide, sir.
Lords, the property which they seek partition of, they've already filed another suit. And it's
ಎರಡು
also
suit
club.
partition ಗೆ ಯಾಕೆ ಅಂತ?
One is filed by a brother who is represented by the petitioner. Another was filed by one of my sisters. In fact,
ಎಲ್ಲಾದ್ರಲ್ಲೂ this suit, the same property is
ಕ್ಲಬ್
there?
ಆಗಿದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಕ್ಲಬ್ ಆಗಿದೆ. ಅವ್ರನ್ನೆಲ್ಲ
Suits club ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ಕ್ಲಬ್ ಆಗಿದೆ.
Then court will decide.
In fact, he
The
sought for
petitioner is before this court seeking the following prayer. The heard so and so. The petitioner is the plaintiff in
OS number
OS
162 of
OS 162 of 2016 filed for partition and separate possession. The issue in the list is not with regard to the merit of the claim or the defense of the respondent. In the said suit, the petitioner files an application under Order 6 Rule 17 seeking omission of a particular property, a particular suit schedule property, i.e. item number 2. The application so filed comes to be rejected, rejection of which has driven the petitioner to this court in the subject petition. The learned counsel Sriraj Gowda, appearing for the petitioner, would vehemently contend that there are two separate suits filed by the brothers. Both ಎರಡು partition,
Both partition.
both for the purpose of seeking partition and separate possession. The suits, in the said suit, the very same property is the suit schedule property. The learned counsel would submit that it cannot be a joint family property. It is a self-acquired property of the present petitioner, and therefore it cannot be in the list of joint family properties that would be partitioned. The learned counsel appearing for the respondent submits that the application is rightly rejected, as in a suit for partition, all the joint family properties should be bought in unless it is proved otherwise by way of evidence. The other suits that are pending, the learned counsel would submit that the court, there is already clubbing of suits and the suits are being taken up together. In that, I have given my so and so. The aforesaid narrated facts are a matter of record. The concerned court rejects the application filed by the petitioner seeking omission of item number 2 in the suit schedule property by the following order. Page
15.
18 to 21 reasons are. Yes. The learned counsel for the petitioner, as contained by the learned counsel for the respondent, that all suits are taken up together and are clubbed and being heard together, would be a circumstance that the petitioner will have to prove the contention that he is now advancing in the application or before this court, that it is not a joint family property but a self-acquired property. This undoubtedly would require evidence. It is not for this court to enter into evidence as to whether the petitioner is holding the subject property, item number 2, is a joint family property or a self-acquired property, leaving open all the contentions, finding no merit in the petition or error in the order that is impugned. Petition stands disposed. All contentions remain open to be urged before the concerned court. Next.
33,
Withdrawal in terms of, yes.
34,
The respondent in this case, my lord, I'm filing a memo along with the acknowledgement for having served the IA on the other side. That was the
Vacating stay.
objection raised by the office on the
Bandidya?
IA for vacating.
Application copy bandilva.
ಬಂದಿದೆ.
ಏನು suit for?
ಡೇಟ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್
Suit for?
ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಪಸ್. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು ಆರ್ಡರ್.
ಯಾಕೆ? ಕಾರಣ
annexed B, my lordship. As per the joint memo, my lordship. Settle between the parties.
Settlement ಆಗಿದೆಯಾ?
Joint memo. Annexed B, my lordship.
Undertakes to withdraw OS 116 of
ಅದ್ರ
2000.
ಮೇಲೆ execution ಹಾಕಿರೋದು.
That was not at all acted upon. This was a simultaneous proceedings. According to this joint memo, 23 lakh rupees was said to have been agreed to be paid. Out of that, 3 lakhs is the only amount which they paid. Because this was defaulted, because there was a default on this, I had to approach the trial court and file a criminal miscellaneous petition, which they themselves have produced.
A page. ಈಗ 3 ಲಕ್ಷ ಬಂದಿದ್ಯಾ?
Only 3 lakhs has been paid. So after 6 months, I have filed a criminal miscellaneous petition for recovery of the entire dues. And during the subsistence of this joint memo, no action was taken as far as the suit is concerned. Written statement is also filed. Matter is referred for Lok Adalat. Then after the ex parte decree has been passed, then they come at the stage of execution when the attachment of movable warrant was issued and they seek stay of the proceedings on the ground that there is a joint memo and I had made a undertaking to withdraw the suit.
As per the
they have not
ಈಗ ಅಗ್ರಿ ಆಗಿದ್ದು ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ 23 ಲಕ್ಷ ಅಲ್ವಾ?
23 ಲಕ್ಷ. ಅದರಲ್ಲಿ ಈಗ 11 ಲಕ್ಷ ಕೊಡಬೇಕಾಗಿತ್ತು. ಆಸ್ ಪರ್ ದಿ dishonorable court order dated my lordship in January. 6 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ ಇಂಟರಿಮ್ ಮಾಡಿ ತಗೊಂಡಾಗ ಇನ್ನು 3 ವಾರ ಬಿಟ್ಟು ಇನ್ನು 5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು. ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ?
11 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ.
ಈಗ 3 ಲಕ್ಷ ಅಲ್ದೇನೆ 11 ಲಕ್ಷನಾ?
ಅಲ್ಲ, ಅಷ್ಟೇ 11 ಲಕ್ಷ ಕೊಡಬೇಕಾಗಿತ್ತು. 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ವಿ. ಅದಾದ್ಮೇಲೆ ಮಿಕ್ಕಿದೇನು ಕೊಟ್ಟಿದ್ವಿ. 11 ಲಕ್ಷ ಬಾಕಿ ಇತ್ತು.
ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ. ಜಾಯಿಂಟ್ ಮೆಮೊಲಿ 23 ಲಕ್ಷ ಇದೆ.
23 ಲಕ್ಷ.
ಆ 23 ಲಕ್ಷ
ದಿವಸ 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ವಿ.
ಆಯ್ತು. ಇನ್ನು 20 ಲಕ್ಷ.
20 ಲಕ್ಷದಲ್ಲಿ 11 ಲಕ್ಷನ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ.
11 ಲಕ್ಷ ಮಾಡಿದೀರಾ?
ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ. ಇನ್ನು 9 ಲಕ್ಷ ಕೊಟ್ಟಿದೀವಿ ಆಲ್ರೆಡಿ.
ಎಲ್ಲಿ ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
they have not paid.
ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ. So
I had to knock the
ಅದು ಬೇರೆ ಮಾತು. ಐ ಆಮ್ ವೇಕೇಟಿಂಗ್ ದಿ ಇಂಟ್ರಿಮ್.
ಅದಕ್ಕೂ ನಾನು ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೊಟ್ಟು ನಾಳೆ ಹಾಕಿ ಸ್ವಾಮಿ. ಟುಮಾರೋ
ಈಗ 11 ಲಕ್ಷ ವಿಡ್ರಾ ಮಾಡಿ ಅಲ್ಲಿ. You withdraw that 11 lakhs. You will have a breather. The petitioner is before this court, will not vacate the interim order, but direct. The petitioner is before this court, calling in question proceedings of execution. The foundation of the challenge lies in a joint memo. The joint memo reads as follows. The learned counsel for the petitioner submits that the suit ends in a compromise on filing a joint memo.
Come on, suit is not ended in a
Allah, sorry.
compromise.
A joint memo was filed in
Egmont's
CC,
proceedings.
1 minute. Joint memo was filed in CC 1582 of 2016, in which the complainant undertook to withdraw OS 116 of 2016. The complainant is the respondent here. The learned counsel for the respondent submits that the 23 lakhs that was agreed on in the joint memo was never acted upon by the petitioner, as only 3 lakhs was paid on the same day, after which not even a rupee is paid. The learned counsel for the petitioner submits that pursuant to the orders passed by this court, 11 lakhs is deposited before the concerned court. Would admit that 9 lakhs is yet to be paid. In that light, the respondent respondent is permitted to withdraw the 11 lakhs that is paid that is in deposit before the concerned court.
Execution number 20 of 23, madam.
Before the concerned court in execution 20 of 2023.
Permission. ಅದು ರಿಮೈನಿಂಗ್ 9 lakh ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ವಾ ಅಂತ ನನಗೆ ಪರ್ಫೆಕ್ಟ್ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ, ಅದನ್ನ ಬರೆಯೋದೇ ಇಲ್ಲ ಈಗ.
ಅದನ್ನ ಬರೆಯೋದು ಬೇಡ. 11 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು ಅದನ್ನ
I'll deposit so and so. List the matter on 22nd.
Please.
Further orders would be passed with regard to the remaining amount on the instructions being sought by both the parties as to whether it is paid or not.
Please.
Yes. Much obliged. Next.
35.
I appear on behalf of the
Interim
respondent
order.
number 1.
Subject to the aforesaid, the interim order stands extended.
Appear on behalf of respondent number 1.
35. Learned counsel so and so
I undertake to file.
undertakes to enter appearance for the first respondent. Registry to print the name of so and so is appearing for. Neeve contesting, huh?
Yes, we'll file our
Painting
objection.
1 to 1A to 1E, ಎಲ್ಲರಿಗೂ ನೀವೇ.
Only for respondent number 1.
Oh. Yes.
My lord, the notice.
Partition.
Partition, my lord. My lord, notice to respondent number 6 to 28 may be dispensed.
Memo.
Already filed.
Learned counsel has filed a memo so and so dispensed 6 to 28. Yes. Let the
2
others
weeks time
also
may be granted. My lord.
Huh?
2 weeks time may be granted for us to file.
list the matter on 26th. Objections if any by then.
Great.
Yes, next.
6.
So, Shara.
ಲೋಕದಾಲತ್ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
Compromise.
Notice has to go to respondent number 3 with respect to
ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ R3 ಗೆ.
ಯಾರ್ಯಾರಿಗೆ?
Respondent number 3 only, my lord.
3 unclaimed. We will not wait for those who don't claim.
But a moment, my lord, in page number.
What is the ground?
In page number 44.
ಲೋಕದಾಲತ್ತ?
Lokadalat, in page number 44 of the compromise.
ಆಗಿದ್ದು ಯಾವತ್ತು?
On 2012-2024.
2012-24.
Sorry, 14-12-24.
ಆಯ್ತು, who are you?
Well, I am the defendant. Whatever, my lord.
You did not sign?
I have signed.
Yes.
The negotiation between the parties is that, my lord. In page number 44, para 5. The plaintiff and defendant number 1, 2, 3, 4A, 4B, and 7 to 10, and 13 have agreed to concede that defendant number 12, Kalapa, has released a portion of the land measuring 34 guntas, 3 acre 12 guntas on western side of scheduled property. But the plaintiff himself concedes he is obtained the share there itself. The negotiation between the parties is that 34 guntas has to be allotted to the.
Why did you sign?
But we are not aware all those things, my lord, and we are not aware. And also, can you see the bottom, my lord? In the bottom of that page, the plaintiff has agreed to pay amount of rupees by way of cash so and so, so defendant number so and so. But that is the respondent number 1 year. That is the plaintiff. But the vacating application.
In the following manner.
Yes, ma'am.
ಇದು ಬಂದಿಲ್ವಾ ದುಡ್ಡು?
ಬಂದಿದೆ. But the plaintiff is claiming that, but the defendant respondent number 2 is claiming he paid the amount. But misrepresenting me, the plaintiff stating that here in my lord that the plaintiff paid. But in the vacating, they said that the defendant number 12 has paid. Lord, there is a 3 acre 12 guntas of the land. If at all the share has been
sued for what?
Partition suit.
You are also, you are the brother.
Yeah, brothers.
12 shares has to be allotted. If at all the plaintiff has got, he got only 11 guntas. And he obtained 34 guntas of
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಎಷ್ಟು ಸಿಕ್ಕಿದೆ?
ಯಾರಿಗೂ ಸಿಕ್ಕಿಲ್ಲ. ಬೇರೆ ಯಾರಿಗೂ ಸಿಕ್ಕಿಲ್ಲ. ಬೇರೆ ಯಾರಿಗೇನು, there is no single piece of land allotted to any other except the plaintiff.
Genealogical.
Except the plaintiff.
If plaintiff number one, plaintiff.
Compromise is like that?
Yes, my lord. Compromise and negotiation between the parties, 34 guntas has to be allotted to the plaintiff and the defendant number 1 to 10 and 13.
Yeah, correct. What has happened later?
But what happened, 34 guntas only.
Agreed to pay by way, you cash ತಗೊಂಡಿದ್ದೀರಾ?
The plaintiff claiming that the plaintiff has been paid. But defendant number 12 has paid plaintiff in page number, the vacating application in para 7. In para 7 in the vacating application.
ನಮ್ಮ vacating IA ನಲ್ಲಿ
After receiving a sum of rupees 14 less by me. The defendant number 11 and plaintiff both are claiming we paid and we paid, both of them. That is a misrepresentation.
ಅಲ್ಲ, he paid, they paid. Have they paid? ನಿಮ್ ಬಂದಿದ್ಯಾ ಏನಾರು?
Paid by the defendant number 11, not the
ಯಾರು
plaintiff.
ಕೊಟ್ರ ನಿಮ್ ಬಂದಿದ್ಯಾ?
Bandit. Defendant number 11, not by the plaintiff. My concern is that 34 guntas has to be allotted to the plaintiff and the other defendants except defendant number 11. The land property is the ancestral property of the plaintiff and defendant number 1 to 10. What in the misrepresenting and in the para.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್ ಕೇಳ. ಎಸ್ ಮೇಡಮ್.
My lord, this ಅದು ನಮ್ಮ ರಿಟರ್ನ್ಸ್ ನಮ್ಮ ವೆಕೇಟಿಂಗ್ IA ನಲ್ಲಿ ಬೈ ಮೀ ಅಂತ ಬಂದಿದೆ, ಪ್ಲೇಂಟಿಫ್ ಕೊಟ್ಟಿರೋದು ಅದು ಅಮೌಂಟ್ ಅಂತಂದ್ಬಿಟ್ಟು. ನಾವು ದ ಕ್ವಶನ್ ಹಿಯರ್ ಇಸ್ my lords, this ಅನಂತಮ್ಮ ಅನ್ನೋರ್ಗೆ ಪ್ರಾಪರ್ಟಿ ಸೇರಿತ್ತು. ಅನಂತಮ್ಮ ಅಂಡ್ ರಾಮಾಂಜನಪ್ಪ, I have given the memo now.
Page 1.
Page 1 is the genealogical tree.
ಒಂದ್ ನಿಮಿಷ, take time. We'll continue at 2:30.
Please, please.
Tomorrow.
ಅವನಾ
2:30 ಗೆ ಮ್ಯಾಚ್.
ಈಗ ಶುರು ಮಾಡಿದ್ಮೇಲೆ ಯಾಕೆ?
ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2:30 ಪಾಸ್ ಔಟ್ ಮಾಡಿಸ್ಕೊಂಡು.
ಅಲ್ಲಿ ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
2:30 ಪಾಸ್ ಔಟ್ ಮಾಡಿಸ್ಕೊಂಡು ಬೆಳಿಗ್ಗೆ.
ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
ಡೈರೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್.
ಡೈರೆಕ್ಷನ್ ಮ್ಯಾಟರ್. ನಾನು ಡೈರೆಕ್ಷನ್
ನಾಳೆಗೆ ನಾಳೆ ಅಲ್ಲಿ ಡೆಫಿನೆಟ್ ಟುಮಾರೋ
ನಾಳೆ ಆಗಲ್ಲ. 2:30 you come, ಆಮೇಲೆ ತಗೊಂತೆ.
ಗ್ರೇಟ್.
Yes.
Next matter, my lords.
ಏನು ಚಿನ್ಮಯನ?
Miscellaneous petition.
Which is that ಕೊಡಿ, ಅದ್ರ ಕೊಟ್ರೆ ಮಾಡ್ಬೋದು. ತೊಳಿ. serial number 150. Oh, ಇದಾ this order. Yes. Same order. ಅದೊಂದೇನಾ?
With your lordship's
My lords, one more mentioning. Serial number
one moment.
39, my lords.
We see 1 minute. Wait. Yes.
That is serial number 41. Petitioners have served a copy to me because I.
No problem. Adjournment. You can ask the court of.
Lord, one
Yes,
lord.
we see what is the problem.
My lords, serial number 39, my lords, adjournment. I am appearing for R8. I'll file my statement of objections, my lord. I'm just requesting for some time.
Yeah. All right. Adjourned. Yes.
Great for my lords.
For posting, your lordship. Arrest warrant has issued.
ಏನು vacating stay ಇದೆಯಾ?
Auction is stayed and the auction purchaser has deposited the entire 4 crores.
Oh, that's the amount. Yes.
My lords,
Take
I
it
am
on.
appearing for the auction purchaser. I have my statement of objection.
Then why
ready.
are you worried? Yes. Yes. Adjournment. Let's have 2 weeks. Yes, next.
Number 168 my lord. I appear for the petitioner my lord. 6 weeks time my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
168.
ಅದೆಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಬಿಡಿ, ಯಾವ್ದು ಬೇಕು?
One memo for posting, your lordship. Arrest warrant has been issued in the execution proceeding.
Lord, one matter, Lord, for tomorrow, Lord. My Lord, defense is likely to be stuck down, Lord. Tomorrow, Lordship.
Tomorrow.
Serial number 92, my lordship.
No, no, 61.
Court officer? Court officer? Serial number 74 ಏನಾದ್ರೂ ಅರ್ಜನ್ ಆಗಿದ್ಯಾ? Court officer? Ma'am, 74 ಅರ್ಜನ್ ಆಗಿದ್ಯಾ?
ಅಂದ್ರೆ all right. ಆಯ್ತು. You could hear the adverse observation. Oh,
Your Lordship.
technical glitch. Yes.
Your
All
Lord-
right. But no, that interim order ತಗೊಂಡ್ಮೇಲೆ you should be ready for argument. Whenever the date is fixed, you should be ready for argument. 12th ಇಲ್ಲ ಅಂದ್ರೆ 15th ತಗೊಂತೀನಿ. All right, yes.
Your Lordship, one urgent mention, Your Lordship. It's a WP. It's arising out of an execution petition, Your Lordship. The judgment debtor, he was ordered that he had filed an application for possession of the property with the help of police personnel. But the
ಏನ್
executing
ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಹೇಳಿ.
ಇವಾಗ ಡೆಮಾಲಿಷ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, Your Lordship.
ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ
ಮೂವ್
ಆಲ್ರೆಡಿ.
ಮಾಡಿದೀರಾ?
Your Lordship,
ಮೂವ್ ಮಾಡಿದೀರಾ?
ಇವಾಗ ಮೂವ್ ಮಾಡ್ತಾ
ಕೊಡಿ.
ಇದ್ದಾರೆ. At 3:30, Your Lordship, will hear them.
ಅದು ಏನ್ ಮುಹೂರ್ತನಾ?
ಇಲ್ಲ, Your Lordship, ಹೊಡೆದಾಕ್ಬಿಡ್ತಾರೆ ಅಷ್ಟೊತ್ತಿಗೆ.
ಆಯ್ತು, ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್. ಕೇಸ್ ನ ತಗೊಂತೀನಿ, ಬಟ್ ಹಾಕ್ಸೋ ಜವಾಬ್ದಾರಿ ನಿಮ್ದು.
Yes, Your Lordship.
Run.
Much obliged.
Yes.
Seal number 92, my lord. Seal number 92, my lord. Seeing for a 2 weeks adjournment.
ಇಲ್ಲೇ ಇದ್ದೀರಾ, ಹೋಗಿ.
ಇಲ್ಲ, Your Lordship, ಮೆಮೊ
ಅದು ಮೆಮೊ ಹೋಗುತ್ತೆ, ಹೋಗಿ.
Seal number 92, my lord. In the last set of hearing, Your Lordship had actually put in that we're supposed to mention, give the inventory record, my lord, inventory report. So 2 weeks time may be granted, my lordship. We'll file an inventory
ಗೊತ್ತಿಲ್ಲ,
report.
wait. If there is a order like that, wait, don't take. ಸತ್ಯಾನಂದ್ ಏನು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ? ತಗೊಳ್ಳಿ. ತೊಂದ್ರೆ ಇಲ್ಲ ಮೇಡಮ್, ಕೊಡ್ಲಿಲ್ವಾ? ಕೇಳಿಲ್ವಾ? ವಿಕೆಟಿಂಗ್ ಇದೆಯಾ? ಸರಿ, ಆಯ್ತಾಯ್ತು. ರಾಜುದಾ? 27th ಬೇಕಾ?
27th ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಓ ಸರಿ, ಇಲ್ಲೂ 27th ತಗೊಳ್ಳೋಣವಾ? ಆಯ್ತು.
Serial number 1
will be extended.
Elective serial number 153 in this case.
Judgments ನೋಡೋಣ. Where are the judgments?
My lordship, serial number 153 in this case.
ಏನ್ ಬೇಕು?
1 week time may be granted in this case, sir. I am for respondent in this case.
Petitioner urgency ಇದೆಯಾ ರಾಜೇಶ್ವರ್? ಇಂಟರ್ ಆರ್ಡರ್ ಇದೆಯಾ?
Interim order is there.
1 week accept, ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ. Yes. List after 2 weeks at the request of the Jagdish or AGL.
AG was here, my lord. He requested to pass over him.
I asked him to come.
Yes, he'll come, my lord.
Because I want his presence.
5 minutes, my lord, he will come.
The moment he comes, I'll take it. Yeah. ಇದು ಕೊಡಿ, ಡಿಕ್ಟೇಟ್ ಮಾಡಿ. 1819 ಒಂದೇ ಅಲ್ಲ. The petitioner, the petitioners, the victims, ಎರಡರಲ್ಲಿ ಸಪರೇಟಾ ಒಬ್ರೇನಾ?
ಬೇರೆ ಬೇರೆ, separate.
Separate. The petitioners in both these cases are victims in special case 182 of 2022 and special case 181 and 182 of 2022. They are at the doors of this court calling in question an order of the concerned court which rejects the application filed by the prosecution witness number 14 seeking his recall for examination in chief and marking of application yaar hakiddu? The application calling in question the rejection of an application filed by the prosecution seeking recall of the witness PW14 to mark certain documents and tender further examination. To witness documents ಆರ್ಡರ್ ಬರೀತೀನಿ, ಮೇಲೆ ಬರಿಬೇಕಾ ಎಲ್ಲ? No, should I in the preamble write everything or remaining in the judgment? No, ತೊಂದ್ರೆ ಇಲ್ಲ. Application 311 ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ರೆ ಫ್ಲೋ ಹೋಗ್ಬಿಡುತ್ತೆ. ಎಸ್, ಏನ್ ಹೇಳ್ದೆ ಮೇಡಮ್? The application of the prosecution, first and third, the petitioners, victims in both these cases, i.e. special case 181 and 182 of 2022, are before this court calling in question the rejection of, the calling in question an order dated so and so, which rejects two applications filed by the prosecution, one under section 311 of the CRPC and the other under section 91. Section 91 application was to produce two documents, and the section 300 application under section 311 was for the purpose of recall of PW14 for further examination. They heard so and so. Facts in brief, germane, are as follows. A crime comes to be registered in crime number 155 of 2022, and the matter 155 of 2022, and much water has flown after ಎರಡು crime ittala.
Only one crime, please, madam.
Only one crime,
Only one.
2022.
Two separate
And
charge
much
sheets.
water has flown after the registration of the crime, narration of which would not be germane for a consideration of the issue in the list. The prosecution witness 14-1, Basavarajan, was examined on what date?
Yes, please, madam.
ಅದೆಲ್ಲ dates ಹೇಳಿದ್ರಲ್ಲಪ್ಪ.
Two dates, please, madam.
Ah.
7 December 2024
Was examined on 7th December 2024
and 16 December
and
2024.
16th December 2024. After the said examination and several other witnesses being examined, the subject applications are filed by the prosecution seeking production of two documents which concerns PW14 and seeking his recall for further examination. The concerned court, by the impugned order, rejects both the applications. The rejection of the application has driven the rejection of the application is now challenged by the victims in those cases, in the aforesaid two cases. The learned senior counsel Hasmat Pasha, appearing for the petitioner, submits that the two letters which are in the nature of encomiums to PW14 given by the accused way back in the year 2007 is necessary to be placed on record and evidence on that score as well. The learned senior counsel would submit that the purport of section 311 is to put the record straight or steer clear any controversy that arises at the time of evidence. He would submit that no prejudice would be caused to the accused if the two documents are produced and examination on those two documents of PW14 rehappens. The learned senior counsel submits that the order of the concerned court is an error and is contrary to the purport of section 311 of the CRPC. Per contra, the learned senior counsel Shri C.V. Nagesh would take this court through the documents appended to the petition to demonstrate that the matter had reached the apex court. The apex court had directed the conclusion of the trial within a year. The concerned court has communicated to the apex court, and the apex court has now granted 3 more months' time for conclusion of the trial. He would otherwise contend that
still pending, my lord, in Supreme Court.
3 months agide andre
Illa. It's pending, please, my lord.
The apex court has a time for extension is already communicated to the apex court, which is pending consideration at the hands of the apex court. The learned senior counsel would otherwise contend that the documents that are sought to be marked are sought to be marked by way of an application under section 91 is by the prosecution. He is by the prosecution and that of prosecution witness number 14. He is not the accused. He is not the first informant, and nothing would change by the marking of those documents. Therefore, for the asking an application under section 311 or 91 should not be permitted is the submission of the learned senior counsel. Both the learned senior counsel appearing for the petitioner and the respondent have placed reliance upon certain judgments which would bear consideration in the course of the order. The afore narrated, I have given my source. The afore narrated facts are are a matter of record. The issue that has driven the petitioner, the victims to this court, is not something that is passed against the victims. It is an application filed by the prosecution. The prosecution filed by the prosecution seeking recall of PW14 as for further examination, and section 9, an application under section 91 seeking production of two documents. What are those documents is germane to be noticed. They are as follows, page 40, 41. The application filed before the concerned court reads as follows, page 42. The concerned court, by its order dated so-and-so, has rejected the application, rejected both the applications. The reason for rejection is as follows. Get it from page 25 to 36. The issue now would be whether the order of the concerned court which rejects both the applications suffers from want of tenability. As observed herein above, the two documents that the prosecution wanted to file, prosecution wanted to place before the court were concerning PW14, the prosecution witness. They were encomiums given to the prosecution witness 14 by the accused 17 years ago. Accused 17 years ago. Of what use the said documents would be is ununderstandable. As the learned senior counsel for the petitioner seeks to take this court through the statement of witness, the deposition of PW14 to contend that it becomes imperative for the production of documents should become imperative. The evidence of PW14 is as follows. Page 18, I will mark ಮಾಡಿದೆ. The applications are filed under section 311 and 91. Section 311 reads as follows. Section 311 permits recall of witnesses in a proceeding at any stage if it would lead to discovery of truth qua the allegation against the accused or the defense of the prosecution. Allegation against the accused or the defense of the accused. In the case at hand, the prosecution witness number 14 is neither the victim nor the informant nor the accused, is a prosecution witness. In such circumstances, whether an application of this kind that is filed at the stage of the trial must be permitted or otherwise need not troubled or otherwise is considered by the apex court. Therefore, the issue need not be gone deep or therefore this court would not delve deep into the matter except quoting those judgments. Both the learned senior counsel for the petitioner and the respondent have relied on several judgments to so-and-so the health in Madam, all of which now bear consideration by the apex court in its latest judgment in 2025 SSC Online SC page 351 in the case of Singh Prajapati versus State of Uttar Pradesh, where the apex court has laid down postulates for the courts considering the application under section 311 to be allowed or otherwise. The apex court holds that if it is not necessary for a decision making in the said proceeding, such applications for the asking should not be permitted. While the apex court holds, yes, it is the right of the accused or the prosecution to file necessary applications to drive home the truth. In the case at hand, driving home whatever is to be produced in those documents would not advance the cause of the victim, nor the cause of the prosecution, nor the cause of nor the defense of the accused. Therefore, the application for the asking is filed and the asking is filed which has been rightly rejected by the concerned court by the aforesaid order. I do not find any error in the order that is passed warranting interference at the hands of this court to direct redo the exercise of the cross-examination, the examination in chief or cross-examination of PW14 as the case would be, as after the examination of PW1 on 2,
Yes,
first PW14 first agide yavattu?
Yes, please, my lord. It was on
ಈಗ ಹೇಳಿದ್ರಲ್ಲ on 2/12 ಏನಿರ್ಬೇಕು ನೋಡಿ
7/12.
7/12/2024 54 witnesses have already been
40 witnesses.
40 witnesses have already but court act 54 ಬರೀತಾರೆ.
Total 54.
40 witnesses have already been examined and totally 54 witnesses have already been examined in the case at hand. Therefore, there is no warrant of interference with the order that is passed by the concerned court. Both these petitions lacking in merit stands rejected.
And it's a single application wherein two provisions have been invoked, not two separate applications.
Application.
Grateful, my lord.
Yes,
Obliged.
next. AG or set kodi. A little backdrop to that, Jagdish sir knows it. I have directed constitution of a cyber command center.
Please, my learned friend was saying.
Yes, adralli. Where is he? Busy? No, move on. Yes, adu kodi madam. I'll just pronounce that.
In fact, the cyber command, insofar as all cyber crimes throughout the state under the supervision of pursuant to the notifications, 2 notifications have been issued, my lord.
No, I have in detail said, reading the whole thing would be unnecessary.
I'll go through the whole thing.
You go through the whole thing and, but this should become a reality.
No.
It should not remain on paper.
In fact, the notifications, everything has been done. We'll
See,
just
that is why I have said I have coined it as CCC, Cyber Command Center. Like your one of the your ittala, the CCB. That way. This is the CCC. It's up to you. I have for short form ಮಾಡ್ಕೊಂಡಿದ್ದೆ. Cyber Command Center ಅಂತ it's the CCC. I have said so. You can do it anyway. So I have said that it should not become a mere edifice of the bureaucracy. I'll release it now.
Please, as per the notification date is 9th
notification
April.
29/2025 tackles about 8 problems.
8 problems.
See,
Correct.
there are few other problems in that.
Please.
For example, the helpline 1930,
Please.
what you have where a person calls the helpline and says, my money has gone. It can be a hoax call, it can be anything. My money has gone into a particular account. That account gets frozen immediately. ಆಮೇಲೆ ನೀವು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ when we have passed some orders that freezing ಆಗಬಾರ್ದು, ಲೀನ್ ಮಾರ್ಕ್ ಆಗಬೇಕು ಅಂತ.
Correct.
So ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಟ್ ಮಾಡಿ. ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡೋದು on an account which has nothing to do is definitely violative of law.
Correct.
So what you should do is ಅವಾಗ ಈಗ ಏನಾಗ್ತಾ ಇದೆ?
Extent also.
ಎಕ್ಸ್ಟೆಂಡ್ ಒಂದು ಆಮೇಲೆ ಒಂದು ಕಾಲ್ ಬರುತ್ತೆ ಎಲ್ಲಿಂದಾನು. ಕಾಲ್ ರಿಸೀವ್ ಆದ ತಕ್ಷಣ ಲೀನ್ ಅನ್ಮಾರ್ಕ್ ಆಗೋಗುತ್ತೆ. ಯಾಕಾಗುತ್ತೆ?
Especially lawyers account.
ಗೊತ್ತಿಲ್ಲ ಯಾಕಾಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ. So for reasons best known to all of you, it will happen. ಫೋನ್ ಬಂದ ತಕ್ಷಣ ಆಗುತ್ತೆ, ಫೋನ್ ಬಂದ ತಕ್ಷಣ ಹೋಗುತ್ತೆ. ಇದೆಲ್ಲ ವಿತೌಟ್ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ಆಗ್ತಾ ಇದೆ. No FIR is registered, no document is created, lien is marked, the account holders are troubled straight away by all jurisdictional police. ಯಾವ ಪೊಲೀಸ್ ಈಗ 1930 ಹೆಲ್ಪ್ ಲೈನ್ ಯಾರು ಎತ್ತಾರೆ ಅವ್ರು ಫ್ರೀಸಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. That has led to lot of problems, lot of litigation. So ಎಲ್ಲ you should
go through your lordship direction.
Integration ಇರ್ಬೇಕಲ್ಲ.
Kindly grant us some time and we'll come back to your lordships.
I have posted the matter on 24th again.
24th, please.
Whatever development takes place on this. And one more thing I have said, see, there are some officers, SIT I have constituted that is doing the job. Now cyber command unit ಮಾಡಿದಾಗ some officers should be there. Some officers are appointed. ನಾಳೆ ದಿನ for political reasons you shift them ಅಂದ್ರೆ the entire unit collapses. Because the birth pangs or the teething problems of a particular unit now begun to become robust, somebody should be there.
We'll look into that also.
I have said everything about that. It will be released.
We'll go through it. By 24th, we'll give a.
By 24th, what you have done. And let me tell you, if this is done, state of Karnataka will be the first state in the country to do this.
No, we'll definitely implement
First
it.
state in the country to bring in something like this. So that is the important, that is the importance of this cyber command unit.
We'll go to the Your Lordship's order in detail, my lords.
Yes.
In fact, my learned friends say some of them have been implemented. We'll go through
No,
what is not
ಅದೇ I
been,
have said clause 1 to 8 implement ಮಾಡಿದ್ದೀರಾ?
balance which have not been.
Balance should be done ಒಂದು. ಆಮೇಲೆ reference to this order is important so that the government order should not be withdrawn
In fact,
by a separate dispensation later.
the 2nd September does not refer to it. I saw that.
No, that's
I
not.
understand.
But
understand.
why of it I am telling you. Because
Understand.
tomorrow dispensation changes, it should not be withdrawn. Because today crimes are faceless. At the click of mouse it is happening. So you should have antidote to those mouse clicks.
We'll definitely do that. Give reference to
That's
this
why I
order.
wanted your presence.
Please.
All right, yes.
Upload that.
ಅಲ್ಲ why separate ಇದೆ ಮತ್ತೆ ಆದಾಗ?
ಏನು?
Let it, the order may be uploaded.
No, the
This
court
will
said
be
you have to
uploaded.
upload it. Please.
Madam. Yes, ಇಲ್ಲ upload. Take care. There's another bench hearing this. This check ಮಾಡಿ ಹೇಳಿ ನನಗೆ. Yes. No, ಅದಲ್ಲ. This is Shyam Prasad is hearing something like this. Where is Angad? Ask him to come.
Bail matter was there.
ಯಾವುದು?
Cancellation of bail moved by the.
ಅಲ್ಲಿ. GM.
Not GM.
ಅಲ್ಲ ಅದೆಲ್ಲ ಅಲ್ಲ. Just check. Ask him to check and get back. Yes. Yes, continue the list, madam. ಇಲ್ಲ.
Let's continue 36.
Sole item, 3 acres 12 acres. The mother of the defendant number 11 has been sold to defendant number 12. 2005. All the family members are right. Only the respondent number 1 year is filed for partition. Respondent number 1 year. He is entitled for 1/12 share. Not during the course of the joint before the local they filed a compromise petition. In the compromise petition, all the family members are entitled for 34 rupees, and the defendant number 12 is entitled for 2 acres. This is a negotiation between the parties. What happens is that for each share, 2 acres has each share, we have received that amount from the defendant, not from the client. We received a share from some of those rupees from the sale. With respect to 2 acres 18 guntas, not with respect to 34 guntas. Now the plaintiff only claiming that he is the owner of the 34 guntas. That is the question. And in this
ಈಗ ನಿಮ್ ದುಡ್ಡು ಬಂದಿದೆಯಲ್ಲ?
With respect to share of the defendant number 12 subsequent purchaser, not on the share of the plaintiff. The same plaintiff alone has got the share. There is no single square feet has been allotted to the other family members except the plaintiff.
Yes, madam.
D12 is the purchaser. We purchased it in 2005.
ಯಾರು?
D12.
ಆಯ್ತು.
That is responding to.
Is that the plaintiff?
He is not the plaintiff.
D12 is the purchaser.
D12 is the purchaser. ನಾವು ಒಂದು ನಿಮಿಷ ಈ genealogical tree ತಗೊಂಡ್ರೆ 2 ನಿಮಿಷದಲ್ಲಿ
ಕೊಟ್ರಲ್ಲ.
G3 ತಮ್ಮ ಕೊಟ್ಟಿದೆ. ಇವತ್ತು ಮೆಮೊ ಕೊಟ್ಟಿದೆ. ಅಲ್ಲಿ ತಿರುಮಲಾಚಾರ್ ಅನಂತಮ್ಮ ಅಂತಿದೆ. ಅನಂತಮ್ಮಗೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಯ್ತು. ಅನಂತಮ್ಮ ಅಂಡ್ ಹರ್ ಸನ್ ಇಸ್ ರಾಮಾಂಜಿನಪ್ಪ. ಅವರಿಬ್ರು ಸೇರಿ 2005 ನಲ್ಲಿ ನಮಗ್ ಮಾರ್ಬಿಟ್ರು. 2005 ಆದ್ಮೇಲೆ ಆಮೇಲೆ ಅವ್ರ ಕೇಸ್ ಹಾಕೊಂಡಿರೋದು ನಂತರ ಹಾಕೊಂಡಿದ್ದು OS ಹಾಕೊಂಡಿದ್ದು. ನಾವು ಪೊಸಿಷನ್ ಅಲ್ಲೆಲ್ಲ ಇದ್ವಿ. ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರೆ ಲಕ್ಷ್ಮಮ್ಮಸ್ ಚಿಲ್ಡ್ರನ್ ಅಂಡ್ ರಾಮಾಂಜನಪ್ಪಸ್ ಬ್ರಾಂಚ್ ಅವರಿಬ್ರು ಸೇರ್ಕೊಂಡು ಥ್ರೂ ದಿಸ್ ಪ್ಲೇಂಟಿಫ್ ಹೂ ಇಸ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಮೈ ಲರ್ನಡ್ ಫ್ರೆಂಡ್ ಹಿಯರ್, your lordship may kindly see his name is here, ನಿರಂಜನ ಮೂರ್ತಿ ಅಂತ, ಲಕ್ಷ್ಮಮ್ಮಸ್ ಸನ್, ತಾವು P ಅಂತ ಕಾಣತ್ತೆ. ಅವ್ರ ಪ್ಲೇಂಟಿಫ್ ಆಗಿ ಅವ್ರ ಕೇಸ್ ಹಾಕಿದ್ರು. ಅವರು ಸೂಟ್ ಅನ್ನು ಹಾಕಿದ್ರು. ಸೂಟ್ ಹಾಕಿದಾಗ ಕಾಂಪ್ರಮೈಸ್ ಬಂತು.
ಇವ್ರು ಯಾರು?
ಅವರು ಲಕ್ಷ್ಮಮ್ಮ ಸನ್, ಅದರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್. ನಿರಂಜನ ಮೂರ್ತಿ ಅನ್ನೋರು ಕೇಸ್ ಹಾಕಿದ್ರು. ಲಕ್ಷ್ಮಮ್ಮಸ್ ಚಿಲ್ಡ್ರನ್ ಇವ್ರು, ಬೇರೆ ಚಿಲ್ಡ್ರನ್ ಇವ್ರು. ಸೊ ಇದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆದಾಗ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ ನೈನ್ತ್ ಡೇಟ್ ಅಲ್ಲಿ ಅದನ್ನ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ರೆಫರ್ ಮಾಡಿದ್ರು. 12/4 ಗೆ ಕಾಂಪ್ರಮೈಸ್ ವಾಸ್ ಎಂಟರ್ಡ್ ಇಂಟು. ಇಟ್ ಈಸ್ ಸೈನ್ಡ್ ಬೈ ಆಲ್ ದ ಪಾರ್ಟೀಸ್. ನಾವು ಪರ್ಚೇಸರ್ಸ್ ನಾವೇನ್ ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ 3 acres 12 ಗುಂಟಾಸ್ ತಗೊಂಡಿದ್ವಿ. ಅಟ್ ಬೆಸ್ಟ್ ಆರ್ ಅಟ್ ವರ್ಸ್ಟ್ 3 shares ಹೋಗ್ಬೇಕಾಗಿತ್ತು. ಏನು ಈ ಅನಂತಮ್ಮನ್ಗೆ, ಲಕ್ಷ್ಮಮ್ಮನ್ಗೆ, ರಾಮಾಂಜನಪ್ಪಗೆ 3 ಜನಕ್ಕೆ ತಗೊಂಡಿದ್ರು ಸಹ. 3 acres 12 ಗುಂಟಾಸ್ ಅಂದ್ರೆ 132 ಗುಂಟಾಸ್ ಡಿವೈಡೆಡ್ ಬೈ 3 ಅಂದ್ರೆ ಒಬ್ಬೊಬ್ಬರಿಗೆ 40 ಗುಂಟಾಸ್ ಅಪ್ರಾಕ್ಸಿಮೇಟ್ಲಿ ಹೋಗ್ತಾ ಇತ್ತು. ಲಕ್ಷ್ಮಮ್ಮ ಬ್ರಾಂಚ್ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ, ಬಿಕಾಸ್ ದಿ ಅದರ್ಸ್ ವರ್ ಆಲ್ ಗೇನ್ಫುಲಿ ಪ್ಲೇಸ್ಡ್ ಎಲ್ಸ್ವೇರ್, ದಿಸ್ ನಿರಂಜನ ಮೂರ್ತಿ ಪ್ಲೇಂಟಿಫ್ ಇದಾರಲ್ಲ, ಹಿ ವಾಸ್ ಅರ್ಚಕ್. ಅವ್ರಿಗೆ 34 ಗುಂಟೆ ನೀವು ಬಿಟ್ಕೊಟ್ಬಿಡಿ, ಆಮೇಲೆ ಇನ್ನೊಂದು 14 ಲಕ್ಷ ರೂಪಾಯಿನ ನಾವು ಇವ್ರಗಳಿಗೆಲ್ಲ ಹೆಣ್ಮಕ್ಳಿಗೂ ಒಂದಷ್ಟು ಕೊಟ್ಕೊಳ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಕಾಂಪ್ರಮೈಸ್ ವಾಸ್ ಎಂಟರ್ಡ್ ಇಂಟು. ನಾವು ತಗೊಂಡಿದ್ದ ಜಾಗದಲ್ಲಿ ನಾವು 34 ಗುಂಟಾಸ್ನ ಇವ್ರಿಗೆ ಬಿಟ್ಕೊಟ್ವಿ. ಯಾಕಂದ್ರೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ನಮ್ಗೆ ನಾವು ವಿ ಹ್ಯಾಡ್ ನಾಟ್ ಪರ್ಚೇಸ್ ಫ್ರಮ್ ಲಕ್ಷ್ಮಮ್ಮ ಅಟ್ ದಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್. ಯಾರು ಅನಂತಮ್ಮ ಅಂಡ್ ರಾಮಾಂಜನಪ್ಪ ಇಂದ ಮಾತ್ರ ತಗೊಂಡಿದ್ವಿ. Ideally speaking, Ananthamma is the owner of the property. She has executed a registered sale deed in our favor way back in 2005. Now all of them have signed.
Plaintiff ಗೆ ಬೇರೆಯವರಿಗೆ ಬಂದಿರೋದೇ ಹೆಚ್ಚು ಅಂತ ಇದ್ದೀರಾ?
ಕೊಟ್ಟಿದೀವಿ, ಆಲ್ರೆಡಿ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ. And everyone has signed. Kindly see, my lords, the only ground that they have taken in the writ petition is that, kindly see the ground that they have alleged in the writ petition. Kindly see, my lords. Illi.
Where is the joint memo ಆತರ ಹಾಕಿದೆ? ಎಲ್ಲಿದೆ?
ಹಾಕಿದೆ. The respondent has not, the ground that is taken is page 7, my lords. Your lordship may kindly see page 7. Page 7 is where they have taken the ground. Only ground that they have taken is ground, page 7, third line from top. The respondent number 1/plaintiff has not let the petitioners and their advocate to read the compromise petition, and he is insisting in petitioners to sign the same in an urgent manner. This is the only ground urgent. And kindly see, my lords, again in page 8, last 3 lines, the same thing they have said.
Has not let the petitioners and their advocate to read the compromise. Advocate ಓದ್ಲಿಲ್ವಾ?
ಅವ್ರುಗಳು ಸೈನ್ ಮಾಡಿ. ಆಮೇಲೆ ಪೇಜ್ 45 ಅಲ್ಲಿ ತಾವು ಗಮನಿಸಬಹುದು. 46 ಸ್ವಾಮಿ, ಪೇಜ್ 46, 45 ನಲ್ಲಿ ಸ್ಲ್ಯಾಬ್ ಇದೆ. ಇದೆಲ್ಲ ಟೇಬಲ್ ಮಾಡಿದ್ದಾರೆ, ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟು ದುಡ್ಡು ಹೋಗಿದೆ ಅಂತ. ದೇ ಅಡ್ಮಿಟ್ ದಟ್ ಆಫ್ ಕೋರ್ಸ್. 45 ತಾವು ಗಮನಿಸಬಹುದು ಸ್ವಾಮಿ.
45 ಅಲ್ಲಿ ಚಾರ್ಟ್ ಇದೆಯಲ್ಲ,
ಚಾರ್ಟ್ ಇದೆ. ಆಮೇಲೆ 46 ತಾವು ಗಮನಿಸಬಹುದು ಸ್ವಾಮಿ. 46 ನಲ್ಲಿ the plaintiff and the defendant.
ಈಗ ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಈಗ ಪೂರ್ತಿ 3 acres and 12 ಗುಂಟಾಸ್ ಪ್ಲೇಂಟಿಫ್ ಹೋಗಿದ್ಯಾ? ಮತ್ತೆ
ಇಲ್ಲ ನಮ್ಗೆ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ.
ಮತ್ತೆ ಆಯ್ತು, 34 ಆ ಶೇರ್ ಪ್ರಕಾರನೇ ತಗೊಂಡ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದೇ ಅದಕ್ಕೆ. ಈಗ ಡಿಫೆಂಡ್ ನಂಬರ್ 12 ಯಾರು?
ನಾವು ಪರ್ಚೇಸರ್ಸ್.
ಪರ್ಚೇಸರ್ಸ್ ಕರೆಕ್ಟ್. 34 ಗುಂಟಾಸ್ ಅಲ್ಲಿ ಈಗ 34 ಗುಂಟಾಸ್ ಯಾರಿಗ ಹೋಗಿದೆ?
ಪ್ಲೇಂಟಿಫ್. ನಾವು
ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಏನಾಯ್ತು? ಎಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಕ್ಲೋಸ್ ಆಗಿದೆ.
ಇಲ್ಲಿ 46.
ಸೊ ಈಗ ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಪ್ಲೇಂಟಿಫ್ ಗೆ 34 ಗುಂಟೆ ಹೋಗಿದೆ, ಅದಕ್ಕೆ ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಲ್ಲ, ಯಾಕೆ ತಗೊಂಡ್ರಿ?
ಅಲ್ಲಲ್ಲ,
ಬಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆಯಲ್ಲ ಆಮೇಲೆ. All these are ladies, is it?
ಇಲ್ಲ
ಮತ್ತೆ
ಇಲ್ಲ.
ಯಾಕೆ ಗೊತ್ತಾಗಲ್ಲ ಅಂತ?
But it's because
Very
we are
difficult
claiming
one.
on the 34 quotas only, not on 288. We are not claiming at the call of the subsequent purchaser. We are claiming on the plaintiff. 34 quotas are ನಮಗ್ ಭಾಗ
ಈಗ 34 ಗುಂಟಾಸ್ ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ವಲ್ಲ?
ನಾವು ಇದ್ರಲ್ಲ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ವಿ ಅವ್ರಿಗೆ, ಯಾಕಂದ್ರೆ ಲಕ್ಷ್ಮಮ್ಮನ್ ಬ್ರಾಂಚ್ ಈಗ ರಾಮಾಂಜನಪ್ಪ
ನೀವು
ಬ್ರಾಂಚ್
ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದನ್ನು ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿ ಅವ್ರು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ನಮಗ್ ಬೇಡವೇ ಬೇಡ ಅಂತ.
ನೀವೇನ್ ಎಲ್ಲ ಎವ್ರಿ ಶೇರ್ ಯು ಟೇಕನ್ ಆಫ್? ವಾಟ್ 44? ಅದೇ ಕಾಂಪ್ರಮೈಸ್.
Para number 7, my lord, last line. Plaintiff has agreed to pay an amount by way of cash to the defendant. Plaintiff has paid, my lord. By receiving the amount from the defendant number 12, I paid cash to them, but they relinquished their share. And I have got 34 quintas to my share, my lord.
You have paid cash to defendant number 12.
I wasn't talking to.
ಇಲ್ಲ, defendant number 12. Defendant number 12 is in turn paid.
No, my lord. I took the money from defendant number 12. I paid to the all the defendants. Other defendant 1 to 11.
Defendant number 12 is 288 quotas, not with respect to 34 quotas. That is only.
There is a clear mention in the compromise petition as well.
That is only.
That plaintiff has paid the.
ಸರ್ ಒಂದ್ ನಿಮಿಷ, 2 ಎಕರೆ 18 ಗುಂಟೆ ಇವ್ರು ಆವಾಗ ಪರ್ಚೇಸ್ ಮಾಡಿ 34 ಗುಂಟೆ ಮಾತ್ರ ಅವ್ರು ಕೊಟ್ಟಿರೋದು. ಅದಕ್ಕೆ ಯಾಕೆ ದುಡ್ಡು ತಗೊಂತಾರ ಅವರು ಈಗ?
ಅದ್ರಲ್ಲಿ 34 ಗುಂಟೆ ಕೊಟ್ಟು ಈ ರಿಮೈನಿಂಗ್ 2 ಎಕರೆ 15 ಗುಂಟೆ ಇದೆ. 2 ಎಕರೆ 15 ಗುಂಟೆ ನಾವು ಕ್ಲಿಯರ್ ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ. ನಮ್ಗೆ ಅಮೌಂಟ್ ಕೊಟ್ಟಿರೋದು 34 ಗುಂಟೆ ಅಲ್ಲ. 2 ಎಕರೆ.
ಅದು ವೇರ್ ಡು ಯು ಗೆಟ್ ದಟ್? ಅವ್ರ ಪರ್ಚೇಸರ್ಸ್ ಯಾಕೆ ಬರ್ಬೇಕು? ಈಗ ಪರ್ಚೇಸ್ ಮಾಡಿದವ್ರು ಯಾಕೆ ಮತ್ತೆ ದುಡ್ಡು ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ?
ಸ್ವಾಮಿ 40
ವೇರ್ ಇಸ್ ಇಟ್? ವೇರ್ ಇಸ್ ದಿ ಕಾಂಪ್ರಮೈಸ್ ಹಿಯರ್?
ಇಲ್ಲ.
Vacating application also the same thing. They paid the amount, but lender fund is also respond number 2. ಅವರು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. They taken the money from the defendant number 12, subsequent purchaser, and he paid to BI.
46 page number 46 para 10 may kindly be seen.
No sir.
46 10.
Okay, the one family member out of the.
ದುಡ್ಡು ತಗೊಂಡಿಲ್ವಾ? ಯಾರಿಂದ ಬಂದಿದೆಯೋ ದುಡ್ಡು ಬಂದಿದೆಯೋ ಇಲ್ವಾ? ಸಿ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 12 ಇಂದ ಬಂದ್ರೆ ಆ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 12 ಪ್ಲೇಂಟಿಫ್ ನೋಡ್ಕೊಂತಾರೆ, ನೀವೇನ್ ವರಿ ಮಾಡ್ಬಿಡಿ. 2 acre 18 ಗುಂಟಾ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? ವೇರ್ ಇಸ್ ಇಟ್? ಟೆಲ್ ಮಿ. First thing is 2005 alle they had purchased the entire land.
3 acres.
No doubt about it. 2000 suit is instituted by the plaintiff, whoever is there, 2012 ಅಲ್ಲಿ. This suit was for how many acres?
3 acres 12 quotas.
ಅದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದೇನು?
34 quotas plaintiff and defendants came.
ಇಲ್ಲ.
Where is that?
Page number 47. Page number 47. Page number 47. That is 34 out of the 34 quotas has been allotted to the plaintiff on the family members. And remaining 2 acres.
ಒಂದ್ ನಿಮಿಷ ರಾಜೇಶ್, ಒಂದ್ ನಿಮಿಷ.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅನ್ನೋದಲ್ಲಿ
Suit schedule property is 3 acres 12 guntas. All right. All the piece and parcel land bearing 3 or 12 guntas bounded on so and so. 34 guntas ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ ಇದರಲ್ಲಿ?
34 second measuring 34 quotas out of the 12 quotas.
Measuring 34 guntas out of 3 acres situated so and so.
Plaintiff ಮಾತ್ರ I'll mention.
ಅಲ್ಲ, compromise schedule A property, compromise schedule B property. ನಿಮಗ್ ದುಡ್ಡು ಬಂದಿರೋದು ಯಾವ್ದ್ರಲ್ಲಿ ಈಗ?
7 and 8 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ತಾವು. Page 45 ನಲ್ಲಿ.
We are not respecting 34 quotas. 12 members, family members. How can the single member has been allotted 34 quotas?
Suit was for partition.
Suit was for partition. All the defendants were the counter claim. In page number, return statement, all the defendants are the counter claim.
Yes, madam. Because there are two schedules here. Schedule A, compromise schedule A property, schedule B property. If this is a composite compromise order, in that 2 acres 18 guntas ಗೆ ದುಡ್ಡು ಹೋಗಿದೆಯೋ 34 guntas ಹೋಗಿದೆಯೋ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಒಂದೇ ಒಂದು ನಿಮಿಷ ಸ್ವಾಮಿ. May I just submit that? Kindly see my lords, this paragraph 7 ಅಲ್ಲಿ.
Paragraph 7 ಬಿಡಿ. This is
compromise petition ಅಲ್ಲೇ ನಾನು.
Petition ಈಗ schedule property ಎಲ್ಲಿ ಹೇಳಿದಿರಾ compromise petition?
ಅದೆಲ್ಲ ಹೇಳಿದೆ ಸ್ವಾಮಿ.
Para 8 ಗೆ ಬನ್ನಿ. Yes, para 8 ಅಲ್ಲಿ plaintiff and defendant considered admitted schedule A property been put to possession of plaintiff and the compromise schedule B property to continued in possession of defendant number 12.
ನಾನು
ನೀವು
number 12.
ಅದು 34 guntas.
ಅಲ್ಲ ನಾವು
2 acre 18 guntas, correct. Respective owners can enjoy so and so.
ಇವರೆಲ್ಲ ಸೇರ್ಕೊಂಡು
Different owners undertook themselves with respect to legal heirs no manner of right interest. ಬಟ್ ಅವ್ರಿಗೆ ಏನೂ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಅದಲ್ಲ ಒಂದೇ ಒಂದು ನಿಮಿಷ ಅದನ್ನ ನಾನು
ಯಾವ್ದರದು ಅಂತ ಗೊತ್ತಿಲ್ಲ
ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತೀನಿ.
ಏನಿಲ್ಲ.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತೀನಿ ಅಂತ ನಾನು. ಇದು ಪ್ಲೇಂಟಿಫ್ ಏನಾಗಿದ್ದಾರೆ ಅಂತಂದ್ರೆ, ನಾನು ತಮ್ಗೆ
ಇಲ್ದಾರೆ
ಜಿನಿಯಾಲಜಿಕಲ್
ಇಷ್ಟೊತ್ತು ತಗೊಂತಾನೆ ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲ ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ಪ್ಲೇಂಟಿಫ್ ಈಸ್ ಅ ಅರ್ಚಕ್.
ಪ್ಲೇಂಟಿಫ್ ಯಾರು ಇರ್ಲಿ, ಆಲ್ ಆರ್ ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್, ಆಲ್ ಆರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್, ಕರೆಕ್ಟ್? ಪಾರ್ಟಿಷನ್ ಆಗ್ಬೇಕಾದ್ರೆ ಎಲ್ರಿಗೂ ಬರ್ಬೇಕು ತಾನೆ ಶೇರ್.
ಅಲ್ಲ ಅವ್ರಿಬ್ರು ಬ್ರಾಂಚ್ ಆಲ್ರೆಡಿ ಬಂದ್ಬಿಟ್ಟಿತ್ತು. ಯಾರಿಗೆ ಅಂದ್ರೆ ದೇ ಹ್ಯಾಡ್ ಸೋಲ್ಡ್ ಇಟ್ ಇನ್ 3 at an undisputed point of time. They had sold it, my lords. Your lordship may kindly see.
This compromise has created all the problem.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿದೆ. Kindly see, my lords, all of them have signed. Kindly permit me.
Now the whole problem is the heartburn. Plaintiff, the only plaintiff has taken everything. 2 acre 18 guntas remains with you, no problem. 34 ಗುಂಟೆ ನೀವೇ ಹೆಂಗ್ ತಗೊಂಡ್ರಿ ಎಲ್ಲ? ಅವ್ರಿಗೇನ್ ಬೇಡವಾ? ಏನು?
I have initiated the suit. They received money and they relinquished their share to me, my lord. Lord, in the compromise B schedule, Lord. At West, compromise schedule A property belongs to plaintiff Sina Niranjana Murthy, same survey number 22.
ನಿಮ್ ಯಾರು ಸೈನ್ ಮಾಡಕ್ ಹೇಳಿದವ್ರು ಇದಕ್ಕೆಲ್ಲ? ಏನ್ 80 years old? And advocates are there, what did they do?
Para 10 ನೋಡ್ಬೋದು ಸ್ವಾಮಿ ಒಂದ್ಸಲ. 46 ಅಲ್ಲಿ
highly
ಅಲ್ಲ 46 ಅಲ್ಲಿ ಅಲ್ಲ ಯಾಕೆ
unreasonable
they
distribution.
had left it. ಯಾರು ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ನಮ್ ಜಾಗಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಇವರೊಬ್ರು
2 acre 18 guntas ಅವ್ರಿಗೆ ಸಂಬಂಧನೇ ಇಲ್ಲ ಬಿಡಿ.
ನಾವು ಇವ್ರಿಗೂ
ನಿಮ್ದು you are appearing for 2 acre 18 guntas, no problem at all. Other than
ಇವರೊಬ್ರು ಬಂದು ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ರು. ಪ್ಲೇಂಟಿಫ್ ಅವ್ರ ಕೇಸ್ ಹಾಕಿದ್ರು, ಪ್ಲೇಂಟಿಫ್ ಅವ್ರ ಕೇಸಲ್ಲಿ ನಾವು ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ವಿ.
ಅಲ್ಲ ಆಯ್ತು, ನಿಮ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಈಗ 2 acre 18 guntas is over now, so you need not have any problem. He will not come in your way at all. So that is over. In yours the problem. Yes sir.
Schedule B property ಅಲ್ಲಿ ಒಪ್ಕೋತಾರೋ ವೆಸ್ಟ್ ಗೆ ಯಾರ್ದಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಪ್ಲೇಂಟಿಫ್ ಶೇರ್ ಏನು ಹೋಗಿದೆ ಅದನ್ನೇ ಇದೆ ಅಂತ ಒಪ್ಕೋತಾರೋ. They themselves permitted.
ಆಮೇಲೆ
ಯಾವ ದುಡ್ಡು ತಗೊಂಡ್ರದಲ್ಲ ವಾಪಸ್ ಕೊಡ್ತಾ ಇರ್ಬೇಕು.
ಅಲ್ಲ 3 ರಿಂದ 4 ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ. ಎಲ್ಲ
ಎಲ್ಲರಿಗೂ ಸಿಗ್ದಾನೆ ಆತರ. nobody will relinquish their rights like this. Oh no, they'll give it back. They'll give it back. You take it back. 34 guntas divide ಮಾಡಿ. ನಿಮ್ಗೇನ್ 2 acre 18 guntas ತೊಂದ್ರೆ ಆಗಲ್ಲ ಬಿಡಿ.
ನಮಗೇನು
no problem.
That's one part of it. That part of it
ಅಷ್ಟೇ, ನಿಮ್ದಿಲ್ಲ ಅಂದ್ರೆ ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
I am bound.
Yes.
But logically speaking, my lords, I am
logically no.
ಅಲ್ಲ ನಾನು ಒಂದು
no, you forget madam, you are appearing for this.
No, I am not ಅಲ್ಲ ನಾನು
ಅಲ್ಲ 2 acre you parties ಬಿಟ್ಬಿಡಿ ನೀವು. You logically you tell me in a partition suit it is to be divided between plaintiff and defendants, no doubt about it.
Equitable partition.
ಹೌದಾ? ಇದು ಯಾವ equitable partition ಇದೆ?
Equitable partition ಆಗ್ಬೋದು, or I can forego also.
Forego should be on madam, either it should be equitable partition, foregoing should be on equitable reasons. ಎರಡೂ ಅಲ್ಲ.
ನಾನು ಕೇಳಿದೆ ನಮ್ಮವ್ರನ್ನ, ಯಾತಕ್ಕೆ ಹಂಗ ಒಬ್ರಿಗೆ ಕೊಟ್ರಿ ಅಂತ ಕೇಳಿದಕ್ಕೆ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ, ಈತ ಅರ್ಚಕ್ಕಾಗಿದ್ರು, ಬೇರೆ ಇಬ್ರು ಕೆಲ್ಸದಲ್ಲಿದ್ದಾರೆ, ಪ್ರೈವೇಟ್ ಕೆಲ್ಸದಲ್ಲಿದ್ದಾರೆ, ಬಾಕಿ ಹೆಣ್ಮಕ್ಳಿಗೆಲ್ಲ ಸುಮ್ನೆ ಒಂದ್
ಅದೇನು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ ಅರ್ಶನ ಕುಂಕುಮ.
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಅಂತ ಇವ್ರು ಹೀಗ್ ಮಾಡಿದ್ರು.
ನಾನು ಹೆಣ್ಮಕ್ಳು ಅಂದ ತಕ್ಷಣ ಆತರ ಅರ್ಶನ ಕುಂಕುಮ ನಿಲ್ಸ್ಬಿಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಅವ್ರು ಯಾರೂನು ಕೇಳೇ ಇಲ್ಲ.
They also have a right, they should have a right.
ಅನಂತಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಅದು. What we purchased was from ಅನಂತಮ್ಮ.
Gone are those days madam, ಅರ್ಶನ ಕುಂಕುಮ ಕೊಟ್ಬಿಟ್ರೆ ಸಾಕು ಅಂತ.
ಅಲ್ಲ ನಾನು ಲಾಜಿಕಲಿ ಅಂತ ಯಾತಕ್ಕೆ ಹೇಳಿದ್ದು ಅಂತಂದ್ರೆ ಒಂದೇ ಒಂದು ವಿಷಯ. By and large, many of the cases get settled either through mediation or through lok adalat. What happens is they arrive at a settlement. All the advocates they have.
Madam, ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ settlement ಆಗುತ್ತೆ ಅಂತ arrive ಆಗ್ತಾರೆ. They'll feel the effect of that when they get nothing, and see somebody else getting a lion's share. That's the whole problem.
That cannot standing outside the case. Though I am standing outside this case. In a larger perspective, I am telling, when they have subscribed, they have agreed to everything in the lok adalat. Can we go beyond that? Kindly see the order sheet, my lords. They have signed the order sheet. There is a
that they admit.
Petition.
That they admit, but the party itself is not equitable. Their judgment code.
Page 46, your lordship may kindly see 1 minute.
ಅಲ್ಲ ನೋಡಿದೀನಿ madam. Yes sir. ಮತ್ತೆ ನಿಮ್ದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. You are 2 acre 18 guntas ತಾನೆ, ಬಿಟ್ಬಿಡಿ, ಅವ್ರು ಡಿಫೆಂಡ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಪ್ಯಾರಾ 10 ಅಲ್ಲಿ ಇದೆ. ನಾವು ಮಿಸ್ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಮಾಡಿಲ್ಲ, ನಾವು ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಿಲ್ಲ.
ನೀವು ಮಾಡಿಲ್ವಾ? ಅದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ, ನೀವು ಮಾಡಿದಿರಲ್ಲ. ಯಾವ ಜಡ್ಮೆಂಟ್ ಕೊಡ್ಬೇಡಿ ಸುಮ್ನೆ. ಎಸ್ 34 guntas ಮೊದಲು ಕೊಡಿ ಸರ್. ನೀವು ಸೈನ್ ಮಾಡೋದ್ರಿಂದ ವೆರಿ ಡಿಫಿಕಲ್ಟ್.
Para number 9 and 10. The High Court has observed that the counsel for the plaintiff must have misled the trial.
That's the problem. I'm aware of that, not that. But you see, ಎಲ್ಲ ನೀವೇ ತಗೊಂಡ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
ದುಡ್ಡು ಹೋಗಿದೆ ಅವ್ರಿಗೆ. ದುಡ್ಡು ಹೋದ್ಮೇಲೆ because I have got 34 quintal.
ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು 30? ಎಲ್ಲಿರೋದು ಇದು?
ನಾನ್ ಕೇಳ
ಎಲ್ಲಿರೋದು?
ನಾನು
ನ್ಯಾಷನಲ್?
ನಾನು ವಿಚಾರಿಸಿದೆ ಸ್ವಾಮಿ ಅದು.
ಅಲ್ಲ ಎಲ್ಲಿರೋದು ಅದು?
ಮಟ್ಟನಹಳ್ಳಿ ವಿಲೇಜ್.
34 ಗುಂಟೆಗೆ ಎಷ್ಟಲ್ಲಿ?
ಬಾರ್ಡರ್ ಆಫ್ ಮಾಲೂರ್ ಬಾರ್ಡರ್ ಗೆ ಬೆಂಗಳೂರು ಹತ್ರ ಇಲ್ಲ, ಮಾಲೂರ್ ಬಾರ್ಡರ್.
ಅಯ್ಯೋ ಅದು ಬೆಂಗಳೂರಿಗಿಂತ ಜಾಸ್ತಿ ಬೆಳೆದಿದೆ ಈಗ.
19 lakhs is the sub registrar's value.
ಅದು ಯಾರಿಗೆ ಬೇಕು ಮೇಡಮ್?
ಅಲ್ಲ ನಾವು
SR ವ್ಯಾಲ್ಯೂ ಅಲ್ಲಿ ಎಲ್ಲ
ಅಲ್ಲ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ಸ್ ವ್ಯಾಲ್ಯೂ 19 lakhs ಇವತ್ತಿಗಿದೆ. ಸೊ 3 times ಅನ್ಕೊಂಡ್ರು ಬಹುಶಃ ಲೆಟ್ ಮಿ ಬಿ ವೆರಿ ಆನೆಸ್ಟ್.
3 times ಇರಲ್ಲ, ಅದಿಷ್ಟಿದ್ರೆ 19 ಇದ್ರೆ 10 times.
ಅಷ್ಟಿರಲ್ಲ, ಅಷ್ಟೆಲ್ಲ ಬರಲ್ಲ, ಆ ಕಡೆ ಎಲ್ಲ ಬರಲ್ಲ ಸರ್, ಅಷ್ಟೆಲ್ಲ ಬರಲ್ಲ.
ಹೆಣ್ಮಕ್ಳಿಗೆ ಬರ್ಬೇಕಲ್ಲ ಮೇಡಮ್.
ನಾವು ಕೊಟ್ಟು
ಬರೀ 2 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ರೆ ಹೆಂಗೆ? ಇಲ್ಲ
ಅಲ್ಲ 14
ಇನ್ಕ್ರೀಸ್
ಲಕ್ಷ
ಇಟ್ ನಾವು
14 ಲಕ್ಷ
ನಿಮ್ದು ಬಿಡಿ ಮೇಡಮ್. ನಿಮ್ದು 2 acres 18 ಗುಂಟಾಸ್ ಬರೋದೇ ಇಲ್ಲ. ಏನು ಏನು ಅರ್ಚನೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಟು ಈಚ್ ದೆನ್
ಈಚ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇನ್ನ ತುಂಬಾ ಜನ ಇದ್ದಾರೆ.
ನಾಟ್ ಈಕ್ವಿಟಬಲ್ ಸರ್. ನೀವೊಬ್ರೆ ಯು ಕಾಂಟ್ ಟೇಕ್ ದಿ ಲಯನ್ ಶೇರ್. ಎಲ್ರಿಗೂ ಬೇಡವಾ? ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಹೌದಾ? ಮತ್ತೆ
ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ
ಅಲ್ವಾ?
ಅನಂತಮ್ಮನ್ಗೆ ಲ್ಯಾಂಡ್
ಆಯ್ತು ಬಿಡಿ, ನಿಮ್ದು ಆಯ್ತು ಬಿಡಿ ಮೇಡಮ್, ಇವೇನು ಟೆನ್ಷನ್ ತಗೋಬೇಡಿ. ಅಲ್ಲಿ ಏನಾರ ಆಗಲಿ, ದೇ ಆರ್ ಯುವರ್ ಸಿಬ್ಲಿಂಗ್ಸ್ ಆರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಸರ್. ಯು ಕಾಂಟ್ ಟ್ರೀಟ್ ದೆಮ್ ಸ್ಟ್ರೇಂಜರ್ಸ್, ದೇ ಆರ್ ಯುವರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್. ಅವ್ರಿಗೆ 2 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟು ನೀವು 2 ಕೋಟಿ ಇಟ್ಕೊಂಡ್ರೆ ಹೆಂಗಿರುತ್ತೆ? ಅದೇನು 10ರಿಂದ 15ಕ್ಕೆ? ಓ ಹಾಗಾದ್ರೆ ಯು ನೋ you sit across and settle. Ildare if I set this aside and send it back, nimdalla madam, only 34. Yes, and send it back andre tondre ಆಗ.
ನಾನು ಬಂದ ತಕ್ಷಣನೇ ಹೇಳಿದೆ ಸ್ವಾಮಿ,
not equal. ಅದಕ್ಕೆ I took some time to understand what is the problem. I was against him. The law definitely is not in his favor, it's a different thing, but equity should be there. ನೀವು ಒಬ್ಬರೇ ತಗೊಂಡ್ರೆ ಹೆಂಗೆ ಹೇಳಿ? ಸೆಟಲ್ಮೆಂಟ್ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆನ್ ದಿ ಡಾಟೆಡ್ ಲೈನ್ಸ್, ಅದ್ರ ಎಫೆಕ್ಟ್ ಗೊತ್ತಾಗಿರೋದು ಆಮೇಲೆ. ಅಂಡ್ ಲೋಕ್ ಅದಾಲತ್ತೆ ಹರಿಲಿ ಎಲ್ಲ ಮುಗಿದೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ದಟ್ಸ್ ದಿ ಹೋಲ್ ಪ್ರಾಬ್ಲಮ್. ಅದು ಖಂಡಿತ ನಿಲ್ಸೇನೆ. ಯು ನೋ ಹೌ ಇಟ್ ಫಂಕ್ಷನ್ಸ್. ನೀವು ನೋಡಿಲ್ವಾ? ಮೇಡಮ್ಗೂ ಗೊತ್ತು. ಎಸ್, I'll take it next week, no problem.
After 17, 15,
19,
16,
19. Yes. Mindan ilvala madam. I 22nd list, but this 10 lakh 15 lakhs nadiyalla. You sit across, you don't ask 34 guntas back. Correct ah kutkondo mugsi. Take some more amount and leave it at peace. Right. Ultimately ದುಡ್ಡಿಗಾಗ ಅಷ್ಟೇ ಇದು, ಬೇರೆ ಏನಿಲ್ಲ. ಸರಿ, ಈಗ 1 ಗುಂಟ ಕೊಟ್ಟರು ಪ್ರಾಪರ್ಟಿನೇ. Well, I'll not record anything, but I'll take it on 22nd in preliminary hearing. List on 22nd in preliminary hearing. ಅದೊಂದು ಹಾಕ್ಬಿಡಿ, 2 acres 18 ಗುಂಟಾಸ್ ಏನ್ ಪ್ರಾಬ್ಲಮ್. ಬಟ್ ನೀವು ಬನ್ನಿ ಮೇಡಮ್. Interim order subsisting will continue.
ಏನ್ ಹೆದರಿಕೆ ಆಗಿತ್ತು ಅಂದ್ರೆ ಮತ್ತೆ ಲೋಕ್ ಅದಾಲತ್ಸ್ ಮೀಡಿಯೇಷನ್ ನಾವು ದಿನ ಮಾಡ್ತಾನೆ ಇರ್ತೀವಲ್ಲ, ಮತ್ತೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅಲ್ಲಿ ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟು
ಇಲ್ಲ, ಅದಕ್ಕೆ ಇಲ್ಲೇ ಮುಗಿದ್ಬಿಟ್ರೆ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ.
ಅದೇ
ಇಲ್ಲಿ properly seal it properly here.
My only, I mean, submission was in that broader perspective, not other.
Correct, but it should be equitable madam, ಅಷ್ಟೇ, ಬೇರೆ
that they should think before signing.
ಅಲ್ಲ, this
the 2 decisions, my lords, your lordships will be
judgment irli. I'm not on see, if I apply the law I'll have to non-suit him, not a problem.
Correct,
but it is not correct in a family. Why all this? Yes.
37.
Well, interim order ಇದೆಯಾ? ಕರೆಕ್ಟ್, ಬಟ್ ಯಾಕೆ ನಾನ್ ಸರ್ವಿಂಗ್ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಸರ್ವ್ ಮಾಡೋದೇ ಇಲ್ಲ? ನೋಟಿಸ್ ಮಾಡಿದ್ಮೇಲೆ ನೀವೇನು ಮಾಡಲ್ಲ. ನೀವು ಪ್ರೊಸೆಸ್ ಪೇ ಮಾಡಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ? ಲಾಸ್ಟ್ ಇಯರ್ petitioner seeks 10 days time to do the needful. ಮಾಡ್ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ನೀವು ಇದ್ರಲ್ಲಿ ನೀಡ್ಫುಲ್ ಮಾಡಿ ಅವತ್ತು ಕೊಡ್ತೀನಿ. ಲಿಸ್ಟ್ ಆನ್ 22nd in preliminary hearing. ತೊಗೊಳ್ಳಿ, ಅದು learned counsel, respond number 2 ಯಾರು? Learned counsel AM Nitin accepts notice. Nitish accepts notice for the second respondent, registry to print the name of so and so. Coromandel steps ತಗೊಳ್ಳಿ. ಗೊತ್ತಿಲ್ಲ, ಸರ್ವ್ ಮಾಡಿ ಅವ್ರಿಗೆ. Counsel for the petitioner is at liberty to serve on any counsel who is representing the respondent in any of the proceedings between the parties. Yes. Next.
38.
2 weeks time to do the need. Interim order, yeah? 2 weeks time to do the needful. Interim order subsisting will continue to the next date of hearing. Next.
39, 40, 41, 42.
Post immediately after service of notice upon respondents 1 and 2.
43.
So 2 weeks time to do the needful. Next.
44 urgent, 45.
2 weeks.
46, sorry, 46 urgent. 47 urgent, 48.
Therefore, a week time and file objections to.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections. Objections, if any, the next 2 weeks. Interim order, then note. Yes, continue. Next.
49.
Grateful.
PF steps ತಗೊಂಡಿಲ್ಲ? Learned ತಗೊಂಡಿಲ್ವಾ? Affidavit ಹಾಕಿದ್ದೀರಾ? The learned counsel submits. The counsels have refused acceptance of notice. Therefore, the emergent notice to the respondents. 1 to 4. Counsels refuse ಮಾಡಿದಾರಾ? ಯಾರು ಮಾಡಿದ್ದಾರೆ? Counsel. Therefore, notice be issued to respondents. Therefore, emergent notice to the respondents. Yes, next. Interim order subsisting will continue to the next date of hearing. ಆಯ್ತು sir. Yes. ಇಲ್ಲ ಇದಾರಲ್ಲ 51 ಇದು 50 ಪ್ರಸಾದ್ BS ನಾನ್ ಫೈಲಿಂಗ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್. ಎಸ್, ವಾಟ್ಸ್ ದ ಮ್ಯಾಟರ್? ಏನದು?
ಸರ್ವಿಸ್ ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್.
ಇಲ್ಲ ಇದಾರೆ.
He's appearing for one of the.
How many defendants are there? Learned counsel for the petitioner files a memo of acknowledgement of service upon the counsel for the defendants before the concerned court, awaiting their representation. List the matter on 15th, Monday.
51.
For the respondent number 2 in this case, my lords. My lords, the petition itself is not maintainable, my lords.
Why, madam?
It's appellable order, my lords.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು?
Uh,
2197 ನಾ?
22 rule 6, my lords.
22 rule 6 ಗೂ ಅಪೀಲ್?
Oh, sorry, 12 rule 6, my lords. Sorry, my
12 rule 6.
My lords may kindly.
No representation way of the petitioner. Pendency of this petition will not come in the way of further proceedings before the concerned court. Yes, next. List after 4 weeks.
52 urgent, 53.
I appear for the respondent undertakes to file wakalat.
Learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. Lest the matter after 2 weeks interim order subsisting will continue to the next date of hearing. Next.
54 urgent, 55.
Interim order ಇದೆಯಾ? ಏನ್ ಮ್ಯಾಟರ್? Suit for Why do you want the commissioner?
Before commencement of evidence, that's where stage of for hearing on A number 1, page number 37.
ಈಗ ಅಲೋ ಆಗಿದೆಯಾ ಅದು? ಹಾ, ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Towards now there are 10 scheduled 10 items. Towards all the 10 items.
No.
Properties, towards eastern side.
Nothing wrong. We'll reserve liberty. If needed later, you file an application, it will consider.
Their application came to be dismissed. Now they prefer an appeal. This is an appeal before the appellate court. If that application is set as a court, I right to utilize.
ಅದಾದಾಗ ಬನ್ನಿ.
The eastern side road has been shifted to in my property.
ಇನ್ನು ಸೂಟ್ ಶುರು ಆಗಿಲ್ಲ, ಆಗ್ಲೇ ಕಮಿಷನರ್. No.
They have sought for interim injunction from not to interfere in this peaceful procedure.
ಇಂಟರ್ ಮಾಡಿ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಟೈಮ್ ಕೊಡಲ್ಲ, ಅವರು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಬರ್ಲಿ.
I prefer commission application.
Less the matter after 2 weeks. Yes. No, sir. ಬೇಕಾದಾಗ ಅವಾಗ ಹಾಕಿ. ಇವ್ ಶೂಟ್ ಶುರು ಆಗಿಲ್ಲ, ಆಗ್ಲೇ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್. Yes. The learned counsel appearing for the petitioner after arguing the matter at length would seek leave of this court to withdraw the petition, reserving liberty to the petitioner to file any application that is needed at a later point in time at the appropriate stage. With reserving such liberty, the petition stands disposed. Yes.
56 adjourned. 57.
Lords, I appear for the petitioner, my lords. The compliance is done, my lords.
Learned counsel submits by
R1 to R3.
Learned counsel so and so undertakes to enter appearance for respondents 1 to 3. Register to print the name of so and so as appearing for respondents 1 to 3.
Interim order may be kindly
Interim order
extended.
subsisting will continue to the next date of hearing. Next.
Great.
58.
58.
Post immediately after service of notice upon the respondents.
59.
Copies of acknowledgement. Copy served?
Served only.
ನೀವೇ ಇದ್ದೀರಾ? ಮಹೇಶ್.
My lord, my colleague is.
All right. Yes, sir. There's an interim order?
Can you give me some response of
What suit for? Issue. What's the issue here?
issue is, before filing of the suit, there were 3 stages before filing presentation of the claim. After filing of it, some more states have taken place at the institution of the defendant. And they were sought to be treated by an NDA.
The purchasers of the property?
Yes.
Huh.
3 were earlier to, 3 were later to.
3 were earlier to ಯಾವುದು will permit them. Later to ಆಮೇಲೆ.
Court should not rather, can I request my note to kindly?
No, if it is earlier to, you have a right. If it is later to, FDP.
I know I can't cross the limits.
No, legal. Earlier ಯಾರಿದ್ದಾರೆ 3 will permit them to enter. Prior to the institution of the suit, if the property is sold and you are in possession of that property, will permit you to come in. During the pendency of the suit, if you have purchased, come in the FDP.
My note for here connected B. That's my application to bring them on record. And proposed defendant number 8, she is the one who purchased the property earlier to the suit. Later, after filing of the suit, person influence sold it to defendant number for 11, 12, 13, and 14.
Yes, sir.
My lord, no such details are given in the affidavit, my lord, except stating that since from 2006 to 2022.
You file your
transactions.
objections then.
Please.
Learned counsel for the respondent seeks weeks, 10 days time to file statement of objections. Yes, let the others come.
Please.
Can I seek a small intelligence, because my colleagues are finding too hard to get the proceedings adjourned because of the pregnancy of the rectification there. Till the next day of the hearing.
Not a case for stays. Yes, next.
60.
ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Learned counsel submits needful has been done, offers to verify list after 4 weeks. Interim order subsisting will continue to the next date of hearing.
61.
Interim order idea? List after 4 weeks, interim order needful counsel submits needful has been done, offers to verify list after 4 weeks. IO next.
62.
Learned counsel submits needful has been done, offers to verify 4 weeks. IO next.
63.
Yes, my lord, filed wakalat for R4
ಯಾರ್ಯಾರಿಗೆ?
yesterday.
R4 ಗ?
5 to 7 undertake to file.
5 to 7.
Yes.
Counsel case Bhimaya submits that he has entered appearance for the fourth respondent and would undertake to appear for respondents 5 to 7.
My lord, along with this.
And someone.
My lord,
counsel
one
for the
brother has
petitioner
filed this.
submits that the other respondents have also been served by way of hand summons.
My lord,
The submission.
one submission. Another writ petition filed by Mr.
Submission is placed on
May be
record.
connected 25738.
Tag this petition along with
25738 of 2025.
ಬರ್ಕೊಂಡ್ರಾ madam? Yes.
25738.
List after 4 weeks, interim order subsisting will continue to the next date.
Any date may be fixed, my lord.
Vacation. ಆಗ್ಲಿ vacation ಆದ್ಮೇಲೆ ಬರ್ಲಿ. Is next.
Much.
25. 64.
Interim order ಇದೆಯಾ? ಏನ್ ಸೂಟ್ ಏನು? ಇಲ್ಲಿ ಇಶ್ಯೂ ಏನು?
Commission warrant, first commission warrant, there is evidence on it. First commission warrant issued, then commissioner filed a report, he examined. Now second commission application is filed, that takes to tell against that and you will start. Yeah, independent.
Awaiting the representation of affidavit in ಯಾರು counsels ಪರಲ್ಲ. Emergent notice to the respondents in the light of the fact that the counsels have refused to accept notice for the respondents. Counsels before the concerned court have refused to accept notice. Yari, counsel for the respondents. So and so. List the matter after 4 weeks. The order impugned shall remain stayed till the next date. Next.
65.
65, our served, my lord, acknowledgement also filed. The lordship of my colleague is there, my lord. Acknowledgement.
Learned registry file ಮಾಡ್ತಿದ್ದಾರೆ. Counsel for the petitioner.
ಇಲ್ಲ ಫೈಲ್ ಆಗಿದೆ, ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿದ್ದೇವೆ.
Counsel for the petitioner submits that the acknowledgement of service of notice has already been filed before the registry office to verify. Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಇಂಟರ್ ಮಾಡಿಲ್ಲ, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಲಿ ಸ್ವಾಮಿ.
ಬೇಕಿತ್ತಾ? ಹಂಗಾಗ
ಅಲ್ಲ ಇಂಟರ್ ಮಾಡ್ರ್ ಬೇಕಿತ್ತು.
ಏನ್ ವಾಟ್ಸ್ ದ ಮ್ಯಾಟರ್?
ಅಲ್ಲ ಅದು ಆರ್ಡರ್ 26 ರೂಲ್ 10 ಎದು ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಆಲ್ರೆಡಿ ಅಡ್ಮಿಟೆಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಡ್ಮಿಟೆಡ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ ಅಲ್ಲಿ
ವಾಟ್ ಏನ್ ರೆಫರ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
ಅದು ಅಲ್ಲ ರೆಫರ್
ದಿಸ್ ಮ್ಯಾಟರ್ ನೋ ಎಸ್ ಲೆಟ್ ಇಟ್ ಕಮ್. List the matter. No, list the matter after 2. Awaiting the representation of the respondents. List the matter after 2 weeks. Registry to put up the matter immediately after the respondents would get represented. Yes, next.
66 to 68 adjourned. 69.
Learned counsel submits. ಆಗಿದೆಯಾ? Submits needful has been done. Office to verify. Enter ಮಾಡಿದೆ madam. List after 4 weeks. IO next. Post immediately after service of notice upon the respondent.
71.
IO yes next.
71.
R5 R6 here. Learned counsel submits that the respondents have been served. Needful has been done. Office to verify. Interim ಮಾಡಿದ್ರೆ 4 weeks. ಕೊಟ್ಟಿಲ್ವಾ? ಸಾಕು. Yes. Next.
72.
Injunction yaru, yes, no problem. Next.
72.
Yes, Prakash, sir. Learned counsel submits needful has been done, office to verify list after 4 weeks, IO. Next.
73.
IO. ಅದನ್ನೇ extend ಮಾಡಿದ್ದು.
73.
My lord, we are
Then-
appearing on behalf of the
Of a second
respondent
amendment.
number one association.
Issue of a second amendment application being allowed
Ah.
on a finding that there is no need for diligence.
File your objections, madam.
Yes, ma'am.
The learned,
Grant us 10 days time. my
yes,
lord.
madam. The counsel so and so, and you already filed wakalat?
Yes, my lord.
The counsel so and so submits that he has entered appeal. Second respondent registry to print the name of so and so's
First
appearance.
respondent, my lord,
First
respondent number one.
respondent.
Yes, ma'am.
For the first respondent, the registry to print the name of so and so's appearing for the first respondent. Learned counsel would seek 10 days time to file statement of objections. This after 2 weeks, ISO, by then IO. Yes.
My lord, regarding this stay, my lord, it
You have
greatly.
to file your objections, madam. File it.
Yes, my lord.
We'll consider.
Okay.
Interim order.
74. Action 74.
At 74, I appear for the respondent in 74. I have entered appearance in the trial court on 2/9 and they have still not served me a copy of the writ petition.
ಇದು ಯಾರು ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡಿದಾರಲ್ಲ?
ಅವರು ಪೆಟಿಷನರ್ ಬಂದು ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ನಾನು ಬೆಳಗ್ಗೆಯಿಂದ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಕಾಪಿ ಕೊಡಿ, ಅಟ್ಲೀಸ್ಟ್ ಲೆಟ್ ಮಿ ಎಕ್ಸಾಮಿನ್ ದ ಪೇಪರ್ಸ್ ಅಂತ.
ಅದು ಕೊಟ್ಟು.
ಇಲ್ಲ, ಬೆಳಗ್ಗೆನೂ ಕೇಳಿದ್ದೀನಿ. 2/9 I have filed my wakalat before the trial court.
List tomorrow.
Grateful.
Yes. Arun?
25.
Petitioner has heard the contesting respondent.
ಇಲ್ಲ, ಇದ್ದಾರೆ.
entered upon in this case.
Contesting respondent ಯಾರು?
Our respondent number 1.
I'll file my objections, my lords.
Okay.
Other respondents, your lordship may dispense with notice.
Memo ಕೊಡಿ.
Please.
Learned counsel, the petitioner files a memo seeking dispense. ಯಾರ್ಯಾರಿಗೆ?
2 to 14, my lords.
2 to 14.
But the request is to recall
2 to 13.
R4 as their witness, my lord.
R4 has
But
not
now they have
contested the
filed-
matter.
They have filed the written statement also, my lord. But
ಮತ್ತೆ
this is very
ಇರ್ಲಿ
much
ಬಿಡಿ,
required.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಇಂಟರ್ ಮಾಡಿದ್ಯಾ?
Yes, interim order.
ಏನಾಗಲ್ಲ ಬಿಡಿ.
I'll take out notice on the advocates, your lordships are directed.
The petitioner shall serve on the count. ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ already.
But ಅಲ್ಲಿ mutilate ಆಗ್ಬಿಟ್ಟಿದೆ, ಅವರ ನೇಮ್ ಅಂಡ್ ಅಡ್ರೆಸ್ ವಕಾಲತ್ತಲ್ಲಿ mutilate ಆಗ್ಬಿಟ್ಟಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. I am informed. I'll verify and I'll take the steps. 2 to
Learned
13.
counsel for the petitioner shall serve the remaining respondents hand summons ಹೇಳ?
Please.
By way of hand summons. List the matter after 4 weeks. Interim order subsist.
Counsel appearing ಅಂತ. I'll just verify and make submission.
ಆಯ್ತು, counsel appearing before the so and so. List after 4 weeks IO. Next.
And this matter may be listed along with CRP 646 of 2023.
Tag
Transfer ಕೇಳಿದ್ದಾರೆ.
Tag this petition along CRP ಗೆ ಇದಕ್ಕೆ
CRP transfer.
ಅದರಲ್ಲೂ ಸ್ವಲ್ಪ defects ಇದೆ, my lords.
ಅದರಲ್ಲೂ ಡಿಫೆಕ್ಟ್
There
ಇದೆ.
is a declarative suit as well as injunction suit.
There is
They
a
wanted
transfer
to
petition.
merge.
ಟ್ಯಾಗ್ ಮಾಡೋದು ಬೇಡವಾ?
Tag ಮಾಡೋದು ಬೇಡ.
But tag
I
ಮಾಡ್ಲೇಬೇಕು
have my
ಇದರಲ್ಲಿ.
objections.
ಆಯ್ತು, ವಿಲ್ ಸಿ. ಬರ್ಲಿ
Moreover,
ಬಿಡಿ.
it has been transferred to KR Puram.
ನೆಕ್ಸ್ಟ್ ವಿಲ್ ಸಿ.
Please.
ಅದ್ ಬಂದಾಗ ನೋಡ್ಕೊಳ್ಳೋಣ.
Please, please.
76.
The petition, my lords, delivery warrant is issued, my lords. The other day, my lord, I have made a mention.
ಸರ್ವ್ ಮಾಡಿದ್ರ?
ಸರ್ವ್ ಮಾಡಿದೀನಿ, ಲಾಸ್ಟ್ ಟೈಮೇ ಸರ್ವ್ ಆಗಿತ್ತು.
ಡೆಲಿವರಿ ವಾರಂಟ್ ಯಾಕೆ?
Lord, there is a decree for possession,
ಹಾ.
which has been confirmed by the first appellate court, against which second appeal is filed. There is a small delay, my lord, 36 days.
Small delay.
36 days delay, my lords. The other day, my lord, I have made a mention that
In filing the RSA.
RSA, my lords.
ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ ಬಂದ?
ಇಲ್ಲ, ಬಂದಿದೆ, ನೋಟಿಸ್ ಆಗಿದೆ ಅದರಲ್ಲಿ. ನೋಟಿಸ್ ಆಗಿ ಅವರು ಅಪಿಯರ್ ಆಗ್ಬೇಕಷ್ಟೇ. ಅದಕ್ಕೆ. That is why, my lords. Now, my lord, the earlier matter was fixed on 6th. Now it is adjourned to 20th, my lords, saying that unless there is a stay, my lords, we cannot proceed, my lord.
ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
Order on IA number 1, my lord, directing the surveyor to locate the property and
The petitioner is before this court, calling in question an order passed by the executing court under order 26, rule 10. Rule. Where is the application?
my lord, application, my lords, is page number 25, my lord, annexure D, 151 application.
So application filed by the decree holders seeking appointment of a taluk surveyor to proceed with-
Identify the
to
decree schedule
identify the property and draw up a report and place it before the court. The learned counsel for the petitioner submits that a regular appeal was preferred against the said order which comes to be rejected and against which an RSA is preferred, and in the RSA The RSA was preferred after delay of 36 days. Therefore, the notice is issued by the coordinate bench of this court. In the light of the pendency of the same, the order dated so and so shall remain stayed till the appearance of the respondents.
Please apply.
Next.
77.
For the petitioner in the matter, my lord. As I undertake to accept notice on behalf of the respondent. I
Please
filed
serve
my
the copy.
wakalat.
Cabinet council so and so undertakes to enter appearance for the respondent.
This matter before the commercial court stayed. The impugned order is one, my lord, so that was passed under an IA filed by me under order 16 rule 1A, wherein I had sought to bring PW2 as a witness from my side. Wherein, my lord, the same relief is granted to the defendant.
All right, let's see. ಈಗ allow ಮಾಡ್ಬೇಕಾ?
My lords, I prayed 2 weeks time to file the
Cabinet
statement.
council seeks 2 weeks time to file statement of objection. Council for the respondent seeks 2 weeks time. List after 2 weeks. I next.
Interim order, it's great.
Post immediately after service of notice upon the respondent.
Trial court has posted for orders in the, to execute the sale deed in execution petition, my lord.
What's
Kindly
the suit for?
suit for partition, my lord.
Application ಏನು?
Application for appointment of commissioner to execute the sale deed in execution petition.
Execution proceedings. ನೀವ್ ಯಾರು?
No, the,
JDR.
JDS.
ಬರ್ಲಿ ತಾಳಿ.
He is avoiding to take notice, my lord. He is very much present in the village.
ಆಯ್ತು, hand summons ತಗೊಳ್ಳಿ. Counsel for the petitioner to serve the respondent by way of hand summons. Yes, next.
79.
To the party or.
My lord, I appear for petitioner in this case. my lord.
Petitioner ಅಂದ್ರೆ respondent ಅಂದ್ರೆ ಏನ್ ಪಾರ್ಟಿನೇ?
Yes, sir.
Yes.
79.
My
My
lord,
lord, I appear for a petitioner in this case, my lord.
I'll undertake to.
Learned counsel so and so undertakes to enter appearance for the respondent. Register to print the name of so and so is appearing for the respondent.
my lord, kindly direct to the petitioner to serve the copy, my lord.
Petitioner to serve complete set of papers
Yes,
upon the
but yes,
respondent.
but I'll serve upon him, my lord. I'll serve
Next.
upon him.
Much obliged.
I've served it in WhatsApp, but anyhow, I'll serve physical copy.
That is not open, properly opened, my lord. Hence I'm.
ಆಯ್ತು ಆಯ್ತು ಕೊಡ್ತಾರೆ ಯಾಕೆ?
Please, my lord.
I undertake to file wakalat.
Learned counsel so and so undertakes to enter appearance for the respondents 2
to 5 and 8.
2 to 5 and 8. Register to print the name of so and so is appearing for 2 to 5 and 8.
Filing the memo with the acknowledgement.
The learned counsel submits needful has been done in qua service to be effected to other respondents. Yes. List after 2 weeks. IO. Next.
81. Thank you.
List after 2 weeks. Yes.
82.
Not sir, for the petitioner, my lords. I have served the copy on 6/9, my lord.
The learned counsel submits needful has been done office to verify. Interim order ಇದೆಯಾ?
Interim order ಇಲ್ಲ. No, my only, my lords, my application to frame issue has been rejected, my lords. It's a 1962 sale deed which they want to rectify now. I only sought that suit is barred by limitation. The issue being framed for saying that suit is barred by limitation.
The learned counsel appearing for the petitioner submits that the petitioner plaintiff
Defendant.
different, sorry. The petitioner is the defendant. Is before the court calling in question rejection of an application which declines to accept framing of a particular issue. Plaintiff ನೀವೇನ್ ಡಿಮಾಂಡ್ ಮಾಡ್ತೀರಾ? Counter claim ಹಾಕಿ.
No, my lords, the sale deed is of year 1962, which
Maybe.
he wants to correct it now. I only say that let me issue for saying that whether the defendant proves that suit is barred by limitation, law of limitation. That's all I wanted, my lord.
We'll see. List the matter on 22nd in preliminary hearing. Further proceedings before the concerned court till the next date is state.
Grateful.
Next.
83.
Lords, these are
83.
those court commission cases. Court commissioner 26 rule 9. On the last date of hearing, it was heard, my lords.
ನೀವಿದ್ದೀರಾ?
Yes.
This, but I may only point out, I think for they have already apprised lordships on.
ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ಕೆ ಇದ್ದಿದ್ದು.
Like, still, no, only one word. I only want.
Yes, no problem.
Page 25, lords.
Yes.
Para 8. I only came here to point out this. There, my lord, they say, trial court says already the Honorable High Court has directed me to appoint a valuators, therefore I go ahead.
I said I'll send it back. I'll send it aside and send it back. Ibru beda.
ಅಲ್ಲ ಅಷ್ಟೇ, that's all.
Avru beda andru ivru beda.
That is
But,
the
sir,
instruction.
May I
That is
submit?
that he had argued on that day.
No,
I said that reason is wrong.
only to that extent.
So both of you said illa tirmanam
No,
ಮಾಡಿ.
my lords, my submission that day also was,
It has to
it
go.
related to the judgment that I had cited and not to the judgment that my lords had passed.
Correct. He is also showing that there is error. You are also showing there is error.
So that's
Because
all.
the court was not, there was no ambiguity in the court's mind that a direction was given by this honorable court to appoint a court commission. In the preceding paragraphs, it was made very clear that the direction
No,
was only
ಆಮೇಲೆ
to file a fresh
being
application.
spoken to Haki, I have clarified something.
Lordship said in accordance,
Yes.
in accordance with law on merits.
So the court presumes that I have directed and it directs.
No, that is not the case.
No, Madis, that's what.
ಅದು ಮುಂಚೆ
So ಅದನ್ನೇ
the
ಹೇಳಿದ್ನಲ್ಲ.
judgment that I am citing was referred there.
ಆಯ್ತು, will hear it. Yes.
If my learned friend is consented for, I have no objection. If
That may not
wants
be
to argue,
required, my
then
lords,
not-
because
I've been asking for that. We'll send it back or consent here. We'll close it here.
the primary reason being, my lords, initially a consent was given by them.
See, if it
Ultimately,
is.
because it will benefit not both,
No,
ultimately
first
have
you
some
were-
valuation.
He was the petitioner earlier.
Correct, madam.
Please.
Respondent gave a consent.
Consent.
Respondent gave consent for appointment of the court commissioner in a particular manner. Anta
Correct. I have
did.
seen.
The court says a commissioner is appointed for,
Yes.
High Court has already appointed for
directed
whatever
as-
it is. That was the problem. We'll take it, yes. List the matter after 2 weeks. Heard the learned senior counsel probably now appearing for the petitioner. List the matter after. On 22nd, interim order subsisting, will continue to the next date.
Next matter also. That is
Same, ಎರಡು same.
84.
Madam, may be permitted to appear, my lord, on behalf of the respondent number one.
Notice not
ಏನ್ ರುದ್ರಪ್ಪ ಇದು?
seeking for dispensation of issuance of notice to the respondent number 2 to 6.
Memo ಕೊಡಿ.
Please, my lord. Lord, R1 is already appeared, my lord. Not the IA filed by the petitioner not before the trial court under section 151 of CPC not. During the pendency of the FTP proceedings not, the release deed has been executed in favor of the petitioner not. My lord, annexure
Pendency of what proceeding?
FTP
FTP proceedings.
ಏನ್ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ?
release deed.
ಇಲ್ಲ. Annexure B may be seen, my lord.
Annexure B may condition not.
ರಿಲೀಸ್ ಡೀಡ್ ಆಗಿದೆಯಾ?
Annexure B.
ಇಲ್ಲ. Annexure B ನೋಡಿ, page number 15.
ಹಕ್ಕು ಖುಲಾಸೆ ಕರೆಕ್ಟ್.
17.
ಅಲ್ಲ, ಬರೆದು ಕೊಟ್ಟವರು ಯಾರು ನೋಡಿ ಸ್ವಾಮಿ?
My lord, annexure D.
ಒಂದೇ ನಿಮಿಷ.
ಈಗ ಏನಕ್ಕೆ why come before? ಏನಕ್ಕೆ
But
ಬಂದಿದೆ?
we have filed application not under section 151 CPC seeking to dispose of the FTP proceedings in view of the release deed, my lord. My lord, annexure C may condition, my lord. Annexure C
That is rejected.
rejected, my lord. And
Yes.
that petition before this one. Annexure C mutation, my lord. Petitioner name is
Will hear
entered in.
it. Yes. List the matter on
17th
24th.
trial court ಅಲ್ಲಿ 17th ಇದೆ.
ಪರವಾಗಿಲ್ಲ ಏನಾಗಲ್ಲ. ಎಸ್.
ಅಲ್ಲ ಫೈನಲ್ ಆರ್ಡರ್ ಆಗಬಿಡುತ್ತೆ ಅವತ್ತು. Infectious
ಆಗ್ಲಿ ಅಂತಾನೆ. ಎಸ್.
infectious ಆಗ್ಬಿಡುತ್ತೆ.
ಅದಾಗ್ಲಿ ಅಂತಾನೆ ಹಾಕಿದ್ದೆ ಅಡ್ಜನ್.
Monday kindly question Monday, my lord.
Yes. Next.
85.
Petitioner, madam. Complied, my lord. Serve the copy to the
Current
council.
council submits needful has been done. Office to verify.
So file Wakalat also is filed, my lord. They also filed.
Yes, next. 86.
86.
86, I may be permitted to appear through VC, my lord. As per the
Yes,
order
sir.
of the court, I have served the other side advocate,
Learned
madam,
counsel
my
submits
lord.
Learned counsel sworn, Neva.
You may be extended the last.
That is extended. Sir. Yes. The learned counsel submit needful has been done. Office to verify. I owe either 2 weeks. Yes.
Interim order may kindly be extended, my lord.
Yes, sir. Let's after 2 weeks. I owe. Next.
I appear for the petitioner.
My lord, interim order may kindly be extended, my lord, in 86.
The problem we see ಇದೆನೆ.
My apologies.
Yes.
I appear for the
87.
I appear for the petitioner. Yeah, serve the copy to the KDB.
KVT ಇದೆಯಾ?
ಇಲ್ಲ, ಇವ್ರಿಗೆ KDB ಗೆ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ
KDB ಮ್ಯಾಟ್ರ. ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನು? ಜನರಲ್ ಅವಾರ್ಡ್.
ಜನರಲ್
ಜನರಲ್ ಅವಾರ್ಡ್ ಅಲ್ಲ. ಜನರಲ್ ಅವಾರ್ಡ್.
ಪ್ರಿಲಿಮಿನರಿ
List on 16th.
Notice, KDB notice.
Council Sri PV Chandrasekhar is directed to accept notice for the respondent list on 16th in preliminary hearing.
88.
We try to serve the notice on the residents.
Trying to?
We tried to serve
Tried
the
to?
tried, my lord, already tried. They are refused to take notice, my lord.
ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು. Yes. Learned counsel submits needful has been, the learned counsel submits that the counsels have refused acceptance of the copies in terms of the direction of this court list. Therefore, notice be issued to the respondents. Emergent notice to the respondents list after 4 weeks. IO next. Please.
89. Petitioner, my lord, I'm seeking a mandamus for disposal of an application, my lord. In a summary suit filed by the petitioner.
What application?
Seeking leave to defend is pending since past 4 years. It's a summary
The
suit.
petitioner is before this court seeking the following prayer. The petitioner is the plaintiff institutes a suit in OS 3148 of 2020 in which an application, seeking leave is it? In which an application seeking leave to pursue, leave for what, Madam Adrali?
Leave to
defend is pending consideration for the last 4 years. In that light, the petitioner is before this court seeking a direction to the concerned court to consider the application so filed seeking leave and pass necessary orders thereon in accordance with law. In the light of the prayer being innocuous, I deem it appropriate to dispose the petition directing the concerned court to pass an order on the application so filed by the petitioner within an outer limit of 4 weeks from the date of receipt of the copy of the order, if not earlier. Yes.
90.
Yes, Madhu. You are this side.
Appellate tribunal is not functioning.
Huh?
State government.
10%.
10%.
10%.
A and B to be state. A and B to be
Annexures A?
state. A and B.
A and B, 10%.
Obliged.
Yes.
Preliminary hearing 91.
Petitioner notes.
Hmm.
Suit for partition. Lord, the petitioner is the defendant in the trial court. I have denied that the plaintiff is my sister. She has led in her evidence. Issues have been framed. I also lead my evidence, my lord. An application is filed for appointment. DNA.
Rejected?
It's allowed.
Allowed?
Yes, my lord.
Why?
So the court says that there is no other evidence to prove that she is my sister, and therefore DNA analysis is the only way.
The petitioner is before this court calling in question an order of the concerned court which allows the DNA application for conduct of a DNA test on whom?
Petitioner.
On the petitioner, owing to an application filed by the respondent. In that light, there shall be an interim order of stay of further proceedings before the concerned court, emergent notice to the respondent. Next.
92.
This matter may raised for weeks time, my lord. I have taken position after breaking open the lock.
ಅದೆಲ್ಲ ಆಯ್ತಲ್ಲ, ಇನ್ವೆಂಟರಿ ಡ್ರಾ ಮಾಡಿ ಆಯ್ತಲ್ಲ.
ಆಯ್ತು, ಈಗ they have to execute a cancellation of lease. That's why I'm talking to my learned friend.
In terms of the orders passed by this court, and ಎರಡು date ಇದೆ ನಾನೇ ಹೇಳ್ತೀನಿ. In terms of the order passed by this court on 13/8/2025, it transpires that all the movables are taken.
No, there was nothing.
The lock has been broken and the door has been opened and an inventory is drawn. The learned counsel for the respondent submits what remains is execution of a cancellation deed. And,
There is some arrears.
The learned counsel seeks 2 weeks time to do the needful list after 2 weeks. Next.
Interim order may kind.
Interim order subsisting. ಏನಿದೆ interim order?
ಇಲ್ಲ, because I have to deposit the
Subsisting will
money.
continue till the next date of hearing. Yes.
Appeal for the petitioner's matter. First, this is a matter where petitioner is seeking for co-pastoral rights as per section 6 of Indian Marriage Act, my lords.
Relinquish ಮಾಡಿದ್ದೀರಾ ಮುಂಚೆ?
ಇಲ್ಲ. There is no relinquishment as such, my lords. Whereas what has happened is.
Suit is of the year 1998.
Yes.
Yes, sir.
I am also selling with them, my lord. FTP was withdrawn by the other defendants, respondents before this court. And the Liberty is seeking for the file a fresh FDP petition.
My lords, the petitioner is only with the limited prayer that, my lords, FDP court should restore the, one FDP is to be restored and FDP court should.
Who are the other contesting respondents?
Only one contesting respondent who appeared, my lords. Remaining 2 are the other.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾರು?
My lords.
ಎಲ್ಲರೂ ಸರ್ವ್ ಆಗಿದಾರಲ್ಲ.
ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ.
We'll
It's
see.
served unrepresented.
List on Monday, we'll see.
Please.
All right. Madam. Yes. No, just one moment.
94.
Kumar is also here.
Where is he? No, is there another matter of this kind?
I'm sorry, I was on my legs. At that point. Not I examined that. In that petition, not the prayer was for defreezing, but the court has gone into issues of how to resolve that larger conflict which comes with controversies associated with freezing of accounts. In that matter, Prasanna
Yes, Prasanna Kumar sir.
Prasanna sir and Shanti Bhushan sir have been appointed as the amicus.
There's nothing to do with this.
Though my lord, the honorable court directed me to assist how to defreeze the accounts. But I was given a detailed report. But in consultation, I consulted the officer of the rank of IG, then our SP, CBI, not so many people who are experts in the field. I've given a report which indicates not that a defreezing cannot be handled not in isolation of the whole process. But I have also
because I have also passed some orders today.
But I will place on record whatever I have prepared.
No, I have passed an order. This is with regard to freezing and defreezing, that helpline problem, everything. I have tackled with everything and then passed an order today.
But what I have done?
There should not be a conflict. You should bring it to
conflict
the.
till I know. What I have done in my report, I have not collated all the government
Okay, you
orders.
see this order, what I have passed.
Please, please.
Jagdish sir knows it.
It is.
Upload agide. If
Center is also represented through Shanti sir.
Has directed the center to form the guidelines.
no, adike now I have ill formation agilla. Adike I have said for what center? What center?
Union, my lord.
Union. I'm on a different thing. I have directed the constitution of a cyber command center to bring in all cyber crimes under one umbrella.
I have in fact given a suggestion that whatever is a center, how not it should function. What are the shortcomings?
I have written all that. You see, I have uploaded it.
Please.
ಏನ್ ಮಾಡ್ಬೇಕು ಬಿಕಾಸ್ ಕಾಲ್ ಬಂದ ತಕ್ಷಣ ಫ್ರೀಸ್ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ಡಿಫ್ರೀಸ್ ಮಾಡ್ತಾರೆ
ಆಮೇಲೆ ಏನ್ ಶಾರ್ಟ್ ಕಮಿಂಗ್ಸ್ ಇದೆ ಅದು ಕೂಡ ನಾನು
ಎಲ್ಲ ಅದರಲ್ಲಿ ನಾನು ಹೇಳಿದ್ದೀನಿ ಯು ಜಸ್ಟ್ see that and Jagdish sir knows it.
The report which he submitted there may be submitted for the benefit of this court as well.
The place that report we will see.
Since the lordships are anyway exercising continuing.
24th I'll take it. That order is uploaded. You just
yes,
already uploaded. ಅದು ನೀವು ನೋಡಿ. ಅದು union to form guidelines with regard to freezing and defreezing. That's a different thing. Illi it's on a different footing. This was concerning cyber espionage. So serious ಆಗಿ ತಗೊಂಡು ಅದನ್ನ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಅಷ್ಟೇ. War drones were yes, that's what. Yes.
94.
Further hearing ಇದೆಯಾ ಮೇಡಮ್ ಯಾವ್ದಾರು?
4 o'clock on further hearing.
4 o'clock. ನಿಮ್ದು ಮುಗಿಸ್ಬೇಕಲ್ಲ. I'll take it. 2:30 moved matter ಅಂತ ತಗೊಂಡ್ಬಿಟ್ಟು I'll take it. ಏನ್ preliminary ಇಷ್ಟೊಂದು ತಗೊಂಡ್ಬಿಡಿ. ಇದರಲ್ಲಿ CH interim order extend ಮಾಡ್ಬಿಡೋಣ, ಕರೆದು ಬಿಡ್ತೀರಾ preliminary hearing? Just one moment. 94, yes.
My lord, against termination, AIT was preferred before the district judge. Later, the court also a convenience application was filed. Court allowed with 2,000 rupees cost. And the right time, the party cannot pay the amount.
2,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್?
ಹೌದು, ಕಾಸ್ಟ್ ಕೊಡಕ್ಕಾಗಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅದು ಕೊಡ್ಲಿಲ್ವಾ?
ಅದು ಕೊಡಕ್ಕಾಗಿ ಅವಾಗ ಜೈಲಲ್ಲಿ ಇದ್ರು ಅವರು, ಹೆಂಡತಿ ಕೇಸ್ ಹಾಕಿದ್ರಿಂದ. ಆಮೇಲೆ ಆಮೇಲೆ ರೆಸ್ಟೋರೇಷನ್ಗೋಸ್ಕರ 151 ಅಲ್ಲಿ ಅರ್ಜಿ ಹಾಕಿದ್ರು.
ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ?
ಅದನ್ನು ರಿಜೆಕ್ಟ್, ಐ ಹ್ಯಾವ್ ನೋ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಅಂತ ಹೇಳಿ.
ಅವ್ರಿಗಿಲ್ಲ ಬಿಡಿ, ರೀಕಾಲ್ ಮಾಡಕ್ಕಿಲ್ಲ.
ಹೌದು
ಹೌದು. The emergent notice to the respondent, returnable ಬೇಡ, emergent notice to the respondent, the order impugned shall remain state till the next date. Yes.
95.
Date.
The settlement talks are going on, my lord.
Silent counsel for the petitioner submits. Talks of settlement are afoot as was observed here and above. Less the matter after 4 weeks. Settlement, if any, be reported by the parties by them. Next.
For the petitioner in this case, my lord, this is a section 24 challenge to a transfer petition which was rejected by the trial court. A suit for partition and inter se injunctive reliefs are sought for between the family members. They are common plaintiffs and defendants.
It's not clubbed. It should be clubbed.
No, it can't be clubbed.
Why?
For the reason is this. One is suit for
ಹಳೆ
partition.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಏನೋ ಆಗುತ್ತೆ, ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನೋ ಆಗುತ್ತೆ.
ನಾವಿದೀವಿ, ಅದು
ಸೇಮ್ ಪಾರ್ಟೀಸ್.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಸೇಮ್ ಪಾರ್ಟೀಸ್. ಇನ್ ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಪಾರ್ಟೀಸ್ ಅವ್ರನ್ನೆಲ್ಲ ಪಾರ್ಟಿನೂ ಮಾಡಿಲ್ಲ.
ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಎರಡರಲ್ಲೂ ಒಂದೇನಾ?
ಇಲ್ಲ, ಅದರೊಳಗೆ ರಿಲೀಫ್ ಬೇರೆ, ಅದರೊಳಗೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ಎರಡು ಸೂಟ್ಗಳಿದಾವೆ. ಇನ್ನೊಂದು ಬೇರೆ.
ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ಅಲ್ಲ, ಇನ್ನೊಂದು
ಲೆರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟು ಫೈಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್
ಪಿಟಿಷನ್ ಹಾಕಿ
ಅಬ್ಜೆಕ್ಷನ್.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಎಸ್, ಅದೆಲ್ಲ ಹಾಕಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
97.
Date may be fixed.
Yes, next.
An order of police protection has been granted. The only
Granted
reason-
to whom, sir?
An order of police protection not to aid the implementation of the injunction order. Even before the culmination of the appeal period, there is an appeal pending in the most unreasoned fashion, not the most unreasoned fashion. 31 only for one moment. Only 31.
Police injunction ಇದ್ಮೇಲೆ ಕೊಡಬಾರದು ಅಂತಿದ್ಯಾ?
It is not that it cannot be,
Yes.
but there are subjective satisfaction which the court
Correct.
will have to. Only para 9 minutes. Court says minutes. When the plaintiff is entitled for temporary injunction order and injunction is already granted in favor of the plaintiff, there is no bar for granting police protection.
Correct. No bar.
Absolutely. But is there a threat? Have I violated the injunction order? What's the nature of dispute? And there is an appeal pending. And if the injunction order is allowed
You
to
are not violated, Allah.
If it is
So you have
allowed to
not
be
violated,
implemented,
right?
there's a boundary dispute.
You are not violated.
No,
Then why worry?
Photographs for only one moment. I've just disclosed for one moment. For only one moment. 128, 120.
You seek that order before the first appellate court.
That order is in challenge before the first appellate court. The other side, they've been dragging on the matter. Every now and then, the police come to the property. Crops have been demolished. Crops have been destroyed. This petition has been pending, and they have not been participating.
Last time, no representation on behalf of the petitioners.
Last time.
ನೀವಲ್ವಾ petitioners?
ಸರಿ ಆಗಿತ್ತು. ಅದರ ನಂತರ ಸ್ವಾಮಿಗೆ
ಅಲ್ಲ, ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ. ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರಲ್ಲ.
Short time, the other side had short time. My only plea is, in this fashion, police order, police protection cannot be granted.
Barely, let the respondents come.
Can it be tomorrow? Because
it can't be tomorrow. Why?
They are somewhere in the closest proximity. Because this is pending from January 25. Every now and then, we are facing this threat from the police. Every now and then.
Rolling stones, sir. Yes.
There is some urgency. Otherwise, I would not have pressed this matter into service.
Into service?
I would not have pressed this matter so much.
Into service ಯಾಕೆ?
May only request.
Monday.
May only request.
Monday, sir.
Very well. Yes. Can it be in the preliminary hearing at the top?
It will be in the preliminary hearing.
98.
Order 1 Rule 10 application, my lord.
No representation by of the petitioner.
In the last date, my lord,
Display board ಸರಿ ಇರ್ಲಿಲ್ವಾ?
It was not updated, my lord.
Display board ಸರಿ ಇಲ್ಲ, VC ಸರಿ ಇಲ್ಲ.
Sorry, my lord.
Yes, sir.
My lord, suit for specific performance, my lord.
What is under challenge?
I have filed suit for specific performance to execute the sale deed, my lord. My lord, kindly see the
slow motion ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ.
My lord, kindly see the plaint, my lord.
Why are you before the court, sir?
My lord, I have filed application to implead the Koteshwara Bank, my lord.
Koteshwara Bank. Why,
my
sir?
lord, please, because my lord, kindly see the prayer of my suit, my lord, in
Why Koteshwara Bank?
page number 41, my lord.
Why bank?
Because my vendor has obtained loan and in the sale agreement also it is a condition that he has to clear the loan and he will sell the property.
It is between you and your vendor. Why do you want to drag the bank?
Yes, my lord.
Specific performance and specific performance, no stranger. Anything else?
My lord,
Yes.
kindly see the prayer,
Emergent
my lord.
notice to the respondent.
I have clearly, I am ready to pay the loan to the bank, my lord.
No, go and pay, sir. Yes.
It is through it
No
should be
stranger,
happened
no
through court,
stranger
my
in a specific performance suit. Yes, next.
99 adjourned and 100.
List after 2 weeks. Interim order
For the
subsisting.
respondents one.
Similar matter, I have suffered an order.
Suffer. Thank you, Kodis. That's good.
Two matters I had filed. One came before my lords. Another one.
Learned counsel for the petitioner would fairly submit that two orders are passed by this court and the coordinate bench against a coordinate bench. The order passed by the coordinate bench reads as follows. In that light, petition stands disposed. 2:30 moment. 2:30 ಕರೆದ್ಬಿಡಿ.
30 more matters. Orders, seal number 1, Srimati Rakshita DJ.
This is a pending matter. The pending matter, my lords. is-
Who ಮಾಡಿದ್ ಯಾಕೆ?
My lords, there is a threat of demolition of building, my lords. Regarding the urgency that is projected, my lords, I spoke to the concerned AWE. I was orally informed, my lords, they have not even gone near the suit schedule property. It is an oral information that I received, my lords. I shall have to verify it.
Anyway, if it's demolition, don't do it. List the subject petition is moved on the score that the petitioners are apprehensive of their property being demolished by the BDA. The learned counsel for the respondent BDA submits that no such step is even taken. Be that as it may, till the next date of hearing, no demolition of the property should take place. List on 23rd.
Much obliged.
Yes, next.
Seal number 2, Irini Sebastian.
My lord, the decree holder has filed an application seeking police protection to break open the lock to his house. The application was
You are
allowed.
judgment debtor?
I'm the judgment debtor. But the order passed by the trial court also permits demolition of the wall adjacent to the property belonging to the decree holder. That property is mine, my lord. The wall that is being
You
sought to be
suffered a decree.
demolished.
Where is it yours now?
My lords, the wall that is sought to be demolished
The portion of the wall or what wall is not the suit schedule property?
is not part of the suit schedule property. In fact, that is part of my property. We are both neighbor.
So we will only install the wall not to be demolished.
Yes, yes, no, that is
Very
sufficient.
ugly.
The remaining portion of the order may be permitted. Only the wall
The
needs.
judgment debtor is before this court on an apprehension that the concerned court has granted police protection, and on the strength of the police protection, the wall belonging to the petitioner would be demolished. The learned counsel would further add that the wall is not the suit schedule not a part of the suit schedule property. On the said submission, the respondents or the police are restrained from demolishing the wall of the wall belonging to the petitioner. But except this, the order of the concerned court shall accept this. The order of the concerned court, is stayed to the aforesaid extent.
My lords, I've been told the demolition is happening today as we speak.
Yes.
If
What
an
else?
oral direction, if an oral order
ಫೋನ್
can.
ಮಾಡಿ ಹೇಳ್ಬೇಕಾ? ಕೊಡ್ತೀವಿ, ಅವ್ರ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡ್ತೀವಿ ಬಿಡಿ. Yes. Beyond that, what can be done? Yes. ಇಲ್ಲೇ ಮಾಡ್ಬಿಡಿ ಅದು.
Nataraj
ಇದು ಕೊಡಲ್ಲ. ನೋ ಎಂಟ್ರಿ ಮಾಡಿ.
ಅಲ್ಲ ಯಾಕೆ ಅಂತಂದ್ರೆ
ಬೇಡವಾ?
ಏನಾಗಿದೆ ಮಿಲಾಡ್, we have filed a suit seeking declaration. CDP ನಲ್ಲಿ it is a road. We have filed a suit seeking declaration it is a road. And then in the meantime, before the same court, they file a suit and obtain ex parte of an injunction.
He and they ಯಾರದು?
ಅಂದ್ರೆ the defendant.
Defendants. Heard the learned senior counsel Vivek Reddy appearing for the petitioner. ಇದು 3 ದಿವಸ ಮೂವ್ ಮಾಡ್ತಿರೋದು ಇದೇನಾ?
ಇದೆ.
ನಿಮ್ಗೆ ಕಷ್ಟ ಆಗಿದೆ ಲಿಸ್ಟ್ ಆಗೋದು.
ಅದಿದ್ದು ನೀವು ಮಂಡೇ ತಗೊಂಡಾಗ ಇನ್ನೊಂದ್ ದಿನ ತಗೊಂಡ್ಬಿಟ್ರೆ ಎಲ್ಲ ಕ್ಲಿಯರ್
ಅಷ್ಟೇ. ನಾನ್ ಕ್ಲಿಯರ್ ಆಗ್ಬಿಡ್ತೀನಿ. Yes. Heard the learned senior counsel Vivek Reddy appearing for the petitioner. The petitioner counsel on record shall serve the respondent plaintiff, a counsel appearing for the respondent plaintiff before the concerned court and file an acknowledgement of such service by the 15th. List on 22nd. Further proceedings before the concerned court shall remain state till the next.
The court has granted injunction to permitting him to
Stay ಮಾಡಿದ್ನಲ್ಲ. Stay ಬೇಡವಾ?
ಅಂದ್ರೆ ಸ್ಟೇಟಸ್ let them maintain status quo.
ನೀವು ಕಟ್ತಾ ಇದ್ದೀರಾ ಏನಾದ್ರು?
ಅವರು ರೋಡ್ ಮೇಲೆ, ಪಬ್ಲಿಕ್ ರೋಡ್ ಮೇಲೆ.
Sorry. So the status quo where the property be maintained till the next date of hearing. Stable.
Please.
Number 4, Syed Nasaruddin.
Syed Nasiruddin.
Matter apologies. My lord,
Yes.
matter pertaining to disbursement of amount, my lord, acquisition amount by
ಯಾಕೆ ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ?
My lord, KDB is dispersing amount, my lord.
Hmm.
So, my lord, in this case, my lord.
Who
the
are you?
property- I am a purchaser of the property.
When?
2016.
Pre or post?
Pre.
Pre-acquisition.
Yes, my lord. I am a
Where?
purchaser.
Date of acquisition?
2022, my lord.
24.
22.
And the notification ಯಾವತ್ತು sir?
My lord, that I don't have.
ಅಲ್ಲ, even then compensation you are entitled, yes.
My lord, now
Agreement or sale?
Agreement for sale, my lord. Registered agreement for sale, my lord. The
Possession or no possession?
Possession, possession, no, my lord, without possession. My lord, now what has happened?
How
is
much
there is a-
consideration paid?
My lord, 1 crore 30 lakhs.
So, ಎಷ್ಟು consideration, total consideration?
1 crore 44 lakhs.
The learned counsel for the petitioner submits that the petitioner has entered into an agreement of sale with the, in respect of the suit in the subject property, which has now become the subject matter of acquisition and has paid 90% of the sale consideration along with the agreement of sale. Notwithstanding the same, the compensation is now wanting to be released in favor of the landowner. Therefore, till the next date of hearing, compensation, if not released, shall not be released. One, two, yeah, BMI, KDB, ಎರಡು.
Yes, ma'am.
1 and 2, HL Pradeep Kumar. 3, 4 emergent, 3, 4 hands, 3, 4, 5 service by hand summons, list on 23rd. Yes, next. Office objections to be complied. 10 objection ಇದೆ. ಎಷ್ಟು ಅಮೌಂಟ್ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀವಿ? Yes. Office objections to be complied with in the by the next date, failing which the interim order would stand automatically vacated. Next. Shankar.
Serial number 5 to 9, my lord, similar matter.
So ಏನೆಲ್ಲ ಇಷ್ಟೊಂದು?
Similar matter, my lord, 1940 and preliminary
1940
notification.
ಕೊಡಿ.
Lordship has passed.
ಗವರ್ಮೆಂಟ್ ಇದು ಯಾವ್ದು 1942 ಮೂವಿ ಇತ್ತಲ್ಲ, ಆತ ಇದಾಯ್ತು. 1940 ಶೆಲ್ಡ್ ಇಟ್ಕೊಂಡು ಎಲ್ಲರಿಗೂ ತೊಂದ್ರೆ, ಇದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಟ್ಕೊಂಡು ಎಲ್ಲ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ರಿ ಈಗ.
We'll get instruction.
ಎಲ್ಲ ಪ್ರೀ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಇಟ್ಕೊಂಡು ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಕೊಡ್ತಾರೆ ಇವ್ರಿಗೆ? ಸೇಮ್ ಆರ್ಡರ್
Please.
ಅಲ್ಲ, ಆಲ್ 5 to 8.
9, lords.
9.
Please, oblige.
Number 10.
Rajkumar, seek instructions.
Ashina Jiri.
ಆಮೇಲೆ ಪೆಟಿಷನರ್ ಆದ್ಮೇಲೆ ಏನು ಹೇಳಿ?
No, my lord.
ನಿಮ್ದಲ್ವಾ?
I am for the
Sir
petition.
Kashinath.
I am sorry.
ಹಾ.
I am for it. Here, my lord, the defendant petitioner is the defendant, my lord. In a suit, my lord, he filed an application, my lord, for seeking reference of an expert opinion to FSL, my lord, in respect of a signature in the agreement to sell. The suit is, my lord, for ejectment. Here, my lord, they have executed an agreement to sell. Later to 6 years, my lord, they have filed a suit for eviction. Then, my lord, I am in put possession, my lord, pursuant to agreement to sell. It's my defense. It's clear, my lord. It's a
ಯಾಕೆ ಸಿಗ್ನೇಚರ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ?
yes, my lord. That application is allowed. And, my lord, the FSL has requested, my lord, the court to provide a signature pertains to particular year. Then he refused to provide the signature. Then, my lord, I find out their signature is available in other proceedings pending before the revenue court. I filed an application, my lord.
Petitioner to serve on the counsel representing the respondents before the concerned court. List on 22nd. Further proceedings before the concerned court till the next date shall
Posted for
remain state.
judgment. It's posted for judgment.
ಈಗ stay ಮಾಡಿದ್ದಾರೆ.
Obliged.
Next.
Maybe uploaded, load otherwise.
ಯಾಕೆ ನಾಳೆ ಇದೆಯಾ ಜಡ್ಮೆಂಟ್?
12th.
ತುಂಬಾ ಟೈಮ್ ಇದೆ. ಎಸ್.
Hearing number 11, Shraddha Shetty.
ಏನಾಗಿದೆ ಮೇಡಮ್ ಸ್ಕೂಲ್?
Dismissal of my application filed under section 47 in the execution petition of a recovery suit is under
ಏನ್
challenge.
ಫ್ರಾಡ್?
Fraud ಅಂತ ನಾವು ಇದ್ ಮಾಡಿದ್ದೇವೆ. It is a ಅಲ್ಲ ಸ್ಕೂಲ್ ಮಿ ಲಾರ್ಡ್ ಅಂಡ್ ಮೋರ್ ಓವರ್ ಇದು ಅಟ್ಯಾಚ್ಮೆಂಟ್ ವಾರೆಂಟ್ ಇವರು ಟಾಟಾ ಕಂಪನಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ದೇ ಅಪ್ರೋಚ್ಡ್ ಅಸ್ ಸೇಯಿಂಗ್ ಲರ್ನಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಅಂತ ಇಂಟರಾಕ್ಟಿವ್ ಲರ್ನಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಅಂತ ಹೇಳಿ ದೇ ಇನ್ಸ್ಟಾಲ್
ಟಾಟಾ ಕ್ಲಾಸ್. ಹೌ ದೇ ಆರ್ ದಿ ಪ್ಲೇಂಟಿಫ್ಸ್ ಇಸ್ ಇಟ್?
ದೇ ಆರ್ ದ
ಡಿಗ್ರಿ ಹೋಲ್ಡರ್. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಮತ್ತೆ?
ಇಲ್ಲ ಇಟ್ ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ದ ಡಿಗ್ರಿ ಬಿಫೋರ್
Ex parte degree,
ಎಕ್ಸ್ ಪಾರ್ಟೆ ಡಿಗ್ರಿ ಮಿ ಲಾರ್ಡ್ ಅಂಡ್ ದೇ ಸೆಡ್ ಇಟ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ಒನ್ ಅಗ್ರಿಮೆಂಟ್.
Heard the learned counsel Akshata appearing for the petitioner. The petitioner shall serve on the counsel representing the respondent. The counsel for the judgment debtor petitioner would submit that an ex parte decree is obtained by the respondent who is no way connected to the petitioner's school. In that light, there shall be an
Submission.
school, and the petitioner files an application under section 47 before the executing court alleging fraud played by the respondent in securing the said decree. The concerned court has glossed over the issue, and therefore the petitioner is before this court. Before this, you've not been given opportunity to lead evidence.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು.
So and so. In that light, there shall be an interim order of stay of further proceedings in the execution till the next date of hearing. Yes, next.
And for the petitioner, my lord, petitioner is challenging the impleading application, my lord. Rejecting of impleading application.
Who are you, sir?
I am the one of the co-personer, my lord.
Partition
For
suit,
partition.
Why rejected?
My lord, on 6/1/2025, the trial court ordered to comply the furnish the genealogical tree issued by the competent authority.
ನೀವು ಕೊಡ್ಲಿಲ್ವಾ?
ಆ ಟೈಮಲ್ಲಿ ಕೊಡಕ ಐ ಆಮ್ ಎ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಮೈ ಲಾರ್ಡ್, ಐ ಆಮ್ ನೋ ಸಪೋರ್ಟ್ ಇನ್ ದ ಲೊಕ್ಯಾಲಿಟಿ. ಅದಕ್ಕೆ ಈಗ ಅವೈಲಬಲ್ ಇದೆ, ಅಷ್ಟೊತ್ತು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಎಲ್ಲಿದೆ ಈಗ?
ಹಾಕಿದೀವಿ. ಕೈಂಡ್ಲಿ ಸಿ ಅನೆಕ್ಷರ್ ಇ ಇನ್ ಪೇಜ್ ನಂಬರ್ 40 ಮೈ ಲಾರ್ಡ್.
ಅದೊಂದೇ ರೀಸನ್?
ಹೌದು. ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಇಸ್ ಅಟ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 34
ನಾಳೆ
and
ಡಿಸ್ಪೋಸ್
25.
ಮಾಡಿ ಕಳ್ಸೋಣ ವಾಪಸ್.
ಟಿಲ್ ದೆನ್ ಸ್ಟೇ ಅಲ್ಲಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. Between the plaintiff and
the petition, so and so. Petitioner shall serve on the counsel representing the respondents before the concerned court. Further proceedings before the concerned court shall remain stayed till the next date list on 22nd.
much.
Yes.
13. Sachin BA.
Forest authority has fixed the 6-year-old sandalwood tree. They fixed the value of the 6-year-old
without
standing
acquisition.
tree
Ah.
at rupees 845. Relying upon the said order, KDB passed an order saying that in respect of my land which is acquired where there is a standing sandalwood tree. Please, my lords.
Hello, why?
Now the
Speech ಕೊಟ್ಟು ರೂಢಿ ಆಗಿದೆಯಾ? Yes.
KDB has relied upon the forest authority order. My lords, that forest authority order was earlier challenged in another writ petition, and court has held that, my lords, it is not 845.
ಈಗ ಏನಾಗಿದೆ?
My lords, now the impugned order, my lords would find it at annexure A. They have fixed the rate at rupees 845 KDB, relying upon forest authority order. Forest authority order itself was challenged in another writ petition.
No, why did you move it at 230?
Because they're going to cut the trees.
Learned counsel BB Patil is directed to accept notice for KDB ಇದೆಯಾ?
KDB party ಮಾಡಿ.
1, 2 and forest department, Learned AGA. List on 22nd. There shall be an interim. ಏನ್ ಕೇಳಿದೀರಾ ನೀವು?
Interim order which I sought is that not to cut the trees.
ಅಷ್ಟೇನಾ ಅಥವಾ?
My lords, annexure A has sought for an
There shall be an interim order as spread for till the next date. Yes.
14.
ನೀವು ಏನಾರ ಕೇಳಿತೀರಾ ನಾವು ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ತೊಂದರೆ ಆಗ್ಬಿಡುತ್ತೆ.
Great.
A representative suit was filed by the petitioners in the month of September 2024.
ಇದೇ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ರೆ ಗೋಮಾಳ್ ಲ್ಯಾಂಡ್ಸ್ ಇದೆ.
Preservation of Gomad land. Till today, the application is not considered. In the meanwhile, my lord, without there being any sanction by the deputy commissioner, they want to convert this land into residential area.
Heard the learned senior counsel S. Basavaraj appearing for the petitioner. The petitioner is before this court on a piquant circumstance of preservation of Gomad land. The learned counsel submits that without taking permission of the necessary authorities, now the steps are being taken for conversion of these Gomad lands into residential. Change the nature of the lands to that of residential.
Yes, they want some sort of a vago scheme.
To
is
that
formed.
of residential, to a residential place. In that light, there shall be an interim order of stay till the next date.
I sought for status quo order.
ಯಾರ್ಯಾರು ಡೆಪ್ಟಿ ಕಮಿಷನರ್, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್,
Deputy commissioner, assistant commissioner.
ಸೀರಿಯಲ್ ನಂಬರ್ GMCPC ಅಂತ ಆಗಿದೆ.
Civil suit ಎಲ್ಲಿ ಬಂದಿದೆ?
Civil
We have
suit
filed a
ಅಲ್ಲ.
representative
Yes,
suit.
yes. Therefore, status quo que the property be maintained till the next date of hearing.
Okay.
List the matter after 4 weeks. Yes, next.
Admission cell number 15. Srimati Anuparna.
This is a case where the cause of action pleaded, my lord, in the plaint is 28/5/2002, my lord.
CRP.
Suit for declaration, yes, suit for declaration.
Where is the plaint, sir?
Page 41, my lord, is the cause of action, paragraph
41.
11, page 41, para 11.
One ನಿಮಿಷ sir.
Cause of action for the suit arose, that is the first
Suit
cause
of the year
2011.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್? ಅವಾಗ್ಲೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ತಾನೆ.
It was an ex parte in MFA, it was restored back. There was. It's totally barred by limitation.
The heard the learned senior counsel V. Lakshmi Narayan appearing for the petitioner. The petitioner is before this court calling in question an order which rejects the application filed by the petitioner Order 7 Rule 11 CPC. The plaint, the averment of cause of action in the plaint reads as follows, page 41-42. Even according to the plaint averment, the cause of action in the suit arose on 28/5/2002 and 27/2/2003. The suit is instituted in the year 2011.
16/8/2011.
On 16/8/2011, the suit is for declaration. Admittedly, a suit for declaration must be instituted within 3 years from the date of accrual of the cause of action, failing which it would be hit by Article 58 of the Limitation Act. In that light, the suit which was even according to the plaint averment barred by limitation is said to be entertained. In that light, there shall be an interim order of stay of further proceedings before the concerned court in OS 5984/2011 till the next date of hearing. Emergent notice to the respondent. Next. KVT
But
idara?
by mistake, one more CRP is filed.
No, KVT idaralla.
KVT copy ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಟ್ಟಿಲ್ಲ.
Tomorrow no, copy ಕೊಟ್ಟಿದ್ದೀವಿ. I'm sorry.
KVT ಇದ್ರೆ ಕಷ್ಟ. Tomorrow, sir. Please tomorrow.
Hearing on IA 16. Pradeep Naik.
Why is this moved? Pending matter move ಮಾಡಿದ್ರಿ?
Lords, I have grave urgency.
Grave emergency.
For the
Yes, my
petitioner
lords.
toxic counsel.
Oh, ಈಗ
I have
ಎರಡೂವರೆಗೆ ಮೂವ್ ಮಾಡಿದ್ದ?
Yes, my lord. I have blatant threat of disposition. The petitioner number 1 is injected not to trespass into my property. There is a police protection order in my favor. He has suppressed all this material.
In your favor, police protection order.
Police protection order is there. He has suppressed all the material before this court, my lords, and secured a status quo order. Since securing the status quo order, they have been interfering with my peaceful
Sir,
possession.
status quo order is 2/5/2025. Last day.
Lords.
Vacation, yes.
My lords.
Yes, sir.
There are
Yeah, have it on
six.
next week, my lord.
My lords.
The scene is ended up in another.
There are 6 rounds of litigation between the parties.
Wait. The petition, in the subject petition, coordinate bench on 2/5/2025 had passed the following order. The learned counsel for the respondent plaintiff, plaintiff another. You are the plaintiff.
I'm
Defendant.
respondent number 4, my lords.
Suit ಅಲ್ಲಿ.
Before the suit, I'm defendant number 4.
The defendant number 4 in the suit has moved this matter on an apprehension that he would be dispossessed now, notwithstanding the fact, dispossessed now on the strength of the interim order of status quo, notwithstanding the fact that he has an order of injunction in a different suit in his favor and an order of police protection. In that light, the respondent defendant shall not be dispossessed from his property during the subsistence of the subject petition on the strength of the interim order of status quo till the next date of hearing. Yes.
Date may be fixed, my lords.
List on 26.
Interim order may be.
26. Subject to the aforesaid modification, the interim order earlier granted stands extended.
Much.
ಬೇರೆ ತುಂಬಾ ಪ್ರಿಲಿಮಿನರಿ ಇದೆಯಲ್ಲ 5:15 ಮೀಟಿಂಗ್ ಇದೆ. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಎಷ್ಟೊತ್ತು ತಗೊಂತೀರಾ?
Not take more than 8 to 10 minutes. I'll conclude. There are 6 matters.
10 minutes. Then I'll take it at 5 o'clock sharp.
Yes, I shall wait.
Yes, I'll just run through the list by then.
Please.
Let's continue. 101.
Interim order ಇದೆ.
Possession
In respect of the suit schedule property, my lord, here the defendants have filed the successive petitions, my lord.
Let him file his objections. Yes.
The kindly, my lord, they have taken sufficient
2 weeks
time.
time, 2 weeks time is finally granted to file statement of objections. Next. Yes. Next.
Then 203, adjourn 104.
For petitioners, I have to take steps to R1 and 2, your lordship, they have not served the notice. He has filed the wakalat for R3. I may be permitted
Learned
to.
counsel
take-
submits that, you notice Madilo orge.
Yeah, ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು-
Emergent notice to respondents 1 and 2 returnable by the 26th. List
Right.
on 26th. Yes.
105, interim order.
I wait for the petition, my lord.
List
Respondent
after
number
2
1 and
weeks.
2.
I will.
My lord, filing a memo wherein we have taken down all the posts, my lord.
It's
All
a
the
Rose
posts have
Lantern matter, my lord. We had paid
Oh,
10
that
lakh,
matter. Yes, yes.
10 lakh rupees through DD we have paid, my lord. On the last date of hearing.
Taken down, huh?
All the
Also,
posts have
they
been
taken
taken
it down. They
Then
have taken
close
it.
this.
We can, my lords, there is a 4 lakhs pending from our end. Your lordships were supposed to decide on that issue because my.
Oh, 10 lakhs matra kodakke.
Lakhs ಕೊಟ್ಟಿದ್ದೀವಿ.
We'll decide 22nd. List on 22nd.
My lords, there is one small correction. The last date of hearing, your lordships passed an order recording the 10 lakh rupees DD that we had submitted. But somehow, my lords, in the daily orders, that order is not reflected.
ಏ ಇಲ್ಲಿ ನೋಡಿ ಇದೆ ಯಾಕೆ
ಇಲ್ಲ,
Incorrectly uploaded.
incorrectly uploaded.
ಏನಾಗಿದೆ
ಅದು ಬೇರೆ ಕೇಸ್ ಸ್ಟೇಟಸ್ ಅಪ್ಡೇಟ್.
ಕೊಡಿ.
At least online it shows that way, my lords. We haven't.
Correct.
Online case status shows in a different.
Online problem ಇರ್ಬೋದು. Offline correct ಆಗಿದೆ ಇಲ್ಲಿ. See?
I understand.
You want to see it?
ಇಲ್ಲ sir, ಹಂಗಲ್ಲ. Only in online daily.
Maybe
status.
mistake.
Yes, much obliged.
Order correct.
Yes.
106,
Interim order to be extended.
That will be. Yes.
106,
2 weeks.
107,
For respondents.
May be taken up
For the
next
respondent.
week. my
Filed
lords.
objections.
Copyrights under Copyrights Act.
Now what's the matter?
My lords, suit for injunction.
Hmm.
Commissioner had, Subi had filed an application before the commercial court for,
Objections ಹಾಕಿದ್ದೀರಾ?
last time ಹಾಕಿದ್ದಾರೆ. So it may be taken up next week, my lords. Jan Chinnappa,
List the matter next week.
date, my lords.
Next week ಅಂದ್ರೆ date ಅಂದ್ರೆ 26th.
26th.
Yes, list on 26th. Yes.
Great.
Next.
107,
2 weeks. Yes. ಇಲ್ಲದೆ ಇರೋದೆಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಮಾಡಿ.
108,
2 weeks.
109, adjourn 110.
Interim order ಇದೆಯಾ?
I filed Wakalat for respondent.
Which serial number?
108 minutes.
Yes. Okay.
110,
Interim order ಇದೆಯಾ madam?
No, my lords.
List of 2 weeks. Yes.
110, my lords, I appear for respondent number 1. Some
Hmm.
difficulty today, my lords. A short accommodation may be made.
Interim order is there?
Interim orders may be extended, my lords.
The learned counsel appearing for the respondent seeks a week's time. List after 2 weeks. Interim order subsisting would continue to the next date. Next.
My lord, one submission. My lord, I'm for the petitioner. In the
Hmm.
order sheet, it says office objections to be complied. We have complied with the office objection.
Learned counsel submits office objections have been complied with office to verify. Next.
My lord, one submission. There is a office note on this saying annexure C, some of the pages are illegible. We are not relying.
Next time, no, we'll do it next time.
111,
Yes,
adjourn
next.
112,
Parties have taken back the file, my lords. I filed a retirement memo yesterday.
List after 2 weeks. Next.
113,
For respondent number 6 and 7, my lord.
Lords, my application seeking stay of the execution proceedings has been rejected, my lords. I'm a judgment attack. It's a judgment.
List after 2 weeks. Objections, if any, interim
Filed
order
by,
subsisting will
actually filed
continue to
by-
the next date of hearing.
The date may be.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿ.
The counsel for the respondent submits office counsel for the respondent submits that is already filed his objections. List on 26th. Interim order subsisting would continue to the next date of hearing. Next.
114, adjourn 115,
For the petitioner, my lords. I have served the copy today, my lords, for the counsel who represent before the trial court, my lords. And so
Counsel for the petitioner submits that he has served the set of papers upon the counsel for the respondent before the concerned court. Yes.
A week, my lords, after.
List after 1 week. Yes, next.
Much obliged.
116,
Respondent by me. Vacating of CR.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
ಹೌದು. Last
List
occasion
list Wednesday in under the caption hearing on interlocutory applications.
Please.
Yes.
Interim order maybe.
Interim order stands extended to the next date. Yes.
Wait for.
70,
ಆಗೋಯ್ತಾ ಇದು?
Anekal.
ಇದು ಬೇರೆದಾ?
Lining.
ಓ LB correct.
I'm just placing this affidavit on record minutes. There was a, I'm just placing an affidavit on record minutes. There was a statement of objections filed by the other side. As a counter to the same minutes, I have put certain facts on oath.
Not in WP 26219.
ಯಾವ್ದು LB ಇಲ್ಲ JMCP?
LB ನಲ್ಲಿ ಒಂದು I filed not a few documents. Not what led to the complaint by the other side, not is the whatever I have placed.
ಏನ್ ಮ್ಯಾಟರ್ ಇದು?
Not the.
LB ಫಸ್ಟ್ ತಗೋಬೇಕಾ CPC ನ?
LB ತಗೊಂಡ್ಬಿಡಿ.
LB.
ತುಂಬಾ ಹೊತ್ತಾಗುತ್ತೆ ಅಂದ್ರೆ ನಾಡಿದ್ದು ತಗೊಂತೀನಿ.
Can I request?
12th or Monday?
Monday.
ಎರಡರಲ್ಲಿ ಒಂದು.
Monday is also.
Stay ಇದೆಯಾ?
There is no stay.
Why LB is connected to this?
Minutes, illegal construction was being put up.
ಇವ್ರದ್ದು?
Yes, minutes. Instead of a 2-floor minutes, 5 floors have been put up so far.
ಹೌದು ಕೇಳ್ದಂಗಿತ್ತಲ್ಲ.
Yes, minutes. Your lordships have heard us.
Lordship was supposed to direct.
And your lordships also directed the authorities to visit the spot and draw up a mahajar.
What happened?
And the violation is confirmed there. Violation is confirmed. Minutes. So allegations, counter allegations.
Oh, Anekal.
Yes,
yes.
So minutes, allegations, counter allegations. Minutes, my lawyers were threatened before.
Lawyers were threatened.
My lawyers were threatened. Minutes, he was called to the police station. Then minutes, what they do is minutes, they had coerced me to sell the property. And minutes, they had also deposited a TDS even before there is a sale transaction. And they wanted to place all that on record. So minutes, the affidavit is also there on
Since
record.
what I have said.
Minutes,
I
even lawyers were summoned to the police
Let him
station.
say, let him have the.
That is why the lawyers were summoned to the police station. There are affidavits, I think, if he still has to supply some reply, minutes, let him do so.
Supply some reply ಈಗ apply ಆಗಲ್ಲ.
ಅಲ್ಲ ನಾನು ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಮೆಮೋ ಹಾಕಿದ್ರೆ ಇಲ್ಲ ನಾವೇ ಬ್ಲಾಕ್ ಮೇಲ್ ಆಗಿದೀವಿ ಅಂತ ಹಾಕಿದ್ರೆ ಹಾಕ್ಲಿ.
ಇರ್ಲಿ, offense is the best force of defense. ಅಷ್ಟೇ. ಮಂಡೇ ಕೇಳುವ. Keep all your horses ready. List on Monday.
Yes.
In preliminary hearing. Yes. Violation confirmed, ah?
Please, Malad.
Oh, yes. Yes, sir.
Confirm it.
It's a suit for partition is stayed at the instance of third party who
ನೀವು
claims.
ಯಾರಿಗೆ petitioner respondent?
I'm for the respondent. Lords, our suit is stayed.
Argument there. Did hear.
Lords, if your lords were to see the writ petition, Lords, just one line I'll read it in the writ petition.
Suit for
Paragraph number
partition.
4. Lords, partition is in respect of 5 items of property. The petitioner now before your lordship says that he was
temple.
Adikke, para 4 nal he describes himself how he wants to represent the temple.
Oh, Anjaneya Swami temple.
Adikke, the petitioner, he is a local resident of Idlebele village and an erstwhile convener of so and so. Avar yen locus stand I. How can he come and thwart my partition suit? If I have a title, I will get.
ನೀವು partition ಏನ್ partition ಇದು?
Lords, this is a suit for partition amongst the family members where there are 5 items of property which has been re-granted by under the provisions of.
How is he interested?
Lords, now how he says is that in respect of one item of property which is item number 5, survey number 30, he has challenged the order of re-grant passed against me before the Karnataka Appellate Tribunal.
What happened?
That is still pending. So therefore he wants to come. If he succeeds, his property will go out of the purview of the partition suit. How can he come and thwart my partition suit?
Item number ಮಾತ್ರ ಅಲ್ಲ.
Item number ಮಾತ್ರ.
Item number 5 only.
ಅಷ್ಟಕ್ಕೆ restrict ಮಾಡೋಣ.
Lords, that can be, Lords, now so far as that re-grant order is concerned,
no.
It can be made subject to outcome of that appeal.
ಬಿಟ್ರೆ ಹೇಳ್ತೀನಿ. ಅದಕ್ಕೆ restrict ಮಾಡೋಣ ಅಂದ್ರೆ whatever the subject outcome of the appellate tribunal's order, the suit in partition, even if it is decreed, will be modified. In accordance with law.
Lords, this, insofar as item number 5 is concerned, any decree that may be passed in respect of item number 5
Subject to result.
may be made subject to outcome of the proceedings. And
Yes.
his application has to be rejected
Ashte,
only on that.
Disposed. Disposed.
Please. ಅದನ್ನ ನೀವು ಹಾಕಿ ಬೇರೆದು.
Only that will be the order.
Please, my lords. Great.
Challenge only to that extent.
ಮತ್ತೆ ಫುಲ್ ಯಾಕೆ ಮಾಡಿದ್ ನನ್ ತಪ್ಪು. Yes.
119.
List after 2 weeks IO. Next.
Notice was not issued.
ಯಾರಿಗೆ issue ಮಾಡಿಲ್ಲ. Emergent notice to the respondent. Next.
120.
Ramesh.
It's a counter claim, it has been rejected, my lords, not been accepted by the court.
Rejection of plaint ಜೊತೆಗೆ counter claim reject ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Reject ಮಾಡಿಲ್ಲ, it has not been
It
considered.
has not been considered, that's all. It has to be allowed. by-
ಅಂದ್ರೆ that is to be kept alive.
Yes, my lord.
Counter claim is a separate suit. You can't do that. Yes. ಈಗ ಏನಾಗಿದೆ ಇಲ್ಲಿ?
My lords, order 7 rule 11 has been allowed, my lords. My counter claim is not for order.
Friday ಬೆಳಗ್ಗೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. Next date ಏನು? ಎಲ್ಲ ಹೋಗಿದೆಯಲ್ಲ ಏನ್ ಡೇಟೇ ಇಲ್ಲ.
Date ಇಲ್ಲ. In fact, I have preferred an appeal against the rejection of plaint.
That's all right. We'll close everything here.
Yes, my lords.
12th or 15th we'll post it, Monday.
Monday.
Preliminary.
15th preliminary hearing.
Much.
Lords, one submission, 119, interim order is 7.
That will continue. Don't worry. Yes.
121. Preparing for petition, my lord. I pray for a short accommodation.
2 weeks IO. Next.
122.
Satyanand, time ಕೇಳಿದ್ರಲ್ಲ ಆಗ್ಲೇ urgent. Yes.
123. Interim order.
2 weeks IO.
I pray for the, my lordships, 123, my lordships.
Urgency ಇದೆಯಾ?
Yes, my
ಹೇಳಿ.
lordships. Suit is of the year 2005, my lordships. Execution is of the year 2011, my lordships. That has been stayed, my lordships.
Why?
Parallelly, FDP has been filed by.
Why?
What has happened, please, my lord?
ನೀವು ಕೇಳಿದ್ರಿ ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಅಲ್ಲ ಹಂಗಂತ.
ಮತ್ತೆ?
Lord, the execution proceedings, please, my lord, arising out of a compromise decree.
Compromise.
But that compromise decree, please, my lord, was declared as null and void in a separate suit, in a suit for partition.
Compromise decree where by?
Compromise decree, please, my lord, where execution proceedings is.
ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲ?
ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲ. ಇನ್ನೊಂದು separate suit ಅಲ್ಲಿ.
Separate suit ಬರಲ್ವಲ್ಲ?
ಅಲ್ಲ, in a suit for partition.
All right, tell me.
My lord, the compromise decree was declared as null and void to the extent of the plaintiff's share is concerned. Now he is only having undivided share. Now what has happened, please, my lord? Now the execution, FDP was filed. My lord, in the FDP, please, my lord, FDP petition was allowed. He prefers an appeal before the district court. My lord, the district court.
ಸೋಮವಾರ ಕೇಳುವ. List on Monday.
Interim
order will continue. Yes. Next.
124.
For petitioners to lordship, I am for the respondent. Lordships, there is an execution which has been instituted upon, and it is on the 22nd of this month. And they have also obtained the attachment.
List on 15th. Yes. Next.
Much obliged.
25.
Sixteenth, 212 matters is already.
Dependents are both the omnibus court. Petition number 1 is aged 80 years, seeking for the disposal of the 2020 partition suit.
Partition suit 22 ಕಷ್ಟ.
80 ವರ್ಷ ಆಗಿದೆ. ಯಾಕಂದ್ರೆ ಗಂಡ ಗಿಫ್ಟೆಡ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದ ಅದನ್ನ ಸೊಸೆಯಿಂದ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಪಾರ್ಟಿಷನ್ ಬೇಕು ಅಂತ ಹೇಳಿ. ಲೈಫ್ ಟೈಮ್ he only filed suit against the daughter-in-law.
Partition suit 1 ವರ್ಷ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ.
6 ತಿಂಗಳು ಸತ್ಯ ಹೋಗ್ಬಿಡ್ತಾರೆ. 80 ವರ್ಷ.
Partition suit ಅಲ್ಲಿ ಕಷ್ಟ ಸರ್.
ಅಲ್ಲ 80 ವರ್ಷ ಅವರಿಗೆ ನೋಡಿ ಸರ್.
ದಟ್ ಅದಕ್ಕೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಕೊಡೋದೇ ಇಲ್ಲ ಟೈಮ್.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಪೊಸಿಷನ್ ಅದನ್ನ ಆಯೆ ಹಾಕೊಂಡು ಎಲ್ಲ ಎಳಿತಾ ಇದ್ದಾರೆ. ಡಿಪೆಂಡೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಹೇಗಿದೆ DW1 ಗೆ ಅದನ್ನೇ ಎಳಿತಾ ಇದ್ದಾರೆ. ನಾನೆಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಒಂದು 6 months ಟೈಮ್ ಕೊಡ್ಬೋದು. 6 months ಕೊಟ್ರೆ ಮತ್ತೊಂದು 3 ತಿಂಗಳ ಆಟೋಮೆಟಿಕ್ಲಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ತಾರೆ.
ಆಟೋಮೆಟಿಕ್ಲಿ
ಅವ್ರು ಬಂದು ಕೊಡೋದು ರಿಕ್ವೆಸ್ಟ್ ಲೆಟರ್ ಕೇಳ್ತಾರೆ ಮತ್ತೊಂದು 3 ತಿಂಗಳ ಕೊಡಿ ಅಂತ.
We'll see. List on Monday 15th.
126. Interim order.
List after 2 weeks IO. Next.
But interim order may kindly be extended.
127. Interim order.
To same.
Lord, interim order. There's
Same.
an undertaking, my learned friend gave me.
Whatever is there, that will continue.
28.
128. I'm very a suit for injunction was converted into a suit for specific performance. Matt was set down for payment of court fees. However, the court has dismissed the suit for non-prosecution, which your losses will find at page number 26.
One segment.
Just, it's covered by a judgment of this honorable court, which says that the appropriate courts, in the event court fees is not paid, is rejection of plaint under either Order 7, Rule 11A, Revel B or 11C. It cannot result in either the suit being rejected for non-prosecution or for
Non-prosecution ಮಾಡಿದಾರಾ?
non-prosecution at page number 26.
ಹೇಳ್ದಿಲ್ಲ ಈಗ ಏನ್ interim order ಕೊಟ್ಟು ಏನಾಗಿದೆ?
Interim order restore ಮಾಡಿ. I have just asked for a relief, not that. Let a date be fixed. I'll pay the court fees and then the suit can be restored.
Monday ಮಾಡ್ಬೋದಾ?
Very well.
Yes. List on Monday.
One 129.
Happy for the respondent number 1. Senior counsel on this.
Your Lordship, short point for consideration is that this is a subsequent purchaser.
129 na?
Yes, please, Your Lordship. Your Lordship, the subsequent
list
purchaser.
List after 2 weeks. Interim order
Your
subsist will continue to.
Urgency, Your Lordship.
Urgency interim order iddo.
Your Lordship, there's a-
respondent is it?
Respondent number 1.
Please.
Yes, madam.
Your Lordship.
We'll fix a date. 22nd. Yes. Interim order subsisting. What's the matter?
Suit of year 2008, my lord. Plaintiff filed a suit for declaration. The plaintiff number 2, subsequent to pendency of the suit, without obtaining kata subbreached or colluded with the obtaining a sale deed in his favor, behind back of this dependent. In fact, plaintiff father sold the property in the year 1968
filed an
itself.
IA for substitution.
1968.
That has been rejected.
ಅಷ್ಟೇನಾ?
Your Lordship, very briefly, concurrent finding
Now
as
the
against them. They sought to implead themselves. The impleading application has been
No,
rejected.
Then list on 15th, we'll send it.
Please.
Close it and send it back. Yes.
Interim.
List on 15th in preliminary hearing. Yes.
Obliged. Interim order.
130.
That's interim order.
Vacating.
I appeal for respondent number 1, my lord. Seek for a short comment.
Interim order idea?
It is.
List after 2 weeks. I
My
vote
lords,
next.
my only request is this is that case where my own son is attempting to come in the FDP proceedings. She's 87 years old. She's not able to see the fruits of her decree. Lordships may kindly fix a date. That's all I'm requesting.
The list on 22nd.
Please.
Yes.
Interim order may kindly be done. Please. Grateful.
131.
My lords, Order 7 Rule 10 application has been rejected by the trial court on the holding.
What application?
Order 7 Rule 10, return of plain.
Why?
Holding that, my lords, the trial court is the commercial court is also a civil court in the meaning of section 9, and the court can draw an inference in favor of with regard to the jurisdiction.
Adverse inference.
Or it can be drawn beyond the plain, my lord. My lords, may kindly see in page number 24.
Oh, we'll hear. Yes.
Monday, my lords, first time it's coming.
List on Monday, preliminary hearing.
132.
Lords, I've been led by a senior counsel. Kindly have it Monday.
List after 2 weeks.
Lords, Monday, next week, my lords, the matter is on 20th.
Mate? Yes.
Next week,
28th.
20th.
20th. List on 15th. Yes.
Date.
Next.
33.
Writ of mandamus, my lords. Considering the representation by the EDA, my lords.
List on 16th. Yes.
There is a
PDA
threat, my
ಯಾರಿಗೆ
lords.
ಸರ್ವ್ ಆಗಿದೆ? ಸರ್ವ್ ಆಗದೆ mandamus ಕೊಡಕ್ಕಾಗತ್ತಾ?
Notice ಆಗಿಲ್ಲ.
ಆಗಿದೆ ಬರ್ಲಿ. Yes.
Covered by judgment, my lords.
ಅರೆ ಅವ್ರು ಇಲ್ದೆ ಮಾಡಕ್ಕಾಗತ್ತಾ ಸರ್?
Please, my lords.
What is
Tomorrow, my lords. I shall serve the copy, my lords.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅವ್ರು ಬರ್ಲಿ.
The council.
ಇದು ನಾ ಹೇಳುವ ಕಾಲ ಹೋಯ್ತು. No prejudice will be caused if no notice is issued to the respondent, mandamus issued.
No,
No.
my lords, the only threat is that disposing.
No.
Let there be a stay, my lords.
Yes,
At least let them not dispose us.
Nothing. Yes.
Date may be fixed, my lord, at least.
Huh?
Day after tomorrow.
Day after tomorrow, 16th. Get servant come.
Please.
Yes.
Whom?
134. Interim order.
2 weeks I vote. Next.
135.
The telecom tower matter, my lords, police protection.
Telecom tower, Tuesday. Yes.
Preliminary here. Kindly have it Monday.
Preliminary.
I will get
Tuesday,
instruction
sir.
Monday.
Yes. Next.
136.
Lords, the plaintiff's application for amendment and appointment of commissioner is directed to be taken up along with the merits of the matter. It says that it will be considered, page 13(1)(3). It refers to an earlier order of this honorable court.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ?
Let may be permitted to appear. I have entered appearance already before issuance of notice. Let's
Next
kindly
date.
turn to, let's,
Next day ಯಾವತ್ತಿದೆ? ಇಲ್ಲೇ ಇದೆಯಲ್ಲ.
Let's the earlier application for appointment commissioner has been allowed and we have-
ಆಗೋಗಿದ್ಯಲ್ಲ.
14/9. Sorry, ಎಲ್ಲ ಯಾವತ್ರಿ? 15/9 minutes.
We'll take it on Monday.
Very well.
Yes, list on 15th Monday.
That's in the meantime, let them furnish a cost set of papers.
ಕಾಪಿ ಕೊಟ್ಟಿ.
ಅವರು ನೋಟಿಸ್ ಇಲ್ಲದೆ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ, ಕೊಡ್ತೀನಿ ಕಾಪಿ.
ನೋಟಿಸ್ ಇಲ್ಲ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ನೋಟಿಸ್
Before issuance of.
ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ
ಬೇರೆ ಯಾರು ಇದಾರೆ ಅವ್ರೊಬ್ರೇನಾ?
ಅವರೊಬ್ರೆ.
Let's undertake to file power for respondent.
ಹೇಳಿ. Learned Counsel V. Jawar Babu undertakes to enter appearance for the respondent. List the matter on Monday, 15th. Petitioner to serve set of papers upon the aforesaid counsel. Yes, next.
137.
Highly grateful.
Appear for the respondent.
Freezing of the bank accounts. 5 accounts are given, of which 1 belongs to the JDR. Other 4 mallards are of separate entities. They all run mallards school under the same name. Somehow mallards have gotten a hold of the account numbers.
Like if it is a third party account, it is for the third parties to approach the court under 26, under rule 46.
ಈಗ third party accounts are frozen na.
Yes, mallards.
They are not third party account. That is what they say.
ನಿಮಿಷ. ಆ third parties ಯಾರು ಇಲ್ಲಿ?
ಅಲ್ಲಿ ಹಾಕಿದೀನಿ. mallards may come to
ಅಲ್ಲ, ಇಲ್ಲಿ petitioners ಯಾರು?
mallards petitioner is the he is the first JDR. He is the first judgment debtor.
Third parties, why are you bothered?
mallards, I am bothered because mallards they also run the school under the same
Let
name
them
as I
come.
do. mallards they will not be able to come. mallards
Why?
because mallards what has happened is mallards 5 accounts are
Orchid
attached.
school is the school belonging to one of the all.
Problem is this, mallards 5 accounts are attached.
They
All
issue
of
the
them mallards are running
advertisement.
the school under the same
All
name.
30 schools are run by the same entity.
mallards there are different trusts. The bank accounts are
That
different.
23
Mallards, now
crores
what
is
has
the
happened
decree
is
amount.
I am not able.
List on 17th. Yes. Next. 23 crores.
23 crores is the rent. Rent payable to the school.
That's not
ಯಾವ
the
ಸ್ಕೂಲ್ ಇದು?
Orchid school.
mallards the award is for
And
20 crores.
the award is made by the learned arbitrator based on the admissions made by them.
There was no admission. There was a settlement
They-
proposal.
they don't-
We said to
they
put the
don't
quiet
pay
to
1
the
rupee
matter. We
also.
offered mallards to pay 8 crores provided it's
23
taken
crore ಗೆ
into
1 rupee ಕೊಡೋದಿಲ್ಲ ಅವರು.
They don't take it. Mallards, I have challenged it. They have also challenged the very same.
ಏನ್ ಸೆಟ್ಲ್ ಆಗಲ್ಲ ಬಿಡಿ.
Settle agala. Even I tried. That's my only difficulty is this. The debit fees is with respect to those schools mallards which are nothing to do with-
ಕಾರಣಾಂತರಗಳಿಂದ ಆಗಲ್ಲ. Don't worry. Yes.
ಅಲ್ಲ, they don't want to pay. They collect 50 crores.
ಏನಾಗಲ್ಲ
In
ಬಿಡಿ.
this
We
season,
decide it on merits.
They have collected 50 crores. They don't want to pay.
ಡಿಸೈಡ್ ಮಾಡೋಣ ಸರ್.
Available.
ಅಲ್ಲ ನಾನು ಅವ್ರು ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ 50
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದನ್ನ ಹೇಳ್ದೆ ನಾನು.
I'm
ಸೆಟ್ಲ್ ಆಗಲ್ಲ ಅಂತ ಅವರೇ ತಾನೇ ಹೇಳಿದೀಗ.
ಅಲ್ಲ even we have tried, it is not going to get settled mallards. Both of us have made efforts. In all fairness mallards, even sir has taken interest. It has not happened. Both of us have tried mallards.
Seriously?
Mallards, all I'm saying is this. Mallards, those schools have nothing to do with this proceeding.
ಏನೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರಲ್ಲ ಸರ್. ಎಸ್.
ಹಂಗಲ್ಲ
Yes, list next.
Mallards,
Yeah, yes,
only
next.
request is this. Those are mallards with respect to the first account which belongs to me, let the garnishi order be
No,
there.
no,
The
no.
other accounts
ಬೇರೆಯವ್ರ ಅಕೌಂಟ್ ಇದ್ರೆ ಅವ್ರು ಬರ್ಲಿ. ಇಲ್ಲ ಅವರು in terms of
they are-
commercial courts act, let them go there.
ಅವ್ರು ನನ್ನ ಹತ್ರ ಬರ್ತಾರೆ ಸುಮ್ಮನೆ. They are coming and saying your dispute, our accounts are attached. What is mallards? That is the difficulty I'm facing.
Yes.
138.
In this case, I appear for the petition, my lord.
CH
Here, the
moved
trial
it.
court has allowed the application by overlooking the order passed by this honorable court.
What application, madam?
Appointment of commission, order 26 rule 9. By
ಅದು
overlooking the
which
order.
is that
passed-
overlooking order?
Order is at page number 83, my lord.
ಏನಾಗಿದೆ ಅಲ್ಲಿ?
Adರಲ್ಲಿ, writ petition, they themselves have undertaken that they will not adduce either oral evidence or documentary evidence of.
The learned counsel for the petitioner is before this court calling in question an order that permits application on order 26 rule 9, contrary to the observations made by the coordinate bench in order dated 15 January 2025. Therefore, the said order shall remain stayed. It's made clear for the proceedings before the concerned court are not stayed. Yes, new respondent, huh? Very good. Yes, next.
Stay may kindly be granted, madam.
ಕೊಟ್ಟಾಯ್ತಲ್ಲ madam.
Much obliged, madam.
Yes, next.
39.
Appear for the petitioner, my lord. Respondent advocate ಗೆ copy
Enter ಮಾಡಿದ್ಯಾ?
Entry ಮಾಡಿದೆ, my lord.
Yes, 2 weeks IO. Next.
140.
Same.
141.
So this is submission, my lord. This execution procedure, commercial procedure from 2021, my lord. Fourth occasion, we are brought as public auction sale. So finally, we are.
Right, we'll see. Yes, next.
Date may kindly be fixed.
Yes, next.
141.
Mahesh.
For the respondent, my lord.
Enter ಮಾಡಿದ್ಯಾ?
My impleading application was rejected, my lords, being agreed by which I am before the court.
2 weeks IO. Next.
Yes.
142.
Petitioner.
Serve the copies to the councils of the respondents, my lords.
2 weeks IO, next.
IO maybe.
143.
But I appear for the petitioner, my lords. It's a matter where
Commercial court transfer, my lords, sir, from city court to commercial court.
Well,
Whether it should be from the continuation or from the date of.
List on Monday in preliminary hearing. Yes.
till such time interim order may kindly be extended, my
Yes,
lords.
sir, yes.
The
Next.
interim order was not granted.
That is true.
Next, yes, yes, next.
144.
Great, my lords.
My lords appearing for.
Oh, ಇದು ಒಂದೇ ಪ್ರಾಪರ್ಟಿ. 32/1 ಇಲ್ಲ.
ಏನಿಲ್ಲ ಇವಾಗ ನಾವೆಲ್ಲ ಅವ್ರು ಹಾಕ್ಲಿ
relying upon this.
ಕೊಡಿ ಅದನ್ನ
ಏನದು?
ಅವ್ರಿಗೂ ಕೊಟ್ಬಿಡಿ. ಇದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 33 measures 3 acres 34 guntas. Even prior to the sale deed of 1948, which is first of the sale deed on which both of us will be relying upon, the property had already been ported. Survey number 33 was not in existence as of 1948 itself. 1948, the property having been purchased, lords, by Rahmat Jan and Abdul Rashid, who sold this property in favor of Gadi Chelurai Shetty. Lords, I'll just 2 minutes I'll just take. Gadi Chelurai Shetty is the person who is common to both the parties. Let's take it that way. Gadi Chelurai Shetty, he sells the property in favor of Abdul Rashid in 1956. This is defendants, this is the respondent's title. Gadi Chelurai Shetty sells it in 1956. Yes. Then Koikot Jesuit Mission Society has again sold this property in favor of Jesuit Mission Society has purchased this property from Gadi Chelurai Shetty. Then Koikot Jesuit Mission Society has sold this property in favor of Bhagyamma.
ಸೋಮವಾರ ಕೇಳೋಣ. ಎಲ್ಲ ಗಾಳಿಲಿ ಹೋಗ್ಬಿಡುತ್ತೆ ಈಗ.
ಆಯ್ತು. ಅಲ್ಲ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗತ್ತೆ, ಇದಕ್ಕೊಂದು 2 ನಿಮಿಷ ಟೈಮ್ ಬೇಕಾಗತ್ತೆ.
2 ನಿಮಿಷ ಟೈಮ್.
ಇದರಲ್ಲಿ ಒಂದು ಫ್ಲೋ ಚಾರ್ಟ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅವ್ರ ಟೈಟ್ ಲೈನ್ ನಮ್ ಟೈಟ್ ಲೈನ್ ಅಂತ ಅಷ್ಟೇ.
ಅವಾಗ ಗಾಳಿ ಕರೆಕ್ಟ್ ಆಗಿ ಫ್ಲೋ ಆಗುತ್ತೆ.
ಹೌದು.
ಎಸ್.
ಪ್ಲೀಸ್ my lords.
Yes, yes.
145.
Monday.
Same one.
Monday, madam. Same Monday.
146.
Respondents refused to receive the.
Huh?
146.
146.
Respondents refused to receive the code and summons.
Refused.
Refused. I filed the affidavit.
Learned interim order ಇದೆಯಾ?
Interim.
Learned council submits, respondents have refused acceptance of notice, list after 2 weeks, interim IO. Yes, next.
147.
Awaiting service in respect of R1.
I'm appearing, I'm taking notice of respond number 1, my lords. I'm the decree holder.
Senior is appearing.
Yes, yes.
For the judgment
Niಮಗೆ.
debtor.
Yes.
For the judgment debtor, my lords. Because I'll take notice for the respondent because.
There is an interim order.
No, my lords, the order only said, my lords, my respect.
Not to precipitate.
Not the trial court to defer the matter.
Defer,
On the
correct,
4th, my lords, they have appeared and submitted that the court has granted a stay of the proceedings. Successive writ petition approached up to the Supreme Court in the last round of litigation.
Well, I'll take it on Monday.
Yes, my lords, because my execution of the year 2000.
No problem, madam. You file whatever you want, we'll take it on Monday.
This may be clubbed with the other two petitions.
Second,
Other two ಯಾವ್ದು?
There are 3 IAs.
Lord,
Oh,
may I
three-
request for 22nd.
All 3 applications are challenged by 3 different petitions.
My lord, we had filed 1 writ petition. Office had raised an objection.
Common order has been passed. my
Common
lords.
order had been.
Common order, I never say, I will overrule all those of his objections. Common order, separate petitions, yes.
In fact, lords, identical applications filed for the second time.
That we'll see, that's on merits.
Obliged.
Take this petition along, FRR or WP?
No, no, WP.
Take this petition, so ಅದ್ರಲ್ಲೂ ಕೊಟ್ಬಿಡಿ notice ಇವ್ರಿಗೆ.
Yes, my lord, I will.
You take off notice and go through and come
Obliged.
on Monday, yes.
My lord, may I request for 22nd, my lord.
My lords, the anyway,
sir.
the trial court has posted the
Eagerly
matter
objection,
to 2310. So, my lords, the arrangement was only to ask the trial court to defer the matter. Matter
It is
stands
deferred
deferred
already.
to
So we'll
2310.
take it on 22nd then.
Please,
22nd, not October, 22nd September.
Lords, I'll take my chances on 15th on Monday.
No, file your objections, 22nd is anyway before the date.
Obliged, my lords.
Please.
So tag this petition along with so and so list on 22nd. Avat adjournment ಕೇಳ್ಬೇಡಿ. ನೀವಲ್ಲ,
We are ready.
senior ಅಲ್ಲ ನೀವು.
Yes, my
Lords,
lord.
may I request for the matter to come up with suit of
Preliminary
the year
hearing only.
1998.
Preliminary hearing only
Obliged.
on 2nd.
Admission 148.
Sak, admission B group ಬೇಡ. We'll post it another day. Take that for the hearing matter.
Further hearing. 177.
Indian item.
8 minutes, Eye on the clock.
Definitely, 8 to 10. No,
Eye on the clock. I have a meeting at 5:30, but I believe ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಹೋಗ್ತೀನಿ. But 5:23 I'll leave.
Please,
You have 10 minutes.
exactly. I'll write. Madam,
And you start ಮಾಡಿ. ನಾನು ಏನಾದ್ರು ಸಿನಾಪ್ಸಿಸ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ನಿಮ್ದು.
synopsis ಇದೆ. But I'll only trouble, I'll
Because
not
you will
repeat
generally
anything.
not go around everywhere.
I'll not repeat anything. Just
yes.
one important document, not about the claim of,
Hmm.
not Praveen's, madam.
ಇಷ್ಟೇ ಬೇಕಾಗಿರೋದು. Everything will be here. Yes.
Criminal petition 11846 ಅಲ್ಲಿ ಒಂದು ಮೆಮೋ ಫಾರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಪ್ರವೀಣ್ ಅವರು.
ಅದೇ ಫೋರ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ? Yes, help me a lot telling this. I was actually searching for this document which
ಅವರೇ ಹಾಕಿದಾರಾ?
ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ತೋರಿಸಿದ್ರಲ್ಲ ಅತ್ತಾನೆ.
ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ I will not repeat anything which I have already shown.
Yes.
But this not 24/4/25 ಅಲ್ಲಿ not my friend Praveen has produced not certain documents in support of his claim. ಉಳಿದಿದೆಲ್ಲ ತೋರಿಸಿನ ಒಂದೇ ಒಂದು ಪೇಜ್ 40 40 ರೈಟ್ ಹ್ಯಾಂಡ್ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ.
40.
Not may I just not request your lordship kindly have a look at the certified copy. ಅದು ಅವ್ರು ಹಾಕಿರೋದು ಫೋಟೋ ಕಾಪಿ
ಅಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅಂತಾನೆ ಹೇಳ್ತಿರೋದು.
ಇದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಇದೆ. There is criminal petition 11846 ಅಲ್ಲಿ.
Correct.
Not my learned friend has produced on 24/4/25 a compilation of documents.
Compilation of documents. Yes sir. ಅದರಲ್ಲಿ ಪೇಜ್ 40.
ಅದರಲ್ಲಿ ಪೇಜ್ 40.
ಕಾರ್ಗಿಲ್ ಹೀರೋದ ಬಗ್ಗೆ ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ.
ಇದರಲ್ಲಿ not this one, this document your lordship has.
Mutation register.
Now kindly compare this mutation register with the certified copy. Not just now I passed on. This mutation register is the first document in the series which he claims that it has been granted.
Exhibit P6.
P6. Not kindly not have a look at. ಈ ನಾನೊಂದು ಇದು ನೋಡಿ I have provided certified copy. ಅದು flag ಹಾಕಿಕೊಟ್ಟ in the first next page Milord. But this is the certified copy which not the original of which not is in the custody of the court. Your lordship will find the same thing not ಕೆಳಗಡೆ ಇರಲ್ಲ ಸೇಮ್ ಇದೆ. One at the bottom is same. Certified copy ಗೂ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಗೂ ಸೇಮ್ ಇದೆ. Not this portion and not bottom portion of this document which he has produced. Now kindly have a look at the top portion Milord. ಮೇಲ್ಗಡೆ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ರೈಟ್ ಹ್ಯಾಂಡ್ ಫುಲ್ ಕಾಲಮ್ ಕರೆಕ್ಟ್ ಇದೆ. ಇದೆಲ್ಲ ಸೇಮ್ ಇದೆ. Now kindly come to the next column. ಈ ಕಡೆ ಹಿಂದೆಗಡೆಯಿಂದ ಪಕ್ಕದ್ದು ಇದು ಸರ್ವೆ ನಂಬರ್ 60/9 48/1.
ನೀರ್ ಬೇಕಾ?
ಇಲ್ಲ ಹೇಳಿದೀನಿ ರಿಕ್ವೆಸ್ಟ್
ಮೇಡಮ್ ನೀರ್ ಬಾಟಲ್
60/9 48/1 ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಟ್ ಎಲ್ಲ ಬೇರೆ ಇದೆ. ಅದೆಲ್ಲ ವೈಟ್ ನ ರಚಿ ಇಲ್ಲಿ ಬೇರೆ ಏನೋ ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ಸರ್ವೆ ಇಲ್ಲಿ ನಾವು ಮಾಡಿ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ ವಿಚ್ ಹಸ್ ಪ್ರೊಡ್ಯೂಸ್ 105 ಸರ್ವೆ ನಂಬರ್ 105 ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಇದರ ನೇಚರ್ ಆಫ್ ದಿ ರೈಟ್ ಯು ಲಾಸ್ಟ್ ಕಮ್ ಟು ದ ಕಾಲಮ್ ನೇಚರ್ ಆಫ್ ದ ರೈಟ್. What is there in the original is ಚಿಕ್ಕಣ್ಣನವರ ಹಾಜರಿ ಪಡಿಸಿ ಶ್ರೀಮತಿ ಮೇರೆಗೆ
ಅಂದ್ರೆ ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಬರ್ದಿದೆ.
ಅಲ್ಲಲ್ಲ ಇದು ಯಾರ್ದೋ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್, ಹೆಸರೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ. ಅದನ್ನ ಮಾತ್ರ ವೈಟ್ ನ ರಚ್ಚಿ ಅವ್ರದ್ದು ಹೆಸರು ಸರ್ವೆ ನಂಬರ್ ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ದಿ ಒರಿಜಿನಲ್ ಆಫ್ ದಿಸ್ ಈಸ್ ಇನ್ ದ ಕಸ್ಟಡಿ ಆಫ್ ದಿ ಆನರ್. The whole claim of Praveen's client not is this not page number 40. This is so far as not Praveen's client is concerned. Other documents which I have already shown. Ado your lordship will also see idralli innonde document kottidare. Not he has made my job much more easier. Your lordship will find in this not compilation on ink page 25.
ಯಾವ್ದು ಇದರಲ್ಲೇ?
ಇದರಲ್ಲೇ ಹಳೆ ತೋರಿಸೋದು ಮತ್ತೆ ಮಾಡಲ್ಲ ನಾಟ್ ಟ್ರಬಲ್. ಅದು ಹಳೆದೆಲ್ಲ ತೋರಿಸಿದೀನಿ. ಇದರಲ್ಲಿ ಪೇಜ್ 25. ಅದರಲ್ಲಿ ಇದು ದರ್ಖಾಸ್ತ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ಮೊದಲು ಹಾಕುವಾಗ ಬೇರೆ ದರ್ಖಾಸ್ತ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ಹಾಕಿದ್ರು ಇರಲಿ. ದಿಸ್ ಮೆ ನಾಟ್ ಎಕ್ಸ್ಟೆಂಡ್ 6 ಎಕರೆ ಹೇಳ್ತಾರೆ. ಅಂಡ್ ಈ ಕ್ಲೇಮ್ಸ್ ನಂದು ಮಿಲಿಟರಿ ಗ್ರಾಂಟ್ ಮಿಲಿಟರಿಗೆ ಇರೋದೇ 2 ಹೆಕ್ಟೇರ್ ಮಾತ್ರ ಮ್ಯಾಕ್ಸಿಮಮ್.
ಹೌದು.
ಒಂದು. ಎರಡನೇದು
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ
Then your lordship will
6 ಎಕರೆ
find.
ಆಗಕ್ ಸಾಧ್ಯನಾ?
Then next page, my lord. Page 25 ಅಲ್ಲಿ ಏಜ್ ಆಫ್ ದ ಅಪ್ಲಿಕೆಂಟ್ 28 ವರ್ಷ ಅಂತಾರೆ. In the next page, my lord, page 25, column number 7. ಏಜ್ ಆಫ್ ದ ಅಪ್ಲಿಕೆಂಟ್ 28 ವರ್ಷ. Then my lord,
28 ವರ್ಷ.
28 ವರ್ಷ. In the next page, my lord, page 27. Date your lordship will find on the page 27.
2 ಹೆಕ್ಟೇರ್ ಅಂದ್ರೆ 5 ಎಕರೆ ಆಯ್ತಲ್ಲ?
4 ಎಕರೆ ಚಿಲ್ಲರೆ ಆಗುತ್ತೆ.
2.3 acres 1 hectare.
ಇನ್ನೊಂದು not page 27 dated 19/2/76 alone date ಇದೆ. Now kindly come to page 28, my lord. ಇದರಲ್ಲಿ page 28 ಅಲ್ಲಿ ಒಂದು ನೋಟ್ ಇದೆ. ಲಾಸ್ಟ್ 4 lines ಆಫ್ ದ ನೋಟ್. 10-12 ವರ್ಷಗಳಿಂದ ದರಖಾಸ್ತಿನಲ್ಲಿ ಈ ಗ್ರಾಮದಲ್ಲಿ ನೆಲೆಸಿರುವುದು ಖಚಿತಪಟ್ಟು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಉದ್ದೇಶದಿಂದ ಸೋನ್ಸೋ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಫ್ ದಿಸ್ ಇಸ್ ಟೇಕನ್ ಅವ್ರು ಇನ್ನು ಮೈನರ್ ಆಗಿದ್ದವಾಗ ಅದೊಂದಾಗುತ್ತೆ. ದಟ್ ಆಲ್ಸೋ ಮೇ ನಾಟ್ ವಿಲ್ ಬಿ ದೇರ್. ಅಂಡ್ ಮೇ ನಾಟ್ ಈ ವಿತ್ ಇನ್ ದಿಸ್ ಡೇಟ್ ಇದೆ ಡೇಟ್ 19/2/76 ಹೇಳ್ತಾರೆ, ಡೇಟ್ ಹೇಳ್ತಾರೆ. ಆನ್ ದಟ್ ಡೇ ವಾಸ್ ಆಕ್ಚುಲಿ ಇನ್ ಸರ್ವಿಸ್. ಅವ್ರಿಗೆ ಲೀವ್ ತಗೊಂಡಿರೋದು ಫ್ರಮ್ 24/3/76 to 22/5/76. The day on which he says
ಇಲ್ಲಿ ಸೈನ್
ಮಾಡಿದೀನಿ ನಾನು ಇಲ್ಲಿದ್ದೀನಿ ಅಲ್ಲೆಲ್ಲ ಮಾಜರಾಗಿದೆ.
How do you say he was in service and there service ಇರಬಹುದು but leave ಅಲ್ಲಿ
not on leave.
How are you saying that?
No, that not documents I have secured, not adina I did not want to because not it will expand the scope. Then my lord, lastly ಇದನ್ನ ಹೇಳಿದೀನಿ. ಇನ್ನೊಂದು not page 90 of my lord, this again compilation. But this is the proceedings before the special DC. Where my lord, my friend Pravin's client my lord is the respondent.
Yes.
Otherly your lordship will find CR8 RRT 2 S CR8. Otherly your lordship will find page 91, third paragraph my lord. Further, the Tahsildar has submitted report so and so. Further, it is stated that insofar as grant in favor of Muniswami is concerned, there is no document available in the record room. 4 lines, not from the.
Further, it is stated
that insofar as
no
grant
documents
in favor
are available
of
in the record room.
There are no documents available in the record room. But that is now fortified by the originals, not that is in the custody of this on bill. Now, this is as far as not the claim of Pravin's not client is concerned. Then, my lord, may I now request your lordship kindly take up petition in criminal petition 12857.
ಶ್ರೀವತ್ಸ ಸರ್ ಇನ್ನೂ ಇದ್ದಾರೆ. ಆಗೋಯ್ತಲ್ಲ. Then we'll have to, there's a meeting at 5:30. That's the whole problem. ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಯಾವ್ದಿದೆ ಮೇಡಮ್? ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಯಾವ್ದಿದೆ? ಫ್ರೈಡೆ ಅಲ್ಲ, ನಾಳೆ ಆಗಲ್ಲ. ನಾಳೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿರ್ತೀನಿ. We'll take it at 4:30.
But I've been not invited by National Police Academy, my lord, to.
ನೀವೆಲ್ಲ ಬುಕ್ ಬರ್ದಿದ್ದೀರಂತ?
My senior my lord has written book. I had to, my lord.
ಆಯ್ತು, ಫ್ರೈಡೆ ತಗೋಣ. ಫ್ರೈಡೆ ಕಾಂಪಿಟಿಷನ್.
ನಾಳಿದ್ದು 2 ದಿನ ಇದೆ.
ಅಲ್ಲ, ಫ್ರೈಡೆ ಸಾಯಂಕಾಲ.
ಅಲ್ಲಿ ಫ್ರೈಡೆ ಮುಗಿಯೋದು ನನಗೆ 5:30 ಆಗುತ್ತೆ ಕ್ಲಾಸ್.
ನಮ್ದು ಮುಗಿಯೋದು 5:30ನೇ ಆಗುತ್ತೆ.
ಅಲ್ಲ, instead of VC, not I want to be present.
ಅಲ್ಲ, VC also you can come.
Monday.
There is a meeting in there. I would have sat up to 7 o'clock, not a problem.
Monday, my lord. Monday, my lord.
ಆಯ್ತು, ಮಂಡೇ ಫೈನಲಿ ಮುಗಿಸ್ಕೊಂಡು.
Please.
ಶ್ರೀವತ್ಸ ಸರ್, ನಿಮ್ದೇನಾದ್ರು ಇದ್ರೆ 5 minutes. ಬಸವರಾಜ್ ಸರ್ ಆಗಿದೆ. Or is the only person who is entitled to relief. ನೀವಲ್ಲ, ನಿಮಗೂ ಇಲ್ಲ, ಅವ್ರಿಗೂ ಇಲ್ಲ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಯಾರಿಗೂ ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇಟ್ಗೆನೆ ಬಿಡಿ.
ಬಿಡಿ, ಏನ್ರಿ ನೀವು ಸುಮ್ಮನೆ 6
ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್. ಈ ಟೈಮ್ ಮೀಟಿಂಗ್ ಇದೆ ಅಲ್ಲ ಯಾವ್ದು ಬಿ ಗ್ರೂಪ್ ಪಾಸ್ ಓವರ್ ತಗೊಂತೀನಿ. ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ವಿಲ್ ಕಮ್ ಲೇಟರ್. ಪಾಸ್ ಓವರ್ ಮಂಡೇ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಮಂಡೇ ದಟ್ ಫ್ರೈಡೇ ದಟ್ ಕಾಂಪಿಟೇಷನ್ ಕಮಿಷನ್ ಮ್ಯಾಟರ್ ಇದೆ, ಆಮೇಲೆ ತಗೊಂತೀನಿ ಅದಾದ್ಮೇಲೆ. ಪಾಸ್ ಓವರ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ದಟ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ. 4 o'clock ಅಲ್ಲ, 4:30 ವಿಲ್ ಕಂಟಿನ್ಯೂಸ್.